Good morning. No commentary, at least this morning. I'm a tired towel. But as soon as court goes live, you'll see the feed. And good morning. My name's Grant Smith Ellis. It's closing arguments in the Brian Walshe trial. So, with that said, court should be in session any minute now. Thanks for tuning in. No morning commentary today. Good morning to those of you just tuning in. No commentary from me this morning. I'm a little tired. As you can see, we are waiting for closing arguments in the Walshe case, but no commentary from Towel. I'll be up in a little bit, I think, but I don't know. Got a long day. You're going to hear from me later, I think. Going to be an interesting day. But for now, I just kind of want to get my day started, and we'll watch closing arguments. Now, as you might know, it's not going to start with closing arguments right away. They have to do the charge. They have to actually get charged as the jurors. Now, I think charging occurs after closing. Might occur before closing. The point is, I think the charge itself takes a long time. So there I go. Good morning, Nancy and Abby. How are you both doing? I said I wasn't going to do morning commentary, but I'll talk to you a little bit as we wait. I have my camera paused so we can get the HD feed from the pool camera. So you're going to see closings. Walshe didn't put on defense at all, and Walshe doesn't want the state to be able to reference that Walshe said in his opening, or his lawyer, that Walshe was going to take the stand. Walshe bailed on that plan after a devastating series of witnesses preemptively from the state tore apart Walsh's argument that he had a good marriage with Anna. Their marriage was breaking down because of Walshe being on federal probation. Anna had found a new partner in Washington who had helped her get by a home. Anna wanted Brian Walshe to know she was moving on. It was a very sad situation, and Walshe was deeply in debt. He was facing issues with the federal probation, the federal sentencing. It had to do with art fraud, and he just never took the stand. So, God knows what he's going to say in closing. His lawyer is Larry Tipton. The state is in a very strong position. This deliberation won't go past lunch. If it goes past 4 o'clock today, I'll be dumbfounded. It won't. It's not even a question. And jurors don't like to go home over the weekend. Friday deliberations, when it's a clear guilty verdict, is the worst thing for a defendant. They just want to go home. The jurors, so they'll find him guilty. Now, I don't see any holdouts here. It's not a holdout juror type case. There's no cause célèbre in the French for Brian Walshe. So, yeah, I think you got 12 people ready to convict. My view on it all, I think the real how do I put this? The phantom here, what's lying beneath is Michael Proctor not being called. He was on Brian Walsh's defense witness list, but they just didn't call him. Why? I don't know. Walshe also got stabbed in jail. That was a little odd. Everything's odd about this case. But I think this was it came down to why Walshe didn't take the stand and call Proctor. Why he didn't take the stand? Because the last two witnesses from the state were so devastating as to the nature of the relationship breaking down between Anna and Brian Walshe. Why he didn't call Proctor? I don't know. Look at all those other defendants with Rosemary Scapiccio as their lawyer jumping at the bit to call Michael Proctor. Everybody wants to call Michael Proctor. Why didn't Walshe do it? I don't know. I really don't know. It hangs heavy over this case, though. Why Walshe didn't call Michael Proctor. Obviously, other defendants are going to do that. Miles King, Johnson, etc. But there's something about the whole Walshe case that's off. He's obviously guilty, but he didn't put on he could have put on a Karen Reed-style defense and attacked the investigation, and he just didn't. Why? I don't know if it was like a threat to his safety, an institutional decision among the defense bar that this wasn't the best case to bring that out. I don't know. I really don't know. But there's something to it. There I go. I said I wasn't going to comment, but once Nancy and Abby showed up, I had things to say. So this will, if you've been through closings in Norfolk Superior Court before, you know the routine for this. I forget if they do the charge first or closings and then the charge. The point is we're going to be here for a little bit. So get comfortable. They have 45 minutes each side. I don't know if they'll need it. And then they go to the charge. The charge is every jury instruction that they agreed on yesterday. We didn't watch the charge conference in full. We were covering the CCC social consumption yesterday. For those of you who hung with us, that was very interesting. We're going to have Amsterdam-style cafes in Massachusetts now. But in any event, the charge conference laid out. We didn't need to watch the charge conference because the charge conference is just the preview, a longer preview of what the charge is. The charge is where the jury. It's not the charge is. It's the charge. The jury gets charged after closings. And judge sits there, and there's no surprises. Judge sits there and reads a pre-written, agreed upon by both sides, charge instruction, a set of instructions. That takes a while, 45 minutes to an hour. I've been through this before in Norfolk Superior Court. The charges, there's not as many counts, so this won't take as long. But there are a lot of jury instructions. So we'll do that for 45 minutes. And then we're going on verdict watch. I don't anticipate a long verdict watch. I really don't. I think this case will be over by the end of the day. But the morning session is going to run. If jurors are sent to deliberation by 1 p.m., I'll be surprised. There's a lot of just procedural elements to this day. To closings in the charge. And you can't miss anything in the charge conference because it's really important. Like, judge's primary role is a referee, but then judge has this other role, which is to teach the jurors the law that they have to apply. And the lawyers are allowed to talk about it, but only judge can teach the jurors the law. And you got 12 lay people often who are going to go into deliberations that have never learned anything about the law or anything related to do with anything, evidence, procedure, whatever, rights of the accused. So judge has to, just as a preview, judge has to read to these jurors a set of agreed upon instructions that are called a charge. Within that charge, the judge will teach them the law. The judge will tell them the charge, the actual murder charge they're considering. The judge will tell them the elements of the defense. The judge will explain the reasonable doubt standard. The judge will talk about the burden on the prosecution, the reasonable doubt standard. The judge will talk about how the defendant has no burden, doesn't have to testify. The fact that he didn't testify can't be used against him. You shouldn't infer anything from it, et cetera, et cetera. It's a right to not do it. The defendant doesn't have to prove anything, doesn't have to put on a defense. There's no requirement of that. The only burden's on the state. They'll do the consciousness of guilt instruction. That is going to be part of this one, I think, because he admitted to lying to police. So it's like an automatic consciousness of guilt instruction. Any lying to police falls under the consciousness of guilt instruction, which is going to damn him. Because we talked about this during the Reed trial. The consciousness of guilt instruction is technically a limiting instruction. I'm not a lawyer. This is not legal advice. It's technically a limiting instruction for the defense, but the defense never asks for it. What I mean by that is consciousness of guilt looks like it's designed to tell the jury that the defendant's consciousness of guilt shouldn't be inferred unless X, Y, and Z. But if you're a defense attorney, you don't want the word consciousness of guilt said by the judge to the jurors, so you never even ask for the consciousness of guilt instruction. It's not a limiting instruction in form. In content, it looks like one, but in form and in practice, let me rephrase. In theory, it's a limiting instruction. In practice, it's a beneficial tool for the prosecution. Okay? So the only time the consciousness of guilt instruction, as you know from the Reed trial, ever gets read is when the defense lost the motion to prevent the consciousness of guilt instruction from being read. Now, the reason why this becomes important in this case is Walshe is very obviously guilty, but then you hear the judge saying to you, and if you see evidence of consciousness of guilt, such as X, Y, or Z, and then judge will read one or more of six possible options under the consciousness of guilt instruction. There's different ways to do it. Intimidating witnesses, that came up in the Reed case, although it didn't actually, no consciousness of guilt instruction got read in either Reed trial. Another one is lying to police, fleeing, hiding evidence, obstruction of justice. So all of those things could apply. What judge will read, I don't know. So I don't know if he talked to any witnesses, Walshe. But the point is, judge will read one of those or more of those six subsections. And the very fact that the jury is going to hear the judge, who they think is if you're a juror, the judge is your shepherd of your flock. The lawyers, are going to tell you things that are for their case. The judge is like your shepherd. The judge says jump, you say how high. The judge says do this, you do what the judge says. So the judge will explicitly say, I'm not going to instruct you on how to apply the law to the facts. The judge will say this. It is your job to find the facts and then take what I'm teaching you about the law and apply the law to the facts. The judge's job in that regard is, it's such a hallowed position when you're a juror that if a judge says to you something like consciousness of guilt, it sinks your whole case as a defendant, because the jurors have to then, one of them's going to remember, and they're going to get a written printout as well in the charge. This consciousness of guilt thing. Did he do these things? Oh, wow. Well, if that's consciousness of his guilt and the judge said we can consider that, he must be guilty. So it's a fait accompli. It's a very bad situation for Brian Walshe. He's not, and he deserves, in my opinion, to be convicted. He doesn't stand a chance here, though. The state has his defense team completely cornered, and it was a very well presented case by the state. I don't think anyone should discount these prosecutors. That a good prosecutor is like a good journalist. You should fade into the background. Your point is you are the canvas. Nobody looks at the canvas upon which something is painted and says, oh, that's a great type of wood frame, and that's a great type of canvas. No, I'm sorry. That's not what people care about. It's the art on the that you paint on the canvas. So a good artist, a good painter, a good journalist, a good prosecutor just fade into the background, and although they are the medium upon which you are receiving the information, you don't really know about them. Not you don't know about them, but they aren't important. They are the canvas. They are just a piece of poplar wood wrapped in fabric with paint on it. That's when you're functioning effectively, and that's what this prosecution was. It stayed out of the way, but it presented a devastating case, very tactically efficient, very well done, very cordial. Everything about this case was fine. And that's what I think people, it's a lesson to people that criminal cases don't have to be an exercise in hostility. They can be procedurally respectful and also efficient. And that was this case from the state. So as much as we talk about the Norfolk DA's office as a hegemonic entity, it is not. It is definitely embodied by line prosecutors who, outside of the sort of wheeling and dealings of various political machinations, do very good work. I think more people should talk about that, just like we've been talking about the judge in the case who's about to start talking. So I'll talk to you at the break. We're beginning.
For the Commonwealth versus Brian Walsh, criminal indictment 2023-0091. Matter continues on jury trial. Counsel's present in court. Counsel starting with the Commonwealth. Kindly identify yourselves once again for the court and the record.
Good morning, Your Honor. Greg Conner for the Commonwealth.
Good morning, counsel.
Good morning, Your Honor. Ann Yaz for the Commonwealth.
Good morning.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning.
Good morning, Your Honor. Good morning, everyone. Kelly Portis on behalf of Mr. Walsh.
Good morning.
Good morning, Your Honor. Larry Tipton for Mr. Walsh.
Good morning. We'll wait for Mr. Walsh, but while we're waiting, I'm just going to pass you out a couple of versions of something I want you to look at. I have a preference. I don't know how many copies that is, but I think it might be enough. If we need more, I have more. Just put that to the side, counsel, until we get there.
Thank you.
All right. Good morning, Mr. Walsh. I said good morning to everybody else, so good morning to you, too.
Good morning. Thank you.
So since the version that I sent you at 1:55 p.m., I've made the following edits, either based on prompting by you or by my own accord. So on page 9, the use of a dangerous weapon is out. On page 17, the stipulation, separate instruction, I incorporated that into the evidence instruction. On page, it was on page 19. So what I did is I just added into page 19 some text. It's the second sentence. The evidence consists of the testimony of the witnesses, as you recall it. And then I just added in there the things that were marked as exhibits and the stipulation/agreements of the parties, rather than have it as a separate to-do. Just making it a little bit more streamlined. I edited out the last sentence of graphic photos instruction on page, I think it goes to the top of full page 18 as irrelevant to this case. And I also have removed the separate section later on page 18 about opinion testimony as repetitive of the expert testimony section above. On page old page. can't find it right away. You may know where it is when you read through it. It says you'll have all the evidence with you. And I removed the non-relevant weapon and put in including the tools. But as I was thinking about that last night, mental note was, what does the Commonwealth, or how does the Commonwealth intend to safely put those tools? So what I've done in other places, or what I've seen done in other places, and it most often comes up in the context of a knife going back. I've seen other DA's offices basically take the knife and it's like they put it on a hard board and then they strap it down. So the jury can see the item but can't hurt themselves unwittingly with the item. It seems that the same could be done of the tools in this case, if you have the capability to do that. I think I've seen that done in Middlesex, Plymouth. That's how they sort of handle the issue. How are you planning on handling it?
We're working on it this morning, though.
Okay. So what I have in my mind, just so that, and I think law enforcement in the past has done it for the DA's office, so they may have the strapping mechanisms. But as long as I'm assured that they can go in safely to the jury deliberation room, either with a sheath cover on it or preferably strapped down to a hard board, it seems to me that that would be a good approach. Anybody object to that?
No, Your Honor. We'll work with defense counsel, but we're trying to get some supplies to do that this morning.
All right.
We don't have any objection.
So I passed out to you two versions. I went back to look at different instructions I have. I looked at a few different things, and this relates to the direct and indirect evidence instruction. And the version 1 is what I will call I put this in air quotes, I'll call it the Superior Court version of or what I most often see in the Superior Court, which is different than the District Court version, which is a little clunkier, I think. But anyway, you always like what you like, right? That is probably the more traditional, old-fashioned perhaps. As I read through it last night, I think it reads better than the version that I put into the first draft, but I don't have strong feelings about it. So if we have agreement between the parties as to which one you like better, I'm happy to read that. I think both of them are accurate representations of the law. I have a preference for version 1. Take a look at that and let me know when you've finished looking at them and have an opinion.
Your Honor, the Commonwealth doesn't take a position. Neither one seems
Fine. Normally, honestly, I don't spend a lot of time on this in most cases but this case is one that I spent a little more time on it. Yes, Attorney Porges.
Your Honor, we're requesting version 2. So if no one else has a position, I'd ask the court to read that.
All right, which is my version 1, I guess, right? It's the version that was in the instructions yesterday.
I believe so.
All right. Both are correct recitations of the law, so if you wish to draw from any of them, they're all good. And I'm not sure that they make a huge difference. All right. Any other edits to the draft instructions beyond those that I've just incorporated?
Your Honor, on page 12 of the 155 instruction on reaching a verdict, I believe there's some references for each charge, and I would suggest that that might have been a carryover of the plural version.
The four-person,
I have page 12, reaching a verdict, the third paragraph for each charge,
for the charge, yep.
and then has proved every element of the charge beyond a reasonable doubt, then you should find that Mr. Walsh is guilty of the charge or just is guilty.
Okay.
In the next
And
paragraph,
same thing, particular?
yes, Your Honor, particular and then the on that charge.
I'll just end it at not guilty.
Your Honor, on page 13, role of the jury, second paragraph. Do not be influenced by the nature of the,
Charge?
yes, Your Honor.
I think I already made that change. I just didn't tell you I did.
Your Honor, on page 31, alternate jurors, I believe there's a reference to 3, and I believe it's 4.
It is. I made that change later in the day, too, and I didn't tell you about that either.
That's all the Commonwealth has identified, Your Honor. Thank you.
Anything additional from the defense?
No, Your Honor, content, except for the previous exceptions made.
Although now I think most of the previous exceptions you made have been removed.
Just being cautious.
But I get the point. All right, let me step off the bench quickly and make these changes. And the reason for that is I want you to each have all to have a copy so that you can follow along while I'm doing it. It shouldn't take me very long.
All right.
Hello. All right. We have a lot of preliminary matters before we get started, so we'll see how long Judge takes to review these papers. I may just let you hang out, watch the feed. Got to do some towel things. I'm so sorry to hear Nancy has fell. Be careful out there, folks. There's black ice around, and Nancy went rolling. So we are all extending our towel best wishes to Nancy, and also a forewarning that if you are in an area with black ice, you should be very careful on the roads or while walking today. Make sure you have some salt. My name is Grant Smith Ellis. I'm going to let you watch this feed. What did I pick up on? Oh, you named him after Kofi Kingston, Bunny. Yeah, I don't know. My powers of association are pretty good. And Kofi Kingston, I've never met him. I said his uncle. I actually know his dad. His dad's a professor and a librarian. His dad's a really sweet guy. And I don't know. I didn't watch modern WWF. I stopped watching probably back in like April of 2001 during the Attitude Era. I'm more of a fan of like territorial wrestling from like the Memphis days. I really like Kaufman's run, Andy Kaufman's run with Lawler in like 81 through 83. I like a little bit of the Mid-South, Bill Watts' Mid-South. Mid-South was weird, though. Like the promotion was very good, but Bill Watts had like a vision, and his vision, I've best heard it described as, and I guess this is more the Von Erichs, but the Texas wrestling I've heard described as, there was a point where they had a match needing a stadium. I think it was Flair versus Kerry Von Erich. And then for the rest of their time, they had stadiums that needed a match. So I don't know. I kind of like Mid-South, but what I really think was the epitome of the territorial wrestling era was Memphis in 81 through 83. Now, you can talk a little bit about Georgia at the same time, and I think Florida from 79 through 83 had a lot of good talent, and Vern up in the AWA as well. And obviously I know a lot about the development of territorial wrestling, even like Roddy Piper carrying kind of Seattle, and then the culmination of it all with Vince taking over the slot for Georgia Championship Wrestling that normally was filled by Gordon Soley, and then Vince expanding the WWF after his father passed away, and then the WWF finalizing its kind of consolidation after WCW folded because of the terrible decisions of Vince Russo and Eric Bischoff in the 90s. And if you're wondering, Grant, is this why you cannot learn things that are extraneous, because you will just learn everything about it and then remember it? Yes. All right? It's all just in my brain. Oh, Bunny, the next time I see Kofi's dad, I will tell him, I don't think his name's I will tell, I don't know I remember his father's name, actually. They're from Ghana, interestingly, not Jamaica. But yes, I will tell him that. Yeah, it's definitely been cold here this morning. I went out and I was a frigid little towel. But anyway, I'll talk to you for a few minutes. I'm glad some of you are harboring yourselves from the cold. Yes, Bunny, please send in a pic of Kofi. That would be absolutely great. I apparently had some issues getting my email. Someone sent me something I was unable to read. That was actually AD. I hope they'll be able to resend it. But yes, I don't like I like certain levels of cold, like 62, 64 degrees Fahrenheit, towels in his element. You're talking about this, which is like low 20s with a wind chill even lower. Oh, goodness. I was a frigid little towel driving around this morning. I think I've heard this weather referred to as nippy, nips at the body. And let's just say the double entendre there was definitely real for little towel this morning. There's a certain level of cold where even those of us hardened to the long, brutal New England winters with sun gone from our lives by 3 to 4 p.m. on a good day these days are not really ready for something like this. And you might be saying to yourself, Grant, are you just talking because you are tired and you don't want to comment on things and you're going to talk about things later? Yeah, maybe. I heard Towel might make an appearance tonight and have some things to say on the Ray from Dallas show. That could be interesting. Lots of interesting things going on, right? You'll have to tune in. You'll have to find out. But yeah, for now, I'm a cold little towel. And I, like the rest of you, am harboring from the New England winter. Now, Bossy Texas Chick said we expect about a 10:30 start for openings. However, we don't really know what's going to happen procedurally before that. Bunny's like, I enjoy hearing Grant just stream and talk about random things. Well, okay, that's kind of fun. I do have an interesting voice. I was listening to myself ask questions during the live press conference we watched yesterday, and I said, wow, Bossy Texas Chick was right. I really do have an intonation I take on when speaking to the government. And then I was thinking to myself, well, does that mean I have an intonation I take on when doing my broadcasting? And then I realized, oh yes, if you put me with headphones and in front of a microphone, I will adapt a speaking style that's about 280 to 300 words per minute, relatively grammatically accurate, and oftentimes quite fun to listen to. And then I put some of the speeches or monologues I've done previously into a processor, an analytic processor, to find out if that is indeed the rate that I speak at, and to juxtapose that with the pace of most other speakers. It turns out it is indeed abnormal to speak 280 to 30 words per minute in perfect cadence with good grammar and precise syntax, etc., etc. And most people speak at half that speed, and trained speakers go at about 180 words per minute to 220. So it turns out that I am speaking at the upper echelon of the ability of the human voice, which I think is fascinating. I think I've trained myself over so many years to be able to do this. So whatever skills, it's kind of meta to talk about it, but whatever skills I've developed, they are certainly finely honed at this point in terms of sustained dialogue, space, the way that pacing, the way that I breathe. I'm not really sure how it's happened. You develop, I think, much like when you develop fluency in speaking to other people or develop fluency in speaking in front of groups, there's also a fluency you develop with broadcasting, because fading into the background are all the elements that a person who's maybe not familiar with broadcasting or speaking to an audience digital audience would think about. Those moments when you're first adjusting to it are kind of like, oh, what's the setup? Where am I looking? What do I sound like? How is the feed coming in? What are the external factors? What platform am I on? Who's listening? Who's in the comments? All those things aren't in your mind after you do it for a while. It becomes kind of a rhythmic, almost sort of fluid explication of your thoughts, because it's just your normal conversational style. I think I've spoken for, probably 50 to 100,000 hours. That's not an understatement. So at a certain point, I think it's like a muscle. Your ability to speak is a combination of the way that your synapses in your brain fire to actually process and refine the thought that you're having, the thought that you're going to have next, the thought that you're having after that, plus where you were previously in the explication. It's like a real-time synthesis, almost like an index that you're then transliterating into spoken word, and then simultaneously you have to do so in a way that has sort of an element of speech control to it. You have to know how to speak. You have to know how to breathe when you're speaking. You have to know how to deliver words in an English sentence without any pauses and things of that nature. So in that regard, I've thought a lot about these issues, but I don't necessarily take time to explain why it is that I have these skills in terms of public speaking. But it's very natural at this point. It doesn't even feel like there's anything external that influences my brain when I'm engaging in these conversations. I'm just in the moment, in my element, able to relay whatever it is that I want to talk about at that moment quite fluidly. Yes, Bunny, I have certainly trained myself to avoid certain pauses. Now, I will, of course, if I'm reading a question or perhaps thinking, use the word occasionally, but I try to avoid or otherwise. If I'm going to pause, I may take a breath. If I'm speaking about something where tactical pauses will help me slow down, like right there. If I really want to slow down what I'm saying so that I'm delivering information with a purpose and I'm speaking either in allegory or in a subtextual way, then I may use and a lot, because I need that extra half second. Just a little bit of time to think about what I'm doing. If I'm going to use like a rhyming triplet or a pun or an innuendo, I may think, how am I deploying this innuendo or this pun or this allegory? What reference am I using? Is it appropriate for this context? And that in that context gives me just a little bit of time to think about it. But my brain, I think it was Christy Citroni, was commenting on how my brain functions earlier today. And they were saying Grant's brain moves very fast, and he's often privy to information that various compartmentalized segments of the population may know, but very few people know in total and in sum. So when someone was trying to say when Grant's saying things, he's mapping connections that he feels are very firm, and you have to follow what he's inductively thinking in order to understand his process. I understand that's hard because of the way that I speak, and I'm doing that on purpose. I'm educating you, but I'm also demanding a certain level of cogency from you to interact with the material. It's not really gatekeeping, it's a test. If you can't meet the bare threshold of the style in which I deliver the information, that is meant to kind of ward off people who would engage on a more surface level. Now, people in good faith who see a surface level topic and then want to dive more deep, I'll take them through the process. But on the whole, I speak the way I do because it rewards active listening, it rewards people who are informed, it rewards people who pay attention, and I think this kind of content should function like a good book, which is to say, if you listen to it a second time, or if you're paying attention and know the context, the historical context, the writer's history, what the writer was trying to say about like the larger class structure they were writing about, if it's a fiction novel, for example. Great Expectations is a great example of this. You should get something from it. The work itself is not meant to flex. It's not meant as a display of the intelligence of the author. It's meant to encourage the sui generis, or self-generating notion of intelligence by virtue of rewarding it. How do you reward intelligence? You don't praise it. You don't need to put it up there on a stage and tell it how good it is. No, intelligence is rewarded from something like reading a book and seeing something that's hidden in plain sight. So in my opinion, that's how I try to construct the form of the information that I relay on these streams. I want you to see it as an exercise not only in personal growth and education, but I also want you to see that as an opportunity to feel that the effort you put in is being rewarded. Maybe you are getting attention on social media. Maybe you're applying these skills in your life, all of which I think is great. But I want you to be rewarded because you're able to function at a level and engage with material at a level and understand what I'm saying at a level where you feel good. You feel that the effort was worth it, and that process, symbiotic though it may be and very hyper individualized, will lead to ripples within the larger society that can buttress our form of representative government from very insipid discourse that threatens to undercut its principled foundations by alienating people's understanding of what makes government function by virtue of polemic, hyper-argumentative discourse that becomes dramatic, gratuitously, and personal, instead of focusing on systemic reform and how those interpersonal feuds become tools of the corrupt establishment to insulate themselves from the very cogent discourse that would bring about reform. So if you think about it that way, goodness, ladies and gentlemen, I think what we're doing here is important. Marvin Hagler, great to see you. Betty Babel, hello. Bunny B says, your hippocampus retains info and doesn't leave. That's a gift. And then, yes, tactical pauses help for sure. And I've noticed that you don't say hum. Yes. So I think overall I'm very interested in the metacognition of speaking. I'm very interested in the metacognition of how humans think and how I think and why. So I don't really understand my own abilities. I don't know. And I just, if you always had a brain that was working like this all the time, you wouldn't think it was anything different than everyone else's brain. So I just think, oh, this is exactly what everyone else does all the time, and my brain just functions the same way, and it's just a matter of being able to, it must be a matter of being able to compartmentalize this so that some people just don't feel the need to just relay all this information that they have in their brain to everyone all the time. And then I'm like, wait a minute, maybe that's not right. And then I do some research, and it's hard for me to understand it because I don't think of myself as anything but a person. When I walk down the street, I don't know, I'm just a little towel. I don't really think about this. And so when people stare or come up to me or want a picture, I'm like, that's odd. I'm thrilled. Nice to meet you. And then I just move on with my day. I don't really think about it. And then I'm like, wait a minute, maybe there is something to what I'm able to understand, how I put it together. And there you go. So we're back. I talked through the break. I'm sure you'll be a good speaker in time, Bunny. You just need practice.
Everyone all set? Good.
All rise. Jurors entering. Hear ye, hear ye, hear ye. All persons having anything to do with the Honorable Justice Diane Frenier, Justice of the Norfolk Superior Court, draw near, give your attendance, and you shall be heard. Let's have the Commonwealth of Massachusetts in this honorable court. Please be seated. Please turn off your cell phones.
Jurors, and welcome back to the House. Jurors will start today, as we have every day together, with the 4 questions. Jurors, were you able to comply with my order that you not be on any social media or any news media?
Yes.
And were you able to comply with my order that you not do any research about this case?
Yes.
Are you able to comply with my order that you not speak to anyone about this case?
Yes.
And do you all still have open minds?
Yes.
Those 4 answers, for the record, all answered affirmatively by all 16 jurors in the box. We're ready to begin today's work. So as I promised yesterday, jurors, there's 2 chapters that will come interspersed now as we start today. And those chapters are that I will give you the instructions that are specific to the charge of murder here in this case. Then the parties will do their closing arguments. And then, depending on how you're doing, given the time that's passed since then, we may have a short break, a bathroom break. Then I'll come back and give you the more generalized instructions on the law. Deliberately break it into 2 chunks. It's more consumable for you that way. The jurors, I want to thank you for your service on this jury. To a person, when I've looked over, you caught me many times looking over at you. You've been paying attention, and that's exactly what I anticipated, but it's refreshing and rewarding for me to see it. So I know that you have paid attention to the evidence in this case, and I appreciate your attention. Your jury service in this case is a very important part of our democratic self-government. You are responsible to uphold the law and our principles of justice. That's what you promised to do at the start of this trial when you took an oath as a juror. You've all devoted a substantial period of time on this case, time away from your personal lives, your work, studies, your families, to sit as jurors in this case and to decide the very important matter an issue now between the Commonwealth and the defendant, Brian Walsh. You've done so in accordance with the finest traditions and the highest aspirations of our system of justice. Again, I thank you for your service and your sacrifice. You must now consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt that Mr. Walsh is guilty of the crime of murder. The final part of this trial, as I said, will take place in those 3 steps. First, I'll give you on the law that is specific to the charge in this case. Then the attorneys will make their closing arguments, in which they will highlight the evidence that they think is important and will argue in favor of the conclusions that they ask you to make. Defense attorney, Attorney Tipton, will argue first, and the prosecutor, Assistant District Attorney Yaz, will argue last. After the closing arguments, again, I'll give you those generalized instructions that will help guide your evaluation of the evidence and your decision-making and your deliberations as jurors. And then you will work together to reach a unanimous verdict. Please pay careful attention to all of my instructions. All of my instructions are important and you must follow them, whether you agree with them or you do not. To make sure that I give you the instructions accurately, you can see that I'm generally reading them to you. You will also get written copies of the jury charge, the jury instructions, in the jury room when you deliberate the case. I do my best to make sure that the instructions that I'm giving you while I'm speaking match these written instructions. If there is any difference between what I say aloud and the written instructions, please follow what I say aloud. So let me start with the prosecution's burden of proof, and I'll start with the presumption of innocence. There is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Mr. Walsh is presumed to be innocent of the charge in this case. That means that you must consider Mr. Walsh to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at the trial that Mr. Walsh committed the crime charged. And I will explain what I mean by reasonable doubt in a minute. Mr. Walsh does not have to do anything to convince you he is innocent. He does not have to explain anything to the jury. Mr. Walsh does not have to testify, call or question witnesses, or provide any evidence at all because you must presume he is innocent. Instead, it is up to the Commonwealth to prove the charge against Mr. Walsh beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all of the evidence carefully and fairly, if you have a reasonable doubt about Mr. Walsh's guilt on the charge of murder, then your verdict must be not guilty. You may find Mr. Walsh guilty of the charge of murder only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. So, the burden is on the Commonwealth to prove beyond a reasonable doubt that Mr. Walsh is guilty of the charge made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden is on the prosecutor. If you evaluate all of the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That's what I mean by proof beyond a reasonable doubt. There's one indictment or charge in this case. You must decide whether Mr. Walsh is guilty of that charge. For the charge of murder, there are certain things, we call them elements, that the Commonwealth must prove beyond a reasonable doubt to show Mr. Walsh is guilty. I will explain these legal rules to you now. There are two different degrees of murder. Murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. Commonwealth alleges that the defendant committed murder in the first degree on a theory of deliberate premeditation. To find the defendant guilty on this theory of murder, you must be unanimous, that is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every element of this theory beyond a reasonable doubt. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt this theory of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. I'll begin by instructing you now on the elements and the additional requirements for the proof of murder in the first degree with deliberate premeditation, and then I will next instruct you on murder in the second degree. Murder with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following three elements. First, that the defendant caused the death of Anna Walsh. Second, that the defendant intended to kill Anna Walsh. That is, the defendant consciously and purposefully caused Anna Walsh's death. And third, the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. I will now discuss each of those requirements in more detail. The first element is that the defendant caused the death of Anna Walsh. A defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element that the defendant intended to kill Anna Walsh. That is, the defendant consciously and purposefully intended to cause Anna Walsh's death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, that the defendant caused the death of Anna Walsh. Second, that the defendant A, intended to kill Anna Walsh, or B, intended to cause grievous bodily harm to Anna Walsh, or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Anna Walsh. The defendant's act is the cause of death. The act, in a natural and continuous sequence, results in death, and without which death would not have occurred. As you can see, the second element has 3 sub-elements, which I'll call prongs. And the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to Anna Walsh. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that he intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. Let me give you some supplemental instructions relevant to the charge of murder. The definition of death. Death occurs when the heart has stopped long enough to result in complete and permanent loss of brain function. This complete and permanent loss of brain function occurs when, in the opinion of a licensed physician based on ordinary and acceptable standards of medical practice, there's been a total and irreversible cessation of spontaneous brain functions, and further attempts at resuscitation or continued supportive maintenance would not be successful in restoring such function. Next, the jury's obligation on guilt or innocence. You've been instructed on 2 theories of homicide in this case: murder in the first degree and murder in the second degree. If the evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense, you have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of any offense charged, you must find him not guilty. Do either counsel need to see me?
No, Your Honor.
Be happy to see you. I know you haven't been sitting there that long, but you're going to go for a stretch now. So I'm going to ask you to stand up. And, as I said to you before, shake a leg. When you're ready, please be seated. So, jurors, I'm about to conclude my first set of the instructions to you, and we're going to hear the closing arguments of counsel next. This is an important part of the trial because it's the final opportunity that the lawyers have to address you. It's an opportunity for the lawyers to summarize the evidence, to call your attention to certain parts of the evidence that they regard as important, and based on the evidence, to try to persuade you to reach a certain result. However, what you're about to hear is not evidence. Lawyers aren't witnesses. All of the evidence in this case has been presented to you through the testimony of the witnesses, the exhibits, stipulations, which you have before you. And as to the exhibits, you'll have an opportunity to examine those in detail and consider them during your deliberations. Our rules are designed to ensure that the parties receive a fair trial, and they therefore prohibit the attorneys from making certain types of arguments in an effort to persuade you to reach a certain result or to favor or discredit either party. For example, the lawyers are not permitted to refer to facts that are not in evidence in this case. If, based on your memory and understanding of the evidence, a lawyer does this, you should disregard that comment. The attorneys are not permitted to express their personal beliefs in the credibility or lack of credibility of any witness who testified in this case. That determination is entirely for you to make. If a lawyer makes such a comment, you should disregard that comment. This case must be decided based solely on the basis of the admissible evidence and the law that I'm teaching to you. Attorneys are not permitted to persuade you for or against either party by appealing to human passions or prejudices. If a lawyer makes such a comment, you should disregard that comment. If you become conscious of any passion or prejudice as you consider the evidence and engage in your deliberations, you must put these feelings aside and not permit them to influence your thinking. With that, we'll turn to the closing arguments. As is the custom, we'll hear first from the defense. Attorney Tipton.
What could happen to a loving father and a loving husband? We're making line of pleas before you. Search for the unspeakable on the internet. Exposed body of the woman that you adore. Government suggests it was an affair. There's no proof of that. There's no proof that Ron Walsh knew anything about an affair between the woman he loved and William Dixon. Money? Second reason that the government suggests, family money?
money that the family had worked together for years and continued to talk about in text messages and the sales of property, trying to protect the assets for the benefit of the whole family and the future of their 3 children. A motive? There's no motive. Refusal to consider prison for a terrible mistake he made. The case that began in 2018. There's no proof of that he was afraid to go to prison. Who wants to go to prison? But prison was always on the table. And it was just something that he had to face up to, and something that he did. So, what would cause a loving husband and a loving father to do the things that you heard about in this case? Could it be something that was sudden, something that was unexpected, something that was unbelievable, something that only a medical examiner would understand, have knowledge of, but not a man like Brian Walshe? Something that is terrifying, something that defies logic when it happens. How do we know that Mr. Walshe was a loving father and a loving husband? We know from much of the testimony of Jim Ludlow. We know from simple testimony from Julie Basler from Kindergarten. When asked questions about her experience with Mr. Walshe and the children, that he would show up and he'd be interested and he'd be friendly, and he was always interested in the progress of his children. And how do we know he was a good father? Because Anna Walshe trusted him with their 3 children, 24 hours a day, 7 days a week, for all those times she was up in Washington, D.C. The unthinkable happens. It happens in a variety of ways. And the Commonwealth must prove to you beyond a reasonable doubt that a homicide occurred, that a killing occurred. Nothing proves that beyond a reasonable doubt on the facts and circumstances and the evidence given to you. There's evidence that he lied to the police. There's evidence that he searched the internet. There's evidence that he disposed of a body. But there is no proof in all of the evidence that you have heard and been presented that he ever once thought about harming the woman he loved. That he ever thought about harming the woman he loved. That he ever planned to harm. That he ever intended to harm. So, when we talk about the evidence of the affair, when we talk about evidence of financial concerns, when we talk about evidence of being ready to go to prison, those are the motives that the Commonwealth needs to prove to you to support any notion that a loving husband and a loving father would kill his wife. And the evidence suggests there was no motive at all. And without a motive, without a reason that is based on facts and circumstances, logic and understanding, without that, you have a sudden and unexpected event that results in confusion, and panic, and fear. all of those things that are so troubling and horrific that you've heard evidence about, they may be argued that they show consciousness of guilt. But people do things, terrible things sometimes, not out of guilt, but out of fear, out of disbelief, out of confusion. Certainly, a loving father and a loving husband would feel guilty about what he did do. Not just about lying to the police, but what he did do in the context of what he did to the woman he loved. In a moment, in hours, and in days of confusion and disbelief and horror. But that feeling of guilt had nothing to do with her killing, because he never killed Anna Walshe. You will hear arguments that you've seen the evidence. You cannot base your verdict on sympathy for Anna Walshe. You can't base your verdict on anger to what Mr. Walshe did. You can't base your verdict on passion, based on the evidence that you've heard that is upsetting and terrifying and at times disgusting. But that's not what you can do as jurors in this case. At the beginning of this case, when you were sworn as jurors, you might not recall it, but the clerk of this court read you some words. To this indictment, the defendant pleads not guilty. He places himself before this country which you are. The obligation that you have accepted in this case is unlike perhaps any obligation that you've ever accepted in your life. Perhaps. That's for you to judge. But your obligation requires that without passion and without anger and without sympathy, that you assess the facts as troubling as they are, and at times as horrific as they are, and make your verdict rest on the evidence, and nothing less and nothing more. Unbelievable? Facts that don't make sense at times? Something that is incongruent? An example of that is the end of Mr. Jim Litlow's testimony, where for almost an hour he talked beautifully about the love between these two people, that he talked glowingly about Mr. Walshe. And then toward the end of his examination, he wanted to say something about now he was thinking there might have been some kind of problem, and reflect upon the evidence that he gave of a phone call he had with Mr. Walshe on the 4th, when the conversation was confusing to Mr. Litlow, confusing where he kept asking what could have happened that would result in Anna Walshe leaving. The lie that Mr. Walshe was telling people out of fear that no one was going to believe him about what happened, so he lied. But consider the way that Mr. Litlow had a terrible time trying to understand that. And why? Because he knew both of them. Because what he was thinking, why would Anna Walshe leave? They love each other. I know them both. It makes no sense. And that is what happens when something happens that is totally totally confusing. You just can't believe it. And you seek answers. You yearn for answers that make sense of something. And when something sudden and unexpected happens, something tragic, your ability to come to terms with it, when it's such a dynamic, such a tragedy, you change. You change. The evidence of the searches, the dark, troubled evidence of the searches. They began at 4:52 a.m. on January 1st of 2023. And the first one is, how do you dispose of the body? It causes chills. It causes disgust. Look at all of those searches. Think of how they evolved. Consider how they go from one subject to another in rapid fashion. Searches conducted by a man that is in disbelief, in confusion. 5 hours spending with his wife on New Year's Eve, enjoying life, talking about the future. And then sudden and unexpected tragedy happens, and it doesn't make sense. If Mr. Walshe began to make those searches with murder in his heart as a result of murder, then why isn't the first search how to dispose of a body after murder? Because that's the search that occurred 6 hours later. And when you see that word murder, no one would not react to that word. And certainly as jurors in this matter, you're expected to react in a way to that. What does that mean? Does that mean that he in fact murdered his wife? But think about it in context. In this case, on these facts, context matters. And so the first time the word murder is used in these horrific searches is 6 hours after they began. And I tried to ask Trooper Garino, one of the forensic specialists, as he called himself, associated with the Mass State Police. I tried to ask him, well, it's only logical, isn't it, that if you don't get results, you change the wording. We all know that from our own common experience. And you look at those searches that came and went during this time, and the results had to do with funeral parlors and cemeteries and things like that. But Mr. Walshe, given the tragedy that occurred to his wife, and given the time that had passed and his fear and disbelief, he couldn't call a funeral parlor. We need to try to understand, what can I do? Then the searches become darker. They become more upsetting. Now the thought is dismemberment. And there's searches like that. You've heard about them. You'll read about them. And then you see searches that cover days. And there's searches about cleaning. And there's searches about how to clean up. You'll read them. And even though they don't talk about murder, they are equally upsetting, because you're thinking, as jurors in this case, he's thinking about cleaning up the basement. He's thinking about how you clean a concrete floor. Context. 1,034 pages of digital data, 3,667 records taken from his MacBook. Not one record, not one page refers to any plan. Not one record, not one page refers to any intent to kill. Nothing. So keep it in context when you review parents. I suggest to you respectfully, you are the jurors. What is the evidence of premeditation? There's evidence of a knife. There's evidence of a knife that is seen in a kitchen cabinet. Could I please have exhibit 201? And next exhibit 202. And finally exhibit 203. The knife. It was above a refrigerator. It was in plain view. Had no visual red blood stain. And yet the government wants you to think about this knife. So think about it. Don't ignore it. Do not refuse to consider it. Of course you will, but think about it. In a cabinet above a refrigerator. And they first test it with some screening test. It doesn't prove that it has blood on it. And they take it, and they should. And then, what happens is everybody loses interest of the knife. Everybody, the Mass State Police, the crime lab. There's no further testing of this knife. And ask yourself, if that knife is to be considered a weapon used, then why is it in that cabinet? You have heard evidence of bags and bags being thrown in dumpsters over a period of days. The government wants you to think that Mr. Walsh killed his wife and perhaps used this knife. Then why was it sitting in a cabinet days later in open view for the police? What logic is that? And there is no proof that it had one piece of biological evidence on it tied to any killing or any harm. And they simply lost interest in it. You can take it down now. Digital data. Talked about that briefly, but there is nothing in that data. All of that data. And we're talking about text messages. We're talking about backbook searches. We're talking about the life that's embodied in computers that this day and age we know apparently keep track of everything we do and to some extent everything we think about. Because that's how the government is using that data. They ask you to look at certain things and indicate and try to argue that, oh, this is what he was thinking. So look at it and judge for yourself. What's in this data that demonstrates premeditation, or intent to kill, or intent to harm? You have heard and seen much physical evidence. You've seen pictures of gray slippers with blood on them. You've seen pictures of all kinds of physical evidence. And if the argument is made by the government, something about a dark gray slipper with blood on it indicates that a murder happened because listen to the argument. Of course you will. But a theory, an opinion, does not make it true. And to suggest something like, the evidence shows that Mr. Walsh went and bought a Tyvek suit, and maybe there's just not enough blood on the Tyvek suit to satisfy the Commonwealth, and so they suggest that some killing happened, and that's why there's so much blood on that slipper and those slippers and all that other evidence. But ask yourself, what do I know about that evidence now from what we heard? Every piece of evidence was put into a bag, but then was put into a compactor eventually and was pressed together and then found. And you will see all of this evidence of when they pulled it out of dumpsters and unloaded the bags, and they first put it on damp ground without any paper below it, without any tarp below it. And you heard from no less than 3 witnesses. Mr. Gould from the Mass State Police Crime Lab, Mr. Sheehan from the Mass State Police Crime Lab, and Ms. Celine from the DNA unit. They all consistently said cross-contamination or transfer. They used different terms, but they all agreed. So the evidence, the physical aspect of the evidence, the thing you see in the photographs, the thing you see now, if you open up one of the bags and take things out, is not representative, or may not be representative of how it looked before. And you must consider that. So when the government makes an argument based on the state of the physical evidence as it appears now, ask yourself, maybe that makes sense, but maybe there's another way of thinking about it. And why is that important to your deliberations? Because you are allowed to rely on what's called circumstantial evidence. You're allowed to rely on inferences. And Her Honor will instruct you on that. I will not. But whatever reason and basis you have for making your choice and determining your decision must be reasonable. And if you, as jurors, talking amongst yourselves, find that some of your fellow jurors say, well, I think maybe it means this, and I believe this, and your other jurors, fellow jurors, say, I think this, and I believe this, you'll all consider it. But if you don't agree, then you have to ask yourself, is that inference reasonable? Is that circumstantial evidence built upon inference? Is that reasonable? And can I use that? And should I use that to try to reach a verdict under a standard of reasonable doubt or moral certainty? What is the evidence that something violent happened in this house? I went through every room as best I could with Mr. Sheehan. There was nothing found in the upstairs bedroom. There was nothing found in the sinks and basins, showers, of multiple bathrooms. Nothing found, meaning biological evidence that might indicate something violent occurred. There was nothing found in the kitchen other than a knife that they lost interest in. There was nothing found in the living room that had padding around the fireplace to protect the children from falling. There was nothing in that bedroom where Anna Walsh, Brian Walsh, as adults, enjoyed their life together and had spent their life together, perhaps every night, before she moved to D.C. to take that job. How do we know that? We know that because the photographs show there was nothing there. Even what was characterized as red-brown stains on curtains in the bedroom turned out not to be blood at all. We know that because trained examiners from the Mass State Police examined probably every square inch of that house. We know that because we saw photographs in her testimony about floor that was dug up based on their experience and training. That biological evidence, like blood, can fall between the cracks of flooring and reside on the subfloor. And so they tore the floor up, and you saw those photographs, and you'll have them. And nothing was found. Nothing at all. I asked Mr. Sheehan about blood spatter, and he forthrightly and honestly said, I'm not a blood spatter expert, but he explained it sufficiently to you. Someone wielding a knife or a weapon and causes blood to let out of a body, and you look for blood that has spattered with directionality. Nothing. Nothing in the bedroom, nothing in the living room, nothing in the bathrooms. No evidence that blood drained down the drains. Could I have Exhibit 217, please? That test that I asked Mr. Sheehan about, the Serotek Hem test, that checks for hemoglobin, for blood, that test, he agreed, can detect blood at the sensitivity of 20 nanograms per milliliter. 20 nanograms. A nanogram, as he agreed, 1/1,000,000th of a gram. Think of how minuscule that is. And they used that all over the house. And so the government elicited questions and answers from many of their state police, but 10 or 20, they didn't call everybody. That's up to them. But apparently there was no need to, because 10 people or more, as Mr. Sheehan had described to you, he was estimating. He was trying to be as honest as he could and credible, and he was. 10 people pouring over that house all day on January 8th. 10 more people or more pouring over that house on January 9th with their tools and their experience, and they don't find anything except multiple bloodstains where? In the basement. In the basement. On the concrete floor. Ask yourself, when you heard testimony that Mr. Walshe attempted to clean, and so therefore they couldn't find evidence in the other parts of the house because he cleaned it. Well, ask yourself, wait a minute. Is that logical to suggest that he cleaned the bedroom up so well nobody could find a thing? He cleaned the living room up where the rug may have been, and they couldn't find anything. Well, then you see those searches where he searches specifically for how to clean concrete. So you might infer, and it might be a reasonable inference, that he attempted to clean that concrete floor. And yet, what was found on the concrete floor? Multiple red-brown stains that turned out to be blood, and in some instances, we can all agree, based on the testimony of Ms. Salim, the profile of those blood drops matched the profile of Anna Walshe. So to suggest that Mr. Walshe did everything he could to clean the basement concrete floor with hydrogen peroxide and mops and cleaning fluids, only to have blood found on the floor, defies a reasonable inference that he was able to clean any part of that house sufficiently to avoid detection. And why is that important? Because nothing violent happened in that house, and that's why there is no biological or blood evidence anywhere in that house. The act of trying to hide the body of his wife and the blood evidence that is seen on that carpet. That's what happened. There's no blood in the living room. The inference might be that the carpet was taken downstairs. Because you can look at those pictures. You can look at the physical pieces of carpet, and you should. If there is no evidence of any killing that happened, and there's no evidence that anything was done before Mrs. Walshe died, and there's no evidence of premeditation or anything, there is evidence of lying and disposing of the body. You can take that downstairs. So now we look at the evidence, and I'm just going to characterize it. Some of the evidence that the Commonwealth has presented to you, and there is no question that their obligation is to present to you evidence. But I just ask you to think about, in some cases, how that evidence was presented to you. And I'm going to use a phrase that may or may not be entirely accurate, but it's cherry picking. It's looking at thousands of points of data and asking you to think about it, but not telling you why you should think about it. And what am I talking about specifically? And I'll give you some examples. We already talked about the hole in the ceiling, but let's talk about it a minute. They kept talking to you about that hole in the bedroom ceiling as if it was of some significance. And yet you recall the testimony of Mr. Sheehan. I didn't say anything significant about it. It looked like somebody might have fallen through the ceiling. And there's nothing significant about the pieces that Mr. Walshe had stored in the cabinet in that same bedroom. I asked Mr. Sheehan about that. No, I didn't say anything significant about that. Yet you kept being given that evidence. And then as the evidence developed, for some reason, there's Mr. Murphy. And it came out in evidence that Mr. Murphy had in fact contacted Mr. Walshe because there was a promotion going on. It wasn't that Mr. Walshe said, hey, come and fix this hole, this suspicious hole. No, he was contacted. And he didn't respond right away, but then he did. And for some reason, they keep insisting that that hole is of some significance, but they don't tell you why. They just give it to you. They do the same thing with the searches. Remember when Trooper Peef was sitting right here and he's asked to look through those thousands of, 250 pages of the search history from the iPhone Mini 13, the phone that belonged to Mr. Walshe, and he's asked to look at it and says, do you see searches there to go to the MGM? Yes, I do. Nothing else. No explanation why that is significant, why it's important to try to determine if a man committed premeditated murder. You're just throwing back pieces of evidence. Why? Why were you given... Why was Trooper Peef asked to tell you about a song, a partial song title? And when you go over that evidence, look through there if you choose to, and I encourage you to do that. And you see song after song and movie title after movie title. Why is it that the government throws that at you and says, Think about this. For what reason? And then they present to you through Trooper Garino something about a porn movie. I'll just take this opportunity right now to apologize to each and every one of you for some of the questions I asked. But it just didn't make sense that you would take that type of evidence and suggest that it has anything to do with determining whether someone committed deliberate, premeditated murder because there's a word in the title of a movie. And that's what I'm talking about, the quality of some of the evidence here thrown at you as if it means something, that it's significant, and yet here you are being asked to determine if someone, Mr. Walsh, committed premeditated murder with a specific intent to kill the woman he loved. When we talk about premeditated murder, we talk about planning, you have to ask yourself, did I hear evidence of the conduct of a man who premeditated, a man that had thought about a killing, a man that had planned? I mean, think about what you heard. And we're not going to repeat all those things I've already said, but I want you to focus on one other piece of evidence. I asked Detective Schmidt, when you went down to the basement on January 4th, you saw some bags down in the basement. Yes, I did. What did you think was in those bags? I thought they were pieces of rope. My goodness. What does that tell you about the thinking process and the sloppiness and the lack of any planning or careful thought that you would expect out of someone who had planned a murder? And then he lets a police officer walk down in the basement, and the police officer, based on his training and experience, uses, I think he said, his boot, and he felt it. He said, felt like pieces of rug to me. Rug? That is in evidence. It has blood. Think about all of that when you're thinking about it. Did this man, Mr. Walsh, did he plan anything? No. Did he intend to kill anybody? No. Did he kill Anna Walsh? No. The evidence does not support a finding of premeditated murder with specific intent to kill based on the evidence, not based on sympathy, based on the evidence. What's some other evidence that is troubling? Mr. Walsh is talking to the police, and he says, I messenger. When asked about, and he was trying to explain it, things will come up on my phone that I thought were for me, but then it turns out they were for Anna. And so the government seizes upon that evidence and suggests that there's evidence that Mr. Walsh had seen text messages between Anna Walsh and William Fastow. And those text messages between Anna Walsh and William Fastow, some text messages are placed into evidence, and I'm sure you'll look at them. And why would the government want you to believe that Mr. Walsh saw those text messages? Because some of the entries in those text messages are very upsetting. They may very well enrage a husband to read about what was going on in those text messages. So you'll look at them. But ask yourself, as you look at them, and perhaps as you think, I could see that might upset, that might put somebody in a rage. Problem is, there is absolutely no evidence that Mr. Walsh ever saw any text message, because he was trying to say, I messenger, and now you know from the testimony of Trooper Keith, there's no such thing as I messenger. We're talking about Facebook Messenger. But the important thing is, there is no evidence in all of the digital data that you have before you, in all the digital data that they examined, that Mr. Walsh ever saw anything going on between his wife and William Faster. And when you look at those text messages, and you might have some question about it, and if the government stands up and says, well, he saw those because he told them that he was seeing iMessenger, which doesn't exist, then ask yourself, why is it that on New Year's Eve, Anna Walsh is taking all these photographs? It's festive. It's a lovely situation. And she says, in the presence of Brian Walsh, as she and Jim Mutwell were taking photographs, hey, why don't we send a photograph to Will Fasto? And was there any evidence that he reacted, Mr. Walsh? No. And when asked by Attorney Porges, well, so what happened next? And Mr. Mutwell really took efforts to remember, and then he said, oh yeah, that happened right before the young boy woke up and came downstairs, and that was around 10:30. So if you just think about that, then the festive and jovial celebration continued for another 2 hours. There is no evidence that he reacted. Mr. Walsh reacted to them sending a photo. Why? Because he knew his wife had a crush on Will Fasto, and it didn't even make him jealous. And how do we know that? Because she told her friend, Alyssa Kirby. And Alyssa Kirby was asked, and she said, you know, Anna told me that he didn't get jealous. He's not the jealous type. In fact, I wish he was more jealous. Please consider that in the context of this notion that the motive for a killing that did not occur, but the Commonwealth's theory of a motive is anger over an affair. There's no evidence of that. Dr. Atkinson told you. Dr. Atkinson described to you the phenomenon of sudden unexpected death. It happens. And just because it's rare, and just because the government will undoubtedly argue that that is nonsense, listen to their argument. But Dr. Atkinson made it clear it happens. It happens in young and old, male and female. It happens unexpectedly. In fact, it happens with people who have never manifested any problem before. It happens in athletes. And how do we know that it's not absurd, even though it might be rare? How do we know it is an important aspect of what happens to people? Because the laws of this state mandate that the office, the chief medical examiner, get information from doctors, police officers, nurses, when there is a sudden death, when someone is otherwise healthy. They're mandated to investigate that. So there is a statute that Dr. Atkinson told you a little bit about on cross-examination. So ask yourself, is it as unlikely? Is it bizarre? Because Anna Walsh worked out? Yes, she had been sick before. She had been with Alyssa Kirby in the days leading up to this, and Alyssa Kirby wound up having the flu. But that's not what really is at issue here. Sudden and unexpected death may occur because someone is ill. All we know is that it happens. And the fact that someone doesn't believe it could happen doesn't mean that it doesn't. Importantly, though, think about the shock of it happening. Think about the effect it would have on anyone. A lay person that has no idea it could happen. You're down celebrating with your wife and your friend, and then the tragedy happens. And you panic because you can't believe it. You don't understand it. And you don't think anybody's going to believe it. Context. I walked Trooper Keith through all of that information, something that he had not done yet. And so what did you hear? We went methodically. Sometimes, I'm sure for some of you, it was a little painful. It took a little while. But we went through hour by hour, day by day, that basically was the life and the experience that Anna Walsh and her husband, Brian Walsh, were going through in just the days leading up to January 1st of 2023. And what do you see? And you'll have that evidence. You won't have it compiled in the way that I presented it to you, because Trooper Keith never saw fit to assemble it in a way where you could really see what was going on. But what do you see, and what did you learn from the evidence? Two people communicating by phone and by text, talking about sales of property, talking about investments, talking about the future, talking about reinvesting, talking about buying new property in D.C., talking about all of that, and it's all in the text. Joking when Anna Walsh was ill and stayed home and told her husband that in the text. And then they joke about it. I'll get you a plunger. And she responds, it's right there on the text. Joking back and forth in the days leading up to New Year's Eve. I'll tell you what, I'll buy the plunger, you buy me a Porsche, and then you see him shopping for a Porsche for the woman that he loved. How does it go from, I'm going to find you the Porsche you want? It speaks once again to the financial issues that were non-existent. How does it go from that to someone who is purportedly premeditating and intending to kill his wife? And those texts lead right up until she arrives by plane in Cohasset to celebrate. So, context. Once again, divorce? About 11 minutes of talking about divorce and searching about divorce in 7 days of phone calls. And how did that divorce search come up? It came up in the context of protecting the family assets because they just sold the house in Revere that Jim Mutlow told you about. And they're trying to protect it. And the thought is to roll it over in a 1053C. And Mr. Mutlow explained that to you. Planning for the future. That is the relationship between Brian Walsh and Anna Walsh in the days leading up to January 1st. So now we have come to just the evidence that once again just explains their relationship. Not supposition. Not trying to make up what they said to each other. You have that in their text. You have that. Then we get to New Year's Eve. We get to a festive event. Jovial, laughter, love, described in various terms, various ways. Not for 30 minutes, not for 1 hour, but for 5 or 6 hours. Laughter, talking about the future. Jim Mutlow described it for you. Brian Walsh cooking, standing across from the island, feeding both of them, talking, laughing. You see in the testimony that, yes, there was an affair. He didn't know it. He loved his wife. He treated his wife like the wife he loved, the mother of his children, until the sudden, unexpected event happened. Imagine, you are so in love. You support your wife to get a job in D.C. You're going to take care of the kids because, one, you love your children, but you want to take care of them. You want to share property and protect the assets, so everything goes into her name to protect it because he has this federal case. to let's protect our financials for the future. And then you hear the testimony of Alyssa Kirby. Yes, she was upset. There's no doubt Anna Walshe was upset. What exactly she was upset about? Maybe things weren't going really well in the affair she was having. Or maybe she was, in fact, stressed out. Who wouldn't be? They were living apart. She wasn't seeing her children. Now, maybe, it's up to her. Anna Walshe was a wonderful person and a wonderful mother. And that's why he loved her so much. But she had another life, and she went to Dublin, and that's another piece of evidence. They want to suggest to you he knows something about Dublin. Where is the evidence of that? None. And you hear Alyssa Kirby choked up with tears, sobbing on the stand, but nonetheless recalling a conversation she had on 12/29, 3 days before January 1st. What does Anna tell her? Well, I don't know if I love him as much as I used to. Those are her words. I'm paraphrasing, but that was the gist of it. But I want him to take responsibility. Why? Not so she could kick him out, not so she could leave him, so they could reunite as a family. That was what Anna Walshe was talking about. That's what she was thinking, even though she was stressed, even though she was upset. And things like that happen in families, but families make it through. And that's what she was expressing. That's what she was expressing to her best friend, Alyssa Kirby. Could I even hear it 169, please? We are now at the end of the New Year's Eve party, and they sign the champagne bottle. And we were talking about the feelings and the emotions and the state of mind of Anna Walshe and Brian Walshe, and looking towards the future. And this is on January 1st. This is on the day that the tragedy happened. Can you find it? I'm sorry, 169. Oh, I apologize. My fault. I'm sorry. It's at 257. And that's the champagne box that was signed. And what are the words? What a year. And yet we are still here and together. Let's make 2023 the best one yet. We are the authors of our lives. Courage, love, perseverance, compassion. Those are the words of Anna Walshe talking to her husband. Look what she says. What a year, and yet we are still here. What does that tell you? Yes, they had been through a lot. She missed her children. What mother wouldn't? But they were working toward the future. And one final thing about the state of mind of Brian Walshe at this period of time. He made reservations for a New Year's Day dinner so he could be alone with his wife. And the evidence of that is in these records. And I'm not going to have it called up. I'll just tell you. Exhibit 79, page 186, record 682. That's the data. He's researching where to take her out. And you'll see a reference to Nightingale, a restaurant that I asked Trooper Keith about. A restaurant that's right on the line of Marblehead and Lynn. Exhibit 59, at 12:27, those records indicate that Mr. Walshe credit card used to reserve dinner for $573.76, so him and Anna could spend New Year's Day celebrating. And Exhibit 170, a text from Nightshade Restaurant itself acknowledging the reservation. And those were the plans that he made. And the government will suggest that's some kind of evidence of premeditation. Well, it's not any evidence of anything but love. And I'll just tell you, When you look at that evidence, you'll see that that email exchange was deleted. It's right there in the evidence. And then you heard the federal probation officer saying he wouldn't be allowed to go there. He'd have to get permission. So yes, did Mr. Walsh lie to his probation officer for what reason? So he could take his wife out for a New Year's dinner, and that evidence, and the evidence that you saw in that champagne box, is what their life was right at the moment before the tragedy happened. That is the evidence. I'm sorry I talked for so long. I apologize. Mr. Walsh loved Anna Walsh, the mother of his 3 children. There's no evidence that he deliberately premeditated a murder. There's no evidence that he ever intended to kill Anna Walsh. None whatsoever. Mr. Walsh is not guilty. He's not guilty of murder. Thank you.
Jurors can't. Why don't you take a moment to stand up? Everyone good? When you're ready, you may be seated. Yeah, we're closing the argument of the Commonwealth. 80 a.m. You may proceed.
Thank you, Your Honor. Walsh is dead. Anna Walsh is dead because he murdered her, and he intended her death. Anna Walsh is not missing. She never walked out of her Cohasset home on January 1st of 2023 between 6 and 7 a.m. to take an Uber to Logan Airport. She wasn't going to D.C. for a work emergency. There was no emergency. She didn't say goodbye to her son. That's just a story that the defendant told people. But since January 1st, Anna Walsh has not been seen by her friends or co-workers or by the people who loved her. Anna didn't take an Uber. She didn't take a Lyft. She hasn't used her phone. Her phone's had no contact with the Verizon network since January 2nd of 2023, when it was in the vicinity of 516 Chief Justice Cushing Highway. She hasn't used her bank accounts, her passports, her credit cards, her email. She didn't vanish. The defendant was the only adult at 516 Chief Justice Cushing Highway after Jim Lulu left around 1:30 a.m. on New Year's Day. And after he left, Anna was home alone with the defendant and their 3 sons, ages 2, 4, and 6. This defendant caused Anna's death, and the evidence does show you that. The evidence shows you that Anna didn't die of natural causes, but that Anna died a violent death in her Cohasset home on January 1st. You have the photos of those pieces of rug
recovered from the dumpster at the defendant's mother's complex. The rug that had been in the living room. You have the photo of Anna in the living room on top of the rug. And the photo shows that there are wood floors in that room. There's blood on that rug. The rug was recovered from the compactor outside of the defendant's mother's apartment and taken to the office of the chief medical examiner for examination. And Dr. Atkinson found a blood clot and a piece of Anna's Gucci necklace embedded in one of the cut-up pieces of rug. So look at the piece of metal stamped Gucci. It didn't break on its own. The rest of the necklace is missing. This is the necklace that Will Fatsow said that Anna often wore. Look at the slippers from the dumpster. The 2 pairs of adult slippers. The dark gray slippers have hair and blood clumped to the bottom. And the DNA testing tells you that the slippers had the DNA of Anna Walsh and the DNA of the defendant. Then there's the bathrobe, and there are 2 bloody white towels. A towel was tested and had Anna's DNA. Why did the defendant throw those items out? Because they had Anna's blood on them. And the evidence shows you this because the defendant was researching cleaning. How to clean blood from what floors? Does dishwasher clean blood? Is it possible to clean DNA off knives? The defendant still had a cut on his thumb on January 9th, 2023. And on January 1st, before he even went to Lowe's to buy any cutting instruments, an initial stop that he made when he left his house was to go to Walgreens to buy antibiotic ointment and Band-Aids. Then he went to Bin and Liquors, where the manager identified the defendant, and the defendant threw a bag into the dumpster. The store is closed. The parking lot is empty. He's not yet gone to Lowe's. On January 2nd of 2023, the defendant went to Home Goods because he had to buy a new rug for that living room to cover the hardwood floor. He did this days before the forensic scientists got to the house and knew that the rug had been changed. Anna Walsh dying a sudden death from natural causes defies common sense. She was in great shape. The defendant told police that Anna was a sturdy Serbian woman. Listen carefully to his recorded interviews, because those are his words after her death, after he killed her. Mark Salvaggi told you that Anna had the highest health rating of the life insurance company. Anna had to complete an interview, have blood drawn, provide her medical records, and the life insurance company and the underwriters gave her this health rating. Anna was an active person who took care of her health. Ashley Semino, her bar instructor, told you about this exercise class that she took the morning of December 31st of 2022. And Anna was the type of person, she said, who made others want to work harder in their exercise class. Will Fastow told you that Anna was very active. They did yoga together. Sergeant Amy Waterman described Anna's home gym in D.C. And Dr. Atkinson told you about the different ways a person can die, and that it's extremely rare for a 39-year-old in good health to suddenly die of unknown causes. But without a body, it's not possible for the medical examiner to tell you the exact cause of Anna Walsh's death. No autopsy can be done. The defendant deliberately got rid of Anna Walsh's body. The defendant did not want anyone to find Anna's body and to know how she died. So the defendant bought cutting tools at Lowe's and Home Depot, and he cut up Anna's body, the woman that he claimed to love, and he threw her into dumpsters. He was hiding her body. The defendant intended to kill Anna Walsh. He didn't just want her dead, he needed her dead. This was a marriage in crisis, and it was heading towards a breaking point. It began with the defendant's federal case, and through the defendant's interview and his federal probation officer, you learned that the defendant was on home confinement. He was going to have to pay over $400,000 in restitution, and the case had been pending since 2018. You also learned that the defendant had no assets. He told Jamutlu that he only made $50,000 to $60,000 that year, but he had told the police that he had businesses that were not making any money at all yet. Peter Capozzoli told you that the defendant's mother had signed the lease for the Cohasset home, and it was his mother that was paying his rent. Meanwhile, Anna was beginning to thrive. The marriage was beginning to deteriorate. Anna had her dream job. She had risen to become an executive at Tishman Speyer, and she was making close to $300,000 a year. She earned a bonus. And Teresa Marchese said that Anna was a good employee. And the defendant knew this. He bragged of her bonus and salary. She bought a townhouse, and she furnished that townhouse for her family, and she set up bedrooms for each of her 3 boys. But the reality was, her family couldn't join her because the defendant needed the children with him. Being the primary caregiver allowed him to avoid prison. The separation of the defendant and Anna was taking a toll. Anna wanted the children with her, and Anna began a relationship with Will Fastow, which became more serious. The defendant and Anna were growing apart emotionally and physically. Anna struggled not having her children and not being able to be the mother that she wanted to be. This got worse when Anna took the trip to Serbia to take care of her sick mother. Anna and Will Fastow spent the Thanksgiving holiday first in Dublin before Anna went to Serbia. And Anna bought her plane ticket with the credit card that the defendant monitored. And the defendant told police that he monitored their joint Chase Freedom credit card statement. The MacBook history also shows the defendant looking at the Chase account. The defendant knew about Anna's travel because in a recorded interview, he told the police that she had a layover in Frankfurt, and that connection in Frankfurt is on the same credit card statement. And you can see that, it's right in front of you. The defendant was angry about Anna missing Thanksgiving, and he mentioned it repeatedly when he spoke to investigators.
I got angry about Thanksgiving
And then, I realized it was just sad that we're not spending a lot of time together. And she was sad about it too. And it was exhausting for both of us. She was away from the boys. I was always dealing with the boys.
Anna returned from Serbia in December, but she only spent one day in Cohasset. And she was supposed to come home for Christmas morning, but she missed her early flight, and she couldn't get a flight, and then she had to drive up. The defendant told police there was an argument.
I did have an argument with her for the Thanksgiving and the Christmas Eve, so I wasn't going to make the same mistake 3 times.
So what did the defendant do on Christmas Day when his wife wasn't home? He looked up Will Festa on his cell phone, the man his wife had just spent the night with. The defendant was losing Anna. Anna was missing her children and wanted to be them. Anna quickly returned to D.C., and on December 27th, the defendant was looking up the best strategies to divorce for a man and the D.C. divorce laws. This was not to protect assets. That wasn't the search. The defendant told the police that everything was in Anna's name. The defendant had nothing without Anna and the kids. And on December 29th, Anna spoke with General Wu and told him that she was upset about the travel, upset being separated from the children, upset about the defendant's federal case. It was ongoing. It was getting to be too much. On December 29th, Anna went out with Alyssa Curry, and she broke down. This strong Serbian woman who was supposed to be having a fun night out with a girlfriend, going to dance karaoke, instead broke down. Anna told Alyssa that she had told the defendant that he needed to take responsibility for the federal case, go to prison. She wanted the children with her in D.C., and she and the defendant had not been intimate close to a year. In Anna's mind, the marriage was broken. Anna even questioned if she could just take the children because she had already established a separate household. She said that she was falling out of love with the defendant. And at home in Cohasset, what was the defendant doing? He was looking up the Mazda building and the FBI raid on the Crossing building. Looking up something that had happened in the spring of 2022 when Anna first started working for Tishman's Fire. Interestingly, this was when the defendant brought up something he brought up in his interviews, when he lied about Anna having to leave early for a work emergency. He was planning the work emergency. The defendant was going to lose Anna, and when he lost Anna, he would probably lose his freedom. Anna would have a house in D.C. and a nice job, and he would likely go to jail. So the defendant pretended. He lulled Anna into thinking that everything was okay. He joked with her about a Porsche. He didn't want her to realize that he was aware of the relationship with Will or her ability to leave him. He wasn't going to let Anna know that she wasn't safe. On December 31st of 2022, the defendant claimed that he could not find his phone. Why is that important? phone allowed the defendant to be unavailable for 2 days. The mislaid phone allowed him to carry out his plan uninterrupted. And the mislaid phone allowed him to show the police when he eventually reports Anna as a missing person and not have the police question why he didn't contact Anna earlier. The evidence shows that the defendant was methodical. Just look at how he shopped at Lowe's with a list. He planned it with precision. So Jem Lulu came over for dinner on New Year's Eve, and the defendant told Jem that his phone was lost and it was free. Anna was texting throughout the night, including with Will Bastow. This is now the third holiday where Anna was concentrating on the other man in her life. When Jem left, Anna was alive. She was with the defendant, the man she was cheating on, the man she was telling to take responsibility for his actions, and the man who had her children. The defendant murdered Anna that morning in their Cohasset home. And this is what the internet history shows. His internet history, written words. He was looking at best way to dispose of a body. Better to throw away crime scene clothes or wash them. Crime scene. Can you be charged with murder without a body? Anna was dead. The defendant killed her, and he began researching how to get her money, how to inherit, how to get away with the crime. And he might have gotten away with it, but he didn't know that his MacBook was syncing with his son's iPad, the same Apple ID. His demeanor changed during the interview on January 8th when the police mentioned the searches on the iPad. Not because the iPad involved his children. He had already involved the children in his lives. But because he knew he was caught. We know he had already involved the 6-year-old when he had the 6-year-old say that he saw his mother when she left the house on the morning of January 1st. The son could not have seen Anna leave the house. The defendant had already killed her. Listen to the recorded interviews. During the January 5th interview, the defendant spoke about what his son supposedly had seen. And the defendant involved the 4-year-old by saying that the 4-year-old hid his phone, hid the defendant's iPhone 13 mini. So, the defendant's phone made a reservation at Nightshade Noodle Bar for New Year's Day, after the defendant told Anna that they were going to have a special party. This is ironic because the defendant was very clear with police on January 7th that he and Anna had no plans for New Year's Day, and the defendant also knew that he would be violating the terms of his federal probation by going to a restaurant on New Year's Day. But let's look closely at Exhibit 170 about the Nightshade Noodle reservation, which was on the defendant's iPhone Mini 13, which the defense just said was deleted. And if you look on page 2, on the bottom of one of the bubbles, you will see that the message was deleted on January 1st at 7:59 and 5 seconds a.m. This happens to be one of the times that the iPhone Mini 13 was unlocked when it was supposed to be missing. The forensics show that the defendant's phone was unlocked 4 times and it was plugged in on January 1st. You heard testimony that the phone had a password of 197512. And in the January 4th recorded interview, you hear the oldest child needed help with his iPad password, which was 121212. The children didn't unlock the defendant's phone. The defendant blamed his misplaced phone on one of his children when he said that the children hid it. But it makes no sense that a 4-year-old somehow unlocked the defendant's phone and deleted that text reminder. Listen to the defendant's recorded interview. The deletion is made when the defendant is supposedly making French toast and playing with the kids. The defendant had access to his phone. Context. The defendant also had access to 2 other phones when his phone was supposedly lost. He had Anna's phone and he had the iPhone SE. And in the recorded interviews, the defendant told police that on New Year's Eve, Anna had an argument with a friend, and as a result, Anna put her phone upstairs in his bedroom.
You said she went and put her phone upstairs after that?
After that, she, let's say it's 10 or 15, and then she, I remember her putting her phone upstairs because then she came back down without it.
Was, Thomas came down at one point and hung out with you?
Yes. Yeah, exactly.
Was this before, during, or after Thomas was participating as well?
Oh, yeah, Thomas went to bed at, he went to bed and then he came over at like 9 or 10 or something. I think Anna took a bunch of photos. Jem and I don't have any because she didn't send them to us yet. But I think she sent one to Will Fasto. So that was when, that's when the photo was taken about. So it was maybe 10 o'clock or something like that.
You know where upstairs she put her phone at that point?
Yeah, on a bedstand.
That's not what Jem said. Jem said that Anna was using her phone all night. Melissa Kirby texted with Anna. The defendant was telling investigators a story about Anna's phone. How else do we know that the defendant intended to kill Anna and had a plan for doing so? Look at his internet history. Look at what he did. The defendant set up an area in his basement where he surrounded it with plastic sheeting, wore a tie-back suit, and dismembered his wife, the love of his life. Hacksaw, the best tool for dismembering a body. Then, the defendant got rid of Anna's body. He got rid of her belongings. He got rid of her clothes and bag that he told police that she had when she supposedly left on January 1st. He threw her in the garbage bags, tossed those garbage bags in different dumpsters, disposing of a body in the trash. Chatham West apartment rental, the Claremont apartment rental. And police confirm this with the location data from the SE phone and the iPhone 13 mini. The evidence shows that the defendant did this to hide the fact that he murdered Anna. He could not let Anna's body be found because Anna didn't die of natural causes. The defendant murdered Anna, and then he had to hide the evidence of his crime. Look at his mindset, look at his internet history. Want to get away with murder? Use a special detergent. Can you be charged with murder without a body? Best way to dispose of body parts after murder. When you deliberate, look through the binder of the MacBook Internet History. There are no searches of natural causes of death, sudden death, heart attack, aneurysm, stroke, or how to help your children when someone dies unexpectedly or goes missing. The defendant was not sad. Look at his demeanor in the surveillance videos. He's cool and calculating. He's calm. He had planned. On January 1st, he went to the Lowe's store an hour away, even though there were hardware stores approximately a mile from his house. And when he was in Lowe's on January 1st, he wore a mask and he wore gloves and he had a list of what he was shopping for. He was calm as he helped bag the purchases. A hacksaw, buckets. He used cash. Does this show confusion, panic, or fear? But he doesn't stop there. He went to CVS to buy hydrogen peroxide. And then he went to Stop and Shop to buy ammonia. No wonder the house was so clean. And on Monday, January 2nd, he went to Home Goods for rugs and handles. And then he went to Home Depot, where he had bought buckets with lids this time, baking soda, and a hatchet. And at some point that day, he got a call from his probation officer. And he lied, and he said that he was picking up his children. He was able to calmly speak with her. No panic. He had everything now that he needed to dismember the woman that he supposedly loved. And he started to take her body and to throw it into dumpsters, because he had to cover up the crime to get rid of the evidence of the murder. This was not a man in crisis. This was a man who on January 4th went to TJ Maxx to buy pants with a store exchange card. He was calm. But Alyssa Kirby texted him on January 4th asking about Anna, and so he called Tishman's Fire a few minutes later and started to pretend to look for her. He called Will Fastow, but he didn't leave a message. He called back later, and then he calmly left a voicemail. No panic. The defendant knew where Anna was. The defendant even texted Anna's sister in Canada and said that she was missing. He was methodical. Look at the text messages. And at 4:30 p.m. on January 4th, the defendant went to Lowe's to buy a trash can. Comfortable. Not panicked. The police would come to the house and talk about Anna. And the defendant had the house ready. The police think his wife is in D.C. He had his phone ready, and he sent text messages to Anna, even though he knew she would never see him. Despite everything that he had done, on January 2nd, the defendant wrote a text message to Anna. I still love you. Ha ha. Miss June. The defendant prevented anyone from ever finding Anna's body, and there was no autopsy. Dr. Atkinson told you that the medical examiner can't do an autopsy without a body, and all that remains of Anna are a few hairs, some blood, and a few things that belong there. A part of a necklace she often wore, her hunter boots, a black jacket, a purse, her COVID card, and a few other items in the dumpster in his mother's apartment complex. The defendant searched his MacBook for a murder conviction without a body. Please do not allow the defendant's self-serving act of dismembering and disposing of Anna's body to let him get away with this murder. At the start of this trial, we asked you to use your common sense. When you do that, when you analyze the evidence as you deliberate and continue to use your common sense, you will see that the evidence shows there is only one verdict. Find the defendant is guilty of the premeditated first-degree murder of Anna Walshe. Thank you.
We'll see counsel at the side of the bench. The jurors, you're my guidepost. Do you need a break to the bathroom? Okay. All for one, one for all. Give you a break to the bathroom. Let us know when you're ready to come back out. I'll be at your disposal.
All right, please. Jurors, follow me.
Give you a quick break as well, but something's been on my mind that I want to discuss now that the closing arguments are over. And that is, I had asked in connection, this relates to the sentencing, at least for the other two counts, and asked the Commonwealth to provide victim impact statements for any immediate family members of Anna Walsh that wish to provide information, and I haven't received that yet. And there might be a good reason for that. I had told you that I was putting off the sentencing until we had a verdict on the charge of murder. But now that it's a Friday, and I don't want this to linger over into the next week, has the Commonwealth heard back from the Department of Children and Family Services?
Your Honor, we've been in touch with them. They are working on their impact statement. They were hoping to have the impact statement impounded, and I can, as soon as we're done here with the charge, I will speak to the attorney that I've been dealing with. They've been working very hard on this. They're certainly worried about their privacy interests of the children and the social
I think there's a
work.
valid privacy interest of the children, and I'm highly likely to impound it, obviously, with the exception of counsel for both sides being able to see it so that they can make appropriate arguments as a result of the victim impact statement.
I think the department will be very happy to hear that. And they also, much of what they have is through a social worker privilege, so they're concerned about that as well. But as soon as we break, I will be happy to have that conversation.
Well, I'm happy to hear that there's forward progress because I guess I assumed, because I hadn't heard anything, that you were still not getting the answers to the questions you were asking.
No, quite the opposite. They've been working very hard on this.
All right, I appreciate that.
Thank you.
Anything anyone needs before I step off the bench briefly? Thank you.
All rise.
All right. Verdict watch, ladies and gentlemen. Verdict watch begins. We'll let long crime do the ticking counter because sometimes the counter goes completely off and I like to comment on it. This is going to be quick. I don't think they're going to deliberate very long. All right, what do you think, folks? Get your votes in. My name's Grant Smith Ellis. Thank you for watching. I'm going to be with you for a little bit of verdict watch. If it goes too long, I'm not going to be with you. All right, but I'm going to hang out with you. We can talk. If Bossy Texas Chick is here, maybe we can play some trivia. If Nancy is here, that is fun as well. I'm so sad we lost Allie, our dear friend, along the way because there was a comment error or there was some issue with her comments not showing up. She thought they were being removed. They weren't, and I feel terrible about that. In any event, we are on Verdict Watch, ladies and gentlemen. Now, Law and Crime hopefully will update their number. We can do a Verdict Watch clock. Hold on, let me do it for you. It's not the easiest thing in the world to add. It's a little bit annoying, but watch this. Ready? So I add that. All right. Then I click this. Oh, hi, Bossy Texas Chicken Cabela. What do we think? Want to play a little bit of trivia? I can't guarantee I'm going to be able to stay for that long. I'm a little bit tired. Let's see if we can do a countdown. All right, so we do clock. And we do... No, I said clock. All right, hold on. What if we do custom script? Okay, now what if we do clock? Okay, and then we click script, and then we click settings. Now, ready for this? Then I change it from a clock to a count, right? Is that how it works? I don't actually know how this works. No, timer. All right, start. Okay, update. And do I have to actually click play? Is this going to work? Why won't you count? Hold on. I haven't actually thought about this plan very much. Okay, what about now? Oh, come on now. What do I do to make it actually, like, count? Let's see. I am so baffled by this. How do I make it actually count? I just want to make it count things. Alright, hold on. Alright, now can't you count things? I'm so confused. I don't understand why it won't start counting. I just want it to be a loading clock. I'm so baffled by all of this. Yeah, I'm not very fired up today. It's true, Bossy Texas Chick. But also, sometimes I get so fired up, you're like, Graham, why are you so fired up? Well, because I'm a towel. Alright, let's see. Let's see. Why can't... No. 1924 days. Why would I want that? I am so baffled. That doesn't even make sense. Oh, it's counting down. No, I want it to count up. Don't you understand? No, I don't want a clock. I am so baffled by this, ladies and gentlemen. I just wanted it to be a counting timer that starts at 0 and runs. All right, let's try it now. Now, what if I do this and then hit refresh? Then will it count? Ladies and gentlemen, I have been defeated by the clock. Now, you might be saying to yourself, Towel, you can figure this out by just opening up the clock application on your computer. Yes, I can do that. How dare you say that I don't know how to make a script run a stopwatch? I'm a little towel. All right, so, oh, this was the verdict clock. Oh, goodness, look at this piece of history. I have not opened this, ladies and gentlemen, since we watched the Karen Reed trial. That was our verdict clock. 22 hours, 45 minutes, 55 seconds. Oh, the Karen Reed and John O'Keefe trial. We're officially refreshing our verdict clock. All right, there you go. Verdict watch in the Brian Walshe trial. We are on verdict watch. I believe they've been sent to deliberate, and so this is our verdict watch clock. Okay. There we go. Let's do that, and then let's just hold on here. Let me just be able to do this. All right, and then let me reduce that, and then let me reduce this. There we go. That is our verdict watch clock. Okay, so you have a clock, and then a verdict watch timer. Is that exactly accurate? No, it's probably like a minute off, but that's okay. We have our verdict watch up. We are on verdict watch. So, that's all we're really going to do. Maybe we will watch something. Yeah, I guess we can watch Towel ranting about something. I want to go get some lunch. I'm going to make chicken. So, your verdict watch clock is going to be up there, and then I'll get you a video to watch. What should we learn about today? What did I rant about recently? Let me see. How about I peruse through? What would you like to learn about today? Should we learn about the Michael Proctor filing? Should we learn about... Oh, 1.3 on the Towel X. Not bad, 1.3 thousand. Let's see what I want to have us learn about. A little towel. All right, here we go. Let's see here. Oh, I know what I have to do. Hold on. If Bunny and Nancy are still here, Oh, Bunny, wait. Before you go, I have a very special thing to show on the screen. I heard a rumor. This is just a rumor, but I heard a rumor that we have pictures, ladies and gentlemen, of two very special towel doggos. Now, one of them is named Abby, and one of them is named Kofi. Now, if your name is Abby and Kofi, I think you might be very thrilled to see you are about to go up on the TV. Now, the man on the TV definitely loves you all both very dearly, and clearly he is a fan of you as towels. However, this is your first time starring on TV. All right, so the man on the TV not only knows you, Abby and Kofi, you are going to go up on the TV. This is your moment. Yes, you have waited your entire towel doggy lives for this moment. Who's ready for this? Who's going to go up first? I think we are going to put Kofi up first. Who's ready for Kofi? Everyone get ready, ladies and gentlemen. This is a big moment for Kofi. This is his big screen debut, and then Abby will go up right after Kofi. All right, Kofi has arrived. Say hello to Kofi. Now, if you have watched Towel Stream before, you will know that we love dogs. What are you doing, Kofi? You are sideways. Kofi, what are you doing? All right. Kofi is playing a trick on us. Kofi is sideways. What are you doing, Kofi? Hold on now. Hold on. Watch this. Kofi's going to do a trick for us. Oh, no, Kofi, you're rotating the wrong way. This way, Kofi. No, Kofi, not that way. The other way. Oh, no. Now he's flipping around 17 times. All right, Kofi, hold on. Let's do this slowly, my dear friend. All right, slowly. Oh, goodness, you've become miniature Kofi. Kofi, what are you doing? Oh, goodness, ladies and gentlemen. Kofi is now shrunken. I'm so sorry I have shrunken Kofi to the size of a very small doggo. Kofi, please forgive me. I hope you can find it in your heart to do so. Now, let me make Kofi's debut not the size of a miniature doggo. All right, hold on one second. I have a plan. Yes, I have a towel plan. Didn't say it necessarily is a good plan. Oh, there's Kofi in all his glory, ladies and gentlemen. Now, you might be saying to yourself, that is a glorious doggo. Yes, it is. It is a glorious doggo named Kofi who is now right side up. Now, I have a companion for Kofi. Now, her name is Abby, and she is also a dog. Now, you might be saying to yourself, are you sure? Yes. How do I know Abby is a dog? That's Abby. She's right side up. She sleeps a lot, but she knows how to at least appear on the screen right side up. So, ladies and gentlemen, I present to you, in all of their glory, Kofi and Abby. Now, you might be saying, this is the greatest thing I've ever seen in my entire life. Abby's having a great day. She is drooling over Kofi. Now, you may be saying to yourself, those are two wonderful dogs. Yes, absolutely. And, here on Towel Stream, there's nothing better than facilitating two dogs finding out they are towels, and also two dogs figuring out that they clearly need to sit down and have a dinner together. Abby will try to make the meatballs. She'll eat most of them, and then Kofi can have the leftovers, and Abby Bunny Towel and Nancy Bunny Towel and I will laugh. See what I'm saying? Look at those two dogs. How can, even after a difficult trial and having to listen to difficult evidence, how can you not enjoy looking at Kofi and Abby Towel? Look at that, ladies and gentlemen. Absolutely adorable. Yes, no such thing as too much towel doggos. Oh, what a wonderful, wonderful day. I'm having a day. Abby's probably like, that's me. I'm on the TV. Yes, Abby, that is you. You are on the TV. All right, we're on Verdict Watch. We could have a verdict any minute, ladies and gentlemen. What am I going to play for you? Let's see here. What do we want to watch? What video do I have for us? Oh, was this the Cosgrove motion? Well, there's not a Turtle Boy hearing for a while, so we don't need to do that right now. What else do I have here? What's this one? That's another Cosgrove one. I don't know if I want to read that either and yell about that. Hold on. I'm looking for an interesting video. It really comes down to what I feel we should learn about. Kind of want to learn about the chart, you know what I'm saying? But we've watched the chart a few times. But the chart is important. chart is important. Maybe we will do the chart video in full. All right? That's what we'll do. While we're on verdict watch, although I don't know if it'll actually take that long, we'll watch the chart video in full. And if Judge comes back in the next 20 or 30 minutes, we'll cut back to that. Okay? So we're going to watch the chart video. It's an infamous video. It is probably one of the most infamous towel videos. It is full of knowledge. If you've been meaning to get caught up on the Sandra Birchmore case, the Matthew Farwell situation, how it all intertwines, ladies and gentlemen, I have a chart. Nancy said it's a match made in heaven. Well, you know what? In honor of Abby Towel and the wonderful coffee towel. Oh, wait, Judge is back. Hold on, I can't go anywhere. Judge is back.
I just so it's on the record, everybody saw the small edit I made to the verdict slip, and everyone's fine with it. Is that right? Everyone's nodding. Thank you.
All rise to the court, please. Jurors entering.
Okay, we're pausing our verdict watch clock. I guess they had one more thing to do before they started actual deliberations.
Court is back in session. You may be seated.
Welcome back, jurors. Jurors, I'm going to go through the remainder of the instructions, the final stage of this case before you will get the case to deliberate. The intent of the second part of the instructions is to give you some assistance in determining how you go about deciding whether the Commonwealth has proven each element of the indictment is true beyond a reasonable doubt. For the charge, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of the charge. You may not find the defendant guilty on the charge just because you think the defendant did something else that was wrong or improper. Your decision as to the charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip. When all 12 jurors agree on the verdict, the foreperson should check off that verdict and then sign and date the verdict slip in ink. In a little while, I'll go over that verdict slip a little bit more. For the charge, if you all agree that the Commonwealth has proved every element of murder beyond a reasonable doubt, then you should find that Mr. Walshe is guilty. On the other hand, if you all agree that the Commonwealth did not prove one or more of the elements of murder beyond a reasonable doubt, then your verdict must be not guilty. Let me talk about your role. Jurors, you have the most important role in this trial because you will decide who and what to believe and whether the Commonwealth has proved Mr. Walshe's guilt beyond a reasonable doubt. You must be completely fair and impartial and unbiased in your work as jurors. Do not let your emotions, any kind of prejudice, or your personal likes or dislikes influence you in any way. Consider the evidence calmly and carefully. Do not be influenced by the nature of the charge or the possible consequences of your verdict. And do not let your personal feelings about any person, criminal charge, or anything else influence your decision. All parties who come before the court stand as equals before the bar of justice. that a case is brought in the name of the Commonwealth does not entitle the prosecutor to any special consideration. Your verdict must be based on the law as I have given it to you, and on the evidence and the facts as you find, and nothing else. By contrast, my job as the judge is to impose sentence if the defendant is found guilty. Therefore, you are not to consider the sentencing consequences of your verdict at all. That's not your responsibility. So please put any issues about sentencing out of your mind. Let me next talk about evaluating the evidence. You must decide this case based only on the evidence that was presented at trial. You may not decide this case based on anything else. Do not consider anything you have read, heard, or seen outside of this courtroom. Those things are not evidence, and you may not base your verdict on guesswork, speculation, or suspicion. Let me talk to the important topic of the defendant not testifying. As you know, Mr. Walsh did not testify in this case. You may not hold that against him. Mr. Walsh has an absolute right not to testify because, as I've explained, he is presumed to be innocent and does not need to do anything to convince you that he is innocent. It does not matter why Mr. Walsh did not testify. It's not relevant to what you must decide, which is whether the Commonwealth has proved, based on the evidence presented at trial, that Mr. Walsh is guilty beyond a reasonable doubt. The fact that Mr. Walsh did not testify is not evidence. You may not consider it or even discuss it in deciding this case. Let me next talk about witness credibility. During this trial, you've heard from a variety of witnesses. With reference to any and all witnesses who have testified before you, you have wide latitude. As a jury, you can believe every single word that a witness says on the witness stand, or you can disbelieve every single word that a witness says on the witness stand. You may decide to accept parts of a witness's testimony and to reject other parts of his or her testimony. That's for you and you alone to decide. If there are any conflicts in the testimony, it is your function to resolve that conflict and to determine where the truth lies. In evaluating the credibility of witnesses, you may use various tools. You may consider the ability, the opportunity, and the reliability of the witness to see or hear something in the past, and then remember and later testify about it before you in this courtroom. You may consider the conduct of the witness, his or her manner of testifying before you, any inconsistency you may have found in the witness's testimony, any interest the witness may have in the outcome of the proceedings, any bias or prejudice or hostility the witness may have demonstrated while testifying before you, the level of accuracy of the witnesses testifying before you, and the reliability of the testimony as it developed before you. These are some of the tools that you have at your disposal to resolve disputed issues of fact in this case. There's one more point about witnesses that I'd like to specifically address, and that's expert witnesses. This term refers to witnesses who have specialized training or experience in a particular field, generally in cases that are tried in our courts, both civil and criminal. Witnesses may testify to facts that are within their own personal knowledge. That is, things they've personally seen or heard or felt. However, in a variety of cases, this one included, issues arise that are beyond the experience of laypersons. And in those types of cases, we allow a person with specialized training or experience, we call them expert witnesses, to testify, and to testify not only to the facts, but to their opinions, the reasons for his or her opinions, on issues that are within the witness's field of expertise and are relevant and material to the case. Because a particular witness has specialized training and experience in a field, doesn't put that witness on any higher level than any other witness. And you are to treat the expert witnesses just like you would treat any other witness. In other words, as with the other witnesses, it's completely up to you to decide whether you accept the testimony of the expert witnesses, including the opinions that those witnesses gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You are free to reject the testimony and opinion of such witness in whole or in part if you determine that the witness's opinion, not based on sufficient education and experience, or that the testimony of the witness was motivated by some bias or interest in the case. You must also, as has been explained, keep firmly in mind, jurors, that you alone decide the facts. If you conclude that an expert witness's opinion, not based on the facts as you find those facts to be, then you may reject the testimony and opinion of the expert in whole or in part. You must remember, jurors, that expert witnesses don't decide cases, juries do. In the last analysis, an expert witness is just like any other witness, in a sense that you alone make the judgment about how much credibility and weight give the expert's testimony and what conclusions you draw from that testimony. Let me next talk about graphic photographs. The Commonwealth has introduced certain photographs showing items taken from various trash bags retrieved from 300 Forest Street, Peabody, during the investigation of this case. You will have those photographs with you during your deliberations, as all the evidence will be with you during the deliberations. Some of those photos, as you've seen, are not pleasant. Indeed, some may be described as graphic. I instruct you that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by those photographs. Related to this, sometimes evidence is presented that produces in jurors an emotional response. For example, it is natural and understandable to feel sympathy and empathy when you hear or see testimony that suggests what might have occurred to Anna Walsh's body after her death. But as jurors who have taken an oath to follow the law, I instruct you that you must separate any emotional response or reaction on your part from the informational value and weight of the evidence. You must not be influenced in any way by the nature of some of the testimony and video evidence. You must find the facts in this case based only on the evidence. You can't find facts or base your decision, again, on sympathy, anger, passion, or prejudice, or pity for or against either side in this case. Rather, again, jurors, your verdict must be based solely on the evidence in this case and my instructions on the law. So what is evidence? I told you earlier that repeatedly that you must decide this case based only on the evidence presented at trial. The evidence consists of the testimony of the witnesses, as you recall it, the things that were marked as exhibits, and the stipulations, or I told you those agreements, of the parties, which I read into evidence. You will have the exhibits with you in the jury room. Things that were marked for identification aren't exhibits, so don't be looking for those, because they're not exhibits, and you won't be able to consider them. Other things that are not evidence and you may not consider when deciding this case are as follows. The fact that the defendant had been indicted and charged with a crime, not evidence. Questions that the lawyer asked of a witness are not evidence. Only the answers given are evidence. For example, if a lawyer asked, wasn't it raining outside? And the witness answered no, or said, well, it was cloudy. The question is not evidence that it was raining. If a lawyer asked a question and I sustained an objection and therefore the witness didn't answer it, then neither the question nor the fact that the witness did not answer is evidence. If I struck or told you to disregard any part or all of an answer by a witness, then the part of the testimony that I struck, not evidence. You may not consider it. Anything that you may have seen or heard when the court wasn't in session isn't evidence. The opening statements and closing arguments of the lawyers are not evidence. And if your memory of the testimony differs from what the attorney said in their closing arguments, you should rely on your memory. Any notes that you've taken, they're not evidence, but you may use your notes to refresh your memory of the evidence. As you know, evidence can come in many forms. It can be testimony about what someone saw or heard or smelled or felt. It can be someone's opinion, and it can be an exhibit. Whether the evidence is direct or circumstantial, sometimes we call that indirect, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence in the case. Some evidence proves a fact directly. For example, if a witness testifies that she saw and felt it raining outside before she came into the courthouse, then that's direct evidence it was raining. Some evidence proves a fact indirectly, circumstantially. For example, let's say a witness testifies that he saw someone come into the courthouse wearing a wet raincoat and shaking water off of an umbrella. That's indirect evidence that, if you believe it, might lead you to conclude that it was raining outside, even though the witness did not see, hear, or feel the rain. This kind of indirect evidence does not directly prove something is true, but it is evidence from which you could logically conclude that it is. We call this drawing an inference. We all draw inferences every day. We take some known information, we apply our intelligence and common sense, then we reach a conclusion. But inferences must be based on facts. They can't just be guesses that you when you're not sure about something. Sometimes you can draw more than one inference. Also, you may draw an inference even if it is not necessary or inescapable, so long as it's reasonable and warranted by the evidence. You have to decide, jurors, which inferences are reasonable, and decide which seems more reasonable to you. It makes no difference whether evidence is direct or indirect. Commonwealth may be able to prove a criminal charge with direct evidence, indirect or circumstantial evidence, or a combination of both. Let me next talk about credibility. An important part of your job as jurors is to decide who and what to believe. You may believe everything a witness says, part of it or none of it. Sometimes people do not tell the truth. You must decide whether a witness was being truthful or deliberately lying. If you conclude that a witness lied to you about something, then of course, you should not believe that part of the testimony. Sometimes people make an honest mistake. You must also decide whether a witness testified accurately or whether the witness may have gotten something wrong without meaning to do so. A witness may recall seeing or hearing something but actually be mistaken. For example, the witness might not have paid close attention or might have misunderstood what was happening. Or a witness's memory of what happened could be incorrect. If you conclude that a witness tried to be truthful but that some part of that person's testimony was inaccurate, then you should not consider the inaccurate portion. How do you decide whether you believe a particular statement by a particular witness? Well, ask yourself, did the testimony seem reasonable or probable? Did the witness have a good chance to observe what happened? How much attention did the witness pay? Did the witness's memory seem accurate? Was the witness's testimony consistent with other evidence, or instead contradicted by other evidence? How did the witness behave and answer questions while on the witness stand? Did the witness have any motive for testifying in a certain way, or have any other bias that may have influenced the witness's testimony? You should evaluate the testimony of a police officer or someone else who works for a law enforcement agency in the same way as you would evaluate anyone else's testimony. You must not automatically believe or automatically disbelieve a witness just because a person is a police officer. Moving next to the importance or significance of evidence. It's up to you, jurors, to decide how important each part of the evidence is, whether it's testimony by a witness or an exhibit, whether evidence is direct or indirect. You should give each piece of evidence whatever significance you think it deserves. You're not required to believe something simply because it appears in an exhibit. It's up to you to decide how important any exhibit is. You do not have to treat testimony by a witness as more or less significant than the exhibits. You may find that a witness's testimony is very important, or that an exhibit is more important. That is up to you. Next, I want to talk about the alleged victim's state of mind. You heard evidence of statements Anna Walshe allegedly made to William Fasto, Jem Lutlu, and Alyssa Kirby. Those statements are admissible for the limited purpose of establishing Anna Walsh's state of mind, as may be relevant to the defendant's motive or intent to kill. Those statements cannot be considered as proof of the criminal acts charged or as proof that the defendant had a bad character or a propensity to commit any criminal offense. Let me next talk about motive. First, motive is not an element of the offense of murder, and the Commonwealth is not required to prove or show motive. Evidence of motive can be relevant to the issue of intent. Second, an absence of evidence of motive may tend to raise a reasonable doubt. Third, even a total lack of evidence of motive would not necessarily raise a reasonable doubt as to the guilt of a defendant, so long as there is other reasonable doubt. Let me now move to the area of something called consciousness of guilt. I spoke earlier about inferences and the drawing of inferences from indirect or circumstantial evidence. At this point, I want to talk about a particular type of inference based on a legal doctrine called consciousness of guilt. In the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest and that he may have taken steps to conceal Anna Walsh's body after her death. I want to stress to you that I'm not suggesting that he did so, or that you should find that he did so, but only pointing out that there was evidence to that effect. It's up to you to decide what evidence to accept or reject, and what facts to find from the evidence. I point to that evidence to illustrate the legal point involved. If you find from the evidence that the Commonwealth has proved that the defendant provided false information to the police and or took steps to conceal the body of Anna Walshe after her death, then you are permitted to consider whether such actions indicate feelings of guilt by the defendant, and whether in turn such feelings of guilt might tend to show actual guilt on the charge. You are not required to draw such inferences, and you should exercise great caution and do not do so unless they appear to be reasonable in light of all the circumstances in this case. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, or such feelings are sometimes found in innocent people. If you decide that such inferences are reasonable, it's up to you to say how much importance to give them. But remember that such evidence is never enough by itself to convict a person of a You may not find a defendant guilty based upon such evidence alone, but you may consider it along with all of the other evidence in this case. Next, I want to speak to impeachment by the defendant's prior or subsequent bad acts. The only charge the defendant is now facing is the charge of murder. You have heard mention of other acts allegedly done by the defendant, namely, that he was charged in 2018 and sentenced in 2024 in a federal case involving art fraud, and or that he lied to the police, and or that he disposed of the body of Anna Walsh, and or that he lied to his federal probation officer. You may not take the defendant's prior or subsequent acts as a substitute for proof that he committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. You may consider this evidence solely on the limited purpose of the motive, state of mind, intent, plan, or absence of mistake or accident on the part of the defendant. You may not consider this evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant committed these other bad acts, that he must have also committed murder. It would be extremely unfair to consider this evidence for those purposes. Moving next to your notes. Many of you have taken notes during this trial. Your notes may help you remember the evidence, especially the testimony, but of course they're not an actual transcript or official recording of what was said. So use your notes only to help you remember what you saw and heard in the trial. Whether you took notes or you did not, you must rely on your own memory of what the witnesses told you. After the trial is over and you've returned your unanimous verdict, the court officer will collect your notes and I will order that they be destroyed. During the trial, the lawyers occasionally, as was appropriate, objected to questions posed by the witnesses. They may have asked to strike something or, in essence, erase something you saw or heard. When a lawyer believes that something would violate those rules of evidence we've talked about from the beginning, that's the only way they have to let me know. And so don't hold it any against the lawyers that they made such objections. It's part of their job. I want to next turn to fairness. Each of you has taken an oath and promised to be fair, and I'm sure you want to be fair, but that's not always easy. Part of being fair is being willing to examine your decision-making process to be sure that you base your decisions as jurors only on the evidence and the law. One difficulty comes from our own built-in expectations and assumptions, and they exist even if we're not aware of them. We all have them simply because we're human beings. They affect our actions and decisions without us even realizing it. As a judge, I have the same problem as everyone else. So let me share a few strategies that I found to be useful. These strategies will help you make sure that you decide this case based, again, only on a careful examination of the evidence and on the legal rules that I'm teaching to you. First, slow down. Do not rush to a decision. Take time to consider all of the evidence. Quick decisions are more likely to reflect stereotypes or assumptions about people that we might not even be aware of. Second, as you start to draw conclusions, consider not only the evidence that supports your conclusions, but also think carefully about any evidence that undermines or weakens those conclusions. Third, as you think about the people involved in this case, ask yourself, would my decision be different if the people were different? For example, what if the people involved were from different social or economic groups, or different ages, genders, gender identities, or sexual orientations, or came from a different racial or ethnic background? Fourth, listen to each other. Other jurors may have different points of view. If so, they may help you make sure you're focusing on the facts. Of course, other jurors could be influenced by their own unstated assumptions. So don't hesitate to share your views. You should participate actively particularly if you think other jurors are overlooking or undervaluing evidence that you think is important. When you explain your thoughts to your fellow jurors, you help everyone focus on the evidence. If you do these things, then you'll play your part in reaching a decision that's as fair as is humanly possible, and that's your obligation as jurors. Now I'm going to move to giving you some instructions about how to conduct your deliberations. Privacy. The first point you need to know is that you must keep your deliberations secret. You should not tell anyone outside of the courtroom, not even me, anything about your deliberations. For example, please do not tell me or anyone else the results of any votes that you may have taken before you all agree on a unanimous verdict. You must not tell anyone about how your discussions are going or what other jurors are saying. If you need to communicate with me before you reach a unanimous verdict, you should send me a written note and a form that you all agree on. The court officers have one. It must be signed by your foreperson, and I will discuss your note with the lawyers, and then I will either send you a response in writing, more likely, or bring you into the courtroom, less likely, and respond to you in person. If you do send me a note, do not mention any votes that you have taken or anything else about your deliberations. Do not talk about this case unless all of you are present and no one else is in the room. If one of you needs to leave, even for a moment, the rest of you should stop deliberating until that juror returns. That includes the bathroom breaks, because I know that's right inside your spot. If we break for the day without you reaching a unanimous verdict, you must not communicate with the other jurors about this case until the next day, only after we gather in the courtroom, and I ask you to resume your deliberations. As you work to decide this case and until I accept your verdict, you must not communicate with anyone else about the case except each other. And you must not do any kind of research about this case. You may not do so in any way, including with electronic devices, a cell phone, or a tablet. This also will apply to the alternate jurors. We'll talk about those alternate jurors. The law permits only 12 jurors to participate in deciding a criminal case. There are 16 of you here. So in a few moments, our clerk is going to randomly select 4 of you to be what we call alternate jurors. The other 12 of you will work together to decide this case. We chose 16 of you originally in the case, just in case one or more of you got sick or needed or had some other unexpected emergency. If you are chosen as an alternate, your continuing service is still very important, and you must comply with all of the rules that I placed on you. The alternate jurors will stay in another room, and you can't have your own private deliberation. You can't discuss the case with each other or with anyone else for obvious reasons. If we lose a deliberating juror in the group of 12 because of some personal emergency or sickness, then I will send one of the alternates into the jury room. If this happens, the deliberating jury will have to restart its discussions from the beginning. One of you is going to serve as the foreperson of this jury, and we will discuss who that foreperson is going to be in a moment. Foreperson will make sure that each of you has the chance to speak and that the other jurors listen to you respectfully. But the foreperson's opinion about the case is no more important than the opinion of all of the other jurors. Once you agree on a verdict, the foreperson will fill out the verdict slip and will report your verdict in court. I want to next talk about making decisions as a group. When you work together as a jury, you will be making decisions as a group. This kind of decision making is very valuable. Why do I say that? When a jury hears and sees evidence, each juror acts as a safeguard for the others. For example, someone else may recall evidence that you missed. And each of you will have insights that will help the other jurors make sense of the evidence and reach a verdict. No member of the jury is more or less qualified than any other juror to decide who and what to believe. You all heard the same evidence, listened to the same witnesses, and looked at the same exhibits. And you have all taken the same oath, promising that you will, well and truly, try the issues between the Commonwealth and the defendant according to the evidence and the law. So, you are all equally qualified to reach a verdict. I have a few more suggestions that might help you work better together. First, you should discuss and analyze the evidence before you take any votes about a verdict. Voting first could keep you from discussing the issues and hearing other people's perspectives before making up your own mind. Second, I encourage you to discuss not only the evidence you think supports your view of the case, but also what evidence you think might lead you to make a different decision. Third, as jurors, and as the other jurors talk about the evidence that they found important, listen. In order for this process to work fairly, each of you should hear every other juror's insights and ideas. Please be open to them, since they might influence your own thinking. Fourth, don't be shy. As in any group, some of you may feel more comfortable than others sharing your thoughts, but you must have the benefit of everyone's input to help you reach a just verdict. For example, you may be the only one that remembers a particular piece of evidence or has a particular point of view. The more points of view that you all hear, the more effective your deliberations will be. Fifth, don't be afraid to change your mind if the discussion persuades you that you should. But you should not accept a decision just because other jurors think it's the right one. In the end, you should vote based on your own assessment of the evidence, regardless of how other jurors have voted. Ultimately, jurors, each of you must decide this case for yourselves. One last pause to consult with the attorneys.
I repeat, one last sidebar. Ladies and gentlemen, one final sidebar. Jurors about to go to their deliberations. Our verdict clock will start. And then we'll watch a video about Tal's chart during lunch. I'm thrilled to have you all with us today. Hi, Bella. Hi, Nancy. Hi, Abby. I am a little Tal. Sidebar. I repeat, ladies and gentlemen, one final sidebar for the condemned man. If we were in Texas, I think he'd probably be facing the death penalty. We are in liberal Massachusetts. This man is never getting out of jail. A lot of you think 2 to 3 hours for deliberations. That would make us done today. No verdicts between 1 and 2, though.
So I talked to you about a 4-person, and I talked to you about what we call reducing the jury. That is, reducing you down from 16 to 12. I'm appointing juror number 138 in seat number 6 as the 4-person of this jury. Our clerk is now going to randomly select 4 of you from among all the jurors except the 4-person to serve as alternate jurors. So what's physically happening is juror number in seat number 6, juror number 138's number is coming out of the thank you, Madam Clerk.
Your Honor, numbers 1 through 16, with the exception of number 6 of this. Your Honor, our first alternate is juror in seat number 12.
Then no booking, just follow me.
Our next alternate is juror in seat number 5. Juror in seat 15. And our last alternate, Your Honor, is juror in seat number 11.
One last substantive thing that I want to go over with you jurors before I really get into the finally the concluding remarks, and that is I said to you earlier in this second part of the charge that I would go over the verdict slip. There is a verdict slip, and I know that you can't, unless you have stellar vision, you can't see it from where you are, but you can get the layout of it. I'll read it to you. The verdict slip reads, count 001, on or about January 1st, 2023. And it puts the charge, murder in the first degree with deliberate premeditation. That is the charge. We, the jury, find the defendant, and there are 3 options. Not guilty, guilty as charged, murder in the first degree, guilty of murder in the second degree. And there's a place to sign it and date it. And again, the foreperson in pen, not pencil. This time, Madam Clerk, I'm going to ask you to swear in 4 officers.
Please do solemnly swear or affirm that you will take charge of this jury, keep them in some secluded places where they be. You shall not speak to them or suffer anyone else to speak to them except by order of the court or ask that they be read. Say no.
So now the deliberating jurors, the 12 of you, are going to go instruct with private discussions. Have confidence in what you are about to do. By serving on this jury, you carry out a long and proud tradition of citizens of the Commonwealth of Massachusetts serving on jury trials and deciding criminal cases. If you are honest, thoughtful, and fair, you will be able to reach a fair and just verdict, dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in the courtroom during this trial. All we expect from you jurors is that you decide this case with integrity and principle. And with that, I'll ask you and let you go back to the deliberation room to begin your work. Thank you very much.
Court, all right, please. Take your notebooks with you and follow me.
We are on verdict watch.
You may see some small edits that I made to the instruction, and I'll need those now, take the draft off, make sure the numbers are all right for the index that goes down with them. Anything else that the parties need to bring to my attention before I do that?
We received materials to secure those items, and we're going to work
Oh,
on
can I
that.
see that? Are they in secured yet, or you're going to secure?
We're going to secure them. I haven't had the opportunity yet.
All right, let Madam Clerk know when that's done, because I do want to take a look at those before they go in, and of course our court staff as well, court officers might want to take a look at those to make sure that they're comfortable with what's going on in the verdict.
And we thought would cut up pieces of parchment paper for the jurors if they need to examine anything that they can place on their table.
You have a roll, they can do it themselves.
We have a roll. We can give them scissors if you want.
Well, cut them
I think that's why I put that out there.
off. All right.
Thank you.
I think you're pretty familiar that I have a 10-minute rule, which means at all times, Madam Clerk, the whole meeting should be able to return to the court within 10 minutes. All right. I won't take it further between the hours of 1 and 2 on any day. You get an opportunity to attend to your other work.
Thank you, Ron.
All rise.
All right, we are on Verdict Watch. Ladies and gentlemen, my name is Grant Spendelis, and we are going to go on Verdict Watch. Before we do, though, before I go eat something, ladies and gentlemen, that is Abby. That is Kofi. Ladies and gentlemen, it is a match made in doggy heaven. I know Bunny Towel and Kofi right now are losing their ever-loving towel minds. I know Abby is probably sleeping, but she woke up from her nap because she's on the TV. Bossy Texas chick, don't tell Bella, okay? But look at that. It's Abby and Kofi, a match made in towel heaven. Oh, goodness. We've never seen anything like it on Towel Stream. Well, we've had doggos before, but now we're towel doggo matchmaking, and I think we've figured it out. Abby on the right, Abby's adorable, she's napping, and then Kofi on the left, Kofi's a dog. How you doing, Kofi? That's you on the TV. Are you thrilled? That's you. I'm serious. That's actually you. You must be very baffled right now, both Kofi and Abby, but it's okay. It's all right. We'll figure it out. Oh, what a wonderful moment for Kofi and Abby. All right, so ladies and gentlemen, we will keep. How about this? We'll put Kofi and Abby behind Towel. All right, watch this. Watch this genius plan. I was born a towel, and I will continue to be a towel. It's love at first bark. That's hilarious. All right, watch this. They get the position of honor. Look at that, ladies and gentlemen. Abby and Kofi get to hang out with Towel right up there in the corner. How great is that? They need a wedding date. Kofi is beautiful, says Nancy. Abby is also beautiful. Everyone is having a great towel day. All right, look at that. We are on Verdict Watch. I'm going to go eat something. Towel dogs are finding love. It's a beautiful day. It is a great day to be a towel. We're only 400 views on Twitter, 400 viewers behind Ted Daniel and Boston 25. You want to see how we're doing, ladies and gentlemen? I'll show you right now. 1 second. There we go. Look at that. Look how we're doing, ladies and gentlemen. I'll move this into the background in a second. Look at that. Oh, yes, ladies and gentlemen. Towel has 2.7 thousand. We are right behind Boston 25 at 3.1. Towel has 2.7. Defense Diaries 2.4. Brother Counsel 1K. Young Jerk 791. Jennifer Coffindaffer 600. Surviving the Survivor 553. Yellow Cottage Tales 417. Yes, ladies and gentlemen, it is a beautiful day to be a towel. Bossy Texas Chick, you got to make sure you're live because Abby and Kofi were definitely on the screen. It will be a big diamond-shaped bone. Love it. All right, we're going to watch this video about the chart. Everybody get comfortable. Enjoy your day. Brian Walsh case is on Verdict Watch. Let me move this to the background so you can see the Verdict Watch. Hold on 1 second. All right, there you go. Verdict Watch up in the top right, and the chart explained. All right, have fun watching. I'm eating my chicken and following along. You're all wonderful towels. But I did want to take a few minutes to talk about some questions that people have asked about what is the nature of the ongoing overlapping concentric social circles that could be related to the federal probes out of the Moakley Courthouse in Boston. Now, people, as we know, have heard that the federal grand juror leaker, Jessica Leslie, on Monday pled guilty to leaking about at least 4 different active federal investigations. We know that those 4 active federal investigations spanned, or at least the leak spanned August of 2022 through March of 2024. Now, I have a big chart up on the screen, which those faces and names will come to have meaning as we go through this. But to begin, let's talk about how August of 2022 is the exact month, and there's Jessica Leslie's information that she pled to up on the screen, public court document from Pacer. And of course, there is the document showing Alan Jackson joined Karen Reed's legal team in that same month. Now, why does this play into the larger picture? Well, Jessica Leslie was leaking during a time when the U.S. Attorney's Office in Boston, under then U.S. Attorney Rachel Rollins, and then her predecessor, the person who took office after her, Josh Levy, were, according to reports, weaponizing the U.S. Attorney's Office as an arm of certain factions of the Democratic Party within Massachusetts to leak derogatory information about targets of their ire in order to manipulate the political process. This started between May and September of 2022, when Rachel Rollins attempted to weaponize the U.S. Attorney's Office in order to interfere in the Suffolk District Attorney's Office primary between Kevin Hayden and Ricardo Arroyo. Ricardo Arroyo was then an ally of Rachel Rollins, according to a DOJ OIG report released in May of 2023 that led to Rollins resigning her post. And Arroyo was someone who was going to keep up Rollins' hyper soft on crime, extra liberal prosecution approach, and Rollins thought it was important to cement this legacy. Kevin Hayden was a moderate Democrat appointed to fill the vacancy created in Rollins' position when she left the Suffolk DA to become the U.S. Attorney in Boston, which, by the way, I'm pretty sure was a result of Rollins getting a favor from the Biden White House and Senator Ed Markey, because Rollins and Aidan Turtleboy Kearney worked together in 2020, I believe it was, in that Senate primary in Massachusetts between Joe Kennedy Jr. and Ed Markey. Okay, in order to send a Republican operative named Rayla Campbell to Joe Kennedy Jr. events in order to sabotage the race and allow Markey to win. Now, you might say, why would the Biden White House care in 2020 about a Senate race between Joe Kennedy Jr. and Ed Markey? And why would Rachel Rollins be working with Turtleboy to send a Republican operative to Joe Kennedy Jr. events? Well, think about it. It was 2020. Joe Kennedy Jr., I think, was representing the 4th District in the Federal House of Representatives at that time, which is the seat now occupied by Jake Auchinclosh. Okay, JFK in the 50s went from the old 10th District in Massachusetts. His campaign headquarters was down near Lake Street in Brighton and Oak Square, near BC. Tell loves BC. Ladies and gentlemen, JFK went from the 10th District in the Federal House of Reps to that Senate seat, the junior Senate seat in Massachusetts. His desk in the Senate is very famous. People write their names in it when they're in that seat, in the desk, because he did, okay? And then he ran for president, because you get foreign policy experience in the Senate, traditionally, okay? Domestic experience in the House, foreign policy experience in the Senate, run for president. That's especially the Kennedy route. Okay, that's how JFK did it. If you're the Biden White House and you're looking forward to 2024, you don't know this chaos is going to happen with Biden not running and Kamala running. You don't know that's going to happen. So you're thinking about, especially the political machine around Biden, can you insulate Biden from a primary challenge? Well, Rachel Rollins becomes very helpful in that regard if she used Turtleboy to influence that primary, does she not? Does that explain why Rachel Rollins got appointed to the position of U.S. Attorney? Does that explain why part of the reason Rachel Rollins got forced out of office, according to the DOJ OIG, was that Rollins used an official government vehicle and a driver who worked for her at the U.S. Attorney's office to go to a fundraiser in Andover for Dr. Jill Biden? I don't know, but it's certainly a question worth asking. But so we have to remember, there's the political weaponization of the U.S. Attorney's Office. Potentially, that was because Rollins got into the position because of political reasons, okay? Then you have the May through September 2022 influence in the Arroyo primary. Then, okay, you have Rollins in 2023 and Levy leaking about the ongoing situation related to State Treasurer Deb Goldberg and Shannon O'Brien, the former chair of the Cannabis Control Commission, after O'Brien stumbled onto a bunch of internal issues in the commission related to nepotism, misconduct, abuse, cover-ups, etc. And O'Brien tried to deal with it, but got taken out by a collective of staff who were, interestingly enough, connected to Rachel Rollins, because Sean Collins, the former executive director of the Cannabis Control Commission, was very close friends. A deputy treasurer, in fact, before he went to the Cannabis Control Commission with Deb Goldberg, who Deb Goldberg, Rachel Rollins, who was appointed to at least one state board by Goldberg during this time in question. Now, you may have seen my reporting in recent weeks that, according to my sources, Collins tried to unilaterally appoint Rachel Rollins to the position of CCC Chief of Investigations and Enforcement before Rollins became Suffolk DA. Okay, that shows how tight this network was. So you have leaks about the Arroyo and Hayden primary, weaponized leaks by the U.S. Attorney's Office by the Liberals. Okay, then you have weaponized leaks about the Shannon O'Brien and Deb Goldberg case by the Liberals to help Deb Goldberg and Sean Collins and Deb in that group, and to hurt Shannon O'Brien. Okay, so targeting Kevin Hayden, targeting Shannon O'Brien. These are kind of like not necessarily people willing to go along to get along with the Democratic machine. You seen a pattern? Okay. And then we get Josh Levy having a meeting in November of 2022, right as, by the way, you know who took out Rachel Rollins from her position? You know who cooperated with the OIG investigation? You can read the report from May of 2023. Rollins' first assistant, which was Josh Levy, the then head of the criminal division, still head, Bill Abley of the criminal division in Boston, Dustin Chow, the then head of the public corruption unit. I think he's gone. I'm not positive. And then the then executive assistant or executive officer and press officer who's been there for like 20 years. I'm pretty sure I know who it is. That person's a boss. Okay. So these people took out Rachel Rollins because Rollins weaponized the U.S. Attorney's Office. Okay. They know she did. They reported her. I read the report. They all know what she did in the Hayden and Arroyo primary. Then jump in, okay, to November of 2022. That's when the DOJ OIG is moving. Okay. They're about to interview Rollins in November and December of 2023. They actually make a criminal referral because Rollins lied to them about the way she went about leaking a recusal letter to Sean Philip Cotter, who was then with the Herald. It was bad. Okay. Rollins was going to get criminally prosecuted, but I think for her friends in the DOJ hierarchy up near the White House who potentially protected her. Okay. That was the criminal referral was made in January of 2023 and was denied by the then very liberal DOJ hierarchy in Washington. Okay. So the DOJ OIG, as they're moving to interview Rollins in November 2022 and December of 2022, she knows she's on her way out. Okay, they got her. Levy then really starts running the office. We know this because he's the one who takes over when Rollins formally resigns in May of 2023, but she was already on her way out, starting as early as September. They caught her. They took her out right away. Rightfully so with the DOJ OIG because she was weaponizing the office. But then the issue is, so Rollins, when she became Suffolk County District Attorney, had David Yannetti on her transition team. And Alan Jackson in August of 2022, as we talked about Jessica Leslie, I think started to get leaks from that federal grand jury. But you might be saying to yourself, wait a minute, there was no federal investigation into the death of John O'Keefe in 2022. That didn't really start up until in August of 2022. That didn't really start up till November of 2022. It didn't really heat up until the summer of 2023, and it didn't really close until February of 2024. So what could Jessica Leslie have leaked about potentially to Alan Jackson in August of 2022 as he was beginning to map out his defense strategy for the Karen Reed case? Well, I'll tell you, folks, and you got to remember this because this is the key to it all. I think that Sandra Birchmore, who was a young woman in Canton, Massachusetts, who was murdered on February 1st, 2021, according to allegations by the federal government, by Matthew Farwell, a former Stoughton police officer, okay, at 9:23 p.m. or so. That murder, okay, was touched on a ring of cops, okay, who went from Stoughton, Uri Buchanan and John Fanning in particular, to the Massachusetts State Police Unit, detailed to the Norfolk County District Attorney's Office, the same unit that investigated Karen Reed for John O'Keefe's death. Now, this is where this really starts to get a little spooky. I have reason to believe that Ken Berkowitz, the former chief of the Canton Police Department, reported to the FBI sometime in 2022, probably before May of 2022, that the Stoughton Police and the Massachusetts State Police Unit detailed to the Norfolk DA covered up Sandra Birchmore's murder. Now, the reason I think this is that the Canton Police Department on February 4th, 2021, they were the ones who initially processed the crime scene at Sandra's apartment where she was found murdered. They got evidence, the Canton Police, they're good people. I believe they're really good people. They got evidence right away that Matthew Farwell was on video at 9:23 p.m. on February 1st, 2021, murdering Sandra Birchmore. Like, he went into her unit and then he went out. They got it. Then they went to the maintenance worker, and the maintenance worker told the Canton Police that was the same man on video that had moved Sandra into her apartment, Matthew Farwell. Then the Canton Police went to Sandra's school where she worked as a teacher's aide, okay? And they got interviews with her coworkers who provided them evidence that Farwell was saying to people that if Sandra refused to if Sandra wouldn't get rid of the baby, the unborn baby she had, if she went through with carrying the baby to term, she wouldn't get rid of, in his words, the baby, then Farwell would, quote, take care of the problem himself, okay? Now, Farwell was under the impression that Sandra Birchmore was pregnant with his unborn child. We've come to find out in recent months, according to reports, that was not true. The DNA testing has confirmed Farwell was not the father of the child. Now, why does this tie in? Well, Sandra was being abused since she was a child, something the Canton Police also found out on February 4th, 2021, and included in their report, according to an audit of the Canton Police Department done in the April of 2025 and presented in public, or concluded in April 2025 and presented in public around then, starting on page 99. Now, if you go to that Canton Police Department audit report, you will find that Sandra Birchmore, the Canton Police also knew that Sandra Birchmore was being abused as a child by Matthew Farwell. Now, the Canton Police took all of this information, okay, and handed it over to the Massachusetts State Police. Now, the person who wrote the report for the Massachusetts State Police exonerating Matthew Farwell was John Fanning, who used to work in Stoughton as a cop. The unit commander at that time was Brian Tully of the State Police Unit. Remember that name. Now, Yuri Buchanan also used to work in Stoughton, and I have sources who indicate that Yuri and John Fanning used to go around to high school parties when they were perhaps older than in high school. Okay. And we also have to remember that Matthew Farwell is linked to Billy Farwell, William Farwell, and Robert Devine, and they're both linked to Sandra Birchmore. This is very clear evidence that there was a ring of cops, at least Robert Devine, William Farwell, and Matthew Farwell, abusing children in Stoughton. Perhaps it may have also included some other people on that list, and that breaks my heart. Okay? But people shouldn't do this, especially in positions of public trust. And it's possible, it's more than possible, that Sandra Birchmore was being abused. We cannot frame this as she was sleeping with. She was being abused by these people in positions of trust. She was hunted. She was found by these police officers in the cadet program when she was an underage child, like 13 years old. And there was a ring of cops, clearly, who were in Sandra's life. And you have to wonder, and it's pretty clear, were there other girls too? Were they abusing other girls? Was Sandra not the only one? Was Sandra not only being abused by more than one cop? Was there a ring of cops abusing a ring of girls? Was this the Jeffrey Epstein on a small scale? Matthew Farwell, was he the Jeffrey Epstein of Canton and Stoughton, Massachusetts? So you have to imagine that if the DOJ and the FBI got a report from the chief of the Canton Police at the time, Kenny Berkowitz, that his officers turned this all over, and somehow the state police, who had the unit tied to the Norfolk DA, who had ties to Stoughton, two of them at least, and Farwell, and this ring of cops, exonerated Farwell. You don't think that might have led the DOJ to start a probe? And you don't think maybe impaneling that public corruption grand jury reportedly in May of 2022 was because of that report, a very serious report from former Canton Police Chief Kenny Berkowitz? Well, folks, I'll tell you, it's more than likely. I think it's very, very, very likely. And in that regard, you have to understand that not only did we have the weaponization of the Department of Justice in Boston by these liberals, which is one component of this investigation, okay? We also had a unit of the state police run by Tully that we will quickly come to find out was involved in more than just the cover-up of Sandra Birchmore's murder. So you have the DOJ in this position where Levy, after Rollins gets forced out of office, I think he's still, because Levy and Rollins and Dustin Chow, I think at least Rachel Rollins and Dustin Chow didn't like the Norfolk DA, Michael Morrissey. Two different reasons, pretextual. One, in 2015, Chow's wife got passed over for a promotion. What really happened was she was a Superior Court prosecutor who got assigned to district court. Her pay was going to be kept the same, but she didn't like it, so she left the office on bad terms. Chow at the time went around saying he was going to do anything in his power to burn down Michael Morrissey's reputation. Okay. Rachel Rollins, when she was Suffolk DA, had two positions that were very controversial among other even liberal Democratic DAs. First, Rollins didn't prosecute like a list of 25 low-level offenses. No one ever did that again. It was bad. It was not a good idea. It ruined the city of Boston, in my opinion. But it caused other DAs to comment against Rollins in public, and then she lashed out at them, including Michael Morrissey. That was about 2019, 2020. Now, similarly, Rachel Rollins had a position that she took that she would not seek life terms in prison for youth murder offenders under 25 due to their fact that their brains weren't fully developmentally ready. Okay, now Rachel Rollins ended up being vindicated on the latter point by the SJC in 2024, and that's now the standard. But you got attacked. The other DAs, including Michael Morrissey, and four of them filed an amicus brief in Rollins' case when she tried to take that position because they did not want that position. And so, setting aside the merits of it, Rollins did not like Michael Morrissey. So in November of 2022, as Rollins is kind of going out of office, and remember, Dustin Chow's not. Dustin Chow took Rollins out. Josh Levy has a meeting in his office in November of 2022 with Karen Reed, Alan Jackson, David Yannetti, okay, in his office. I think Josh Levy already knows about the Sandra Birchmore cover-up at that point, and now he's got someone else coming into his office. Now, I don't think Levy, in my opinion, ever believed, or Dustin Chow ever believed that there was a cover-up of John O'Keefe's murder. I think what Levy and Chow did, they're very smart. This is the highest levels of power in the federal judicial system. I believe what they did, Levy and Chow, was they said to Karen, Alan Jackson, and David Yannetti, we want to investigate the state police for Sandra Birchmore. You cannot tell anyone about this. But we don't want them to know either. We are going to run a grand jury into John O'Keefe's death that won't really be into John O'Keefe's death. It's going to be a backhand or a backdoor way of investigating Brian Tully's unit. You are to just along with this, and in return, we'll let you in public have all this fodder because we want to pressure them a little bit. We want to do what's called a limited hangout, where you bump them a little bit. They'll release a little information that they're under investigation. They know they didn't cover up John's death. They're going to be so focused on that, it's going to cause chaos in their life. Then you can backdoor the investigation of Birchmore. I think Karen, Alan, and David were in on that from the beginning. I think it was an operation. Okay. Then in the spring of 2023, I think what happened was around April or May, Aidan Kearney and Karen Reed got linked up via a woman named Natalie. Okay. And Aidan Kearney, it was rather through Jen Altman and Natalie, but Aidan Kearney and Karen Reed then started communicating. I don't think Aidan Kearney, actually Aidan Kearney was brought in on this. I think the reason Aidan Kearney was facing something in his life in April of 2023, Natalie Haskin, some woman out of Rhode Island, had accused him of wiretapping, and he had used a Rhode Island phone number to call her, but he was in Massachusetts. Apparently he thought that would get him around the Massachusetts wiretapping statute. I don't really know. The point is, he tells Karen about it. Karen tells him to call Alan Jackson. Alan, David Yannetti, and Turtle Boy start talking directly around April 20th to May 3rd of 2023. In those conversations, Alan Jackson is, according to my sources, helping Aidan Kearney because Aidan Kearney wants his wiretapping charge to go away. Now, for reasons unknown, a few weeks later in May of 2023, a field agent from the guy in Worcester, Samuel Weiner, that is his real name, starts reaching out to people in the orbit of a specific federal criminal investigation of Aidan Kearney, the wiretapping charge with Victoria Haskin, and it goes away. Okay. Then over the summer of 2023, Aidan Kearney runs a bunch of blogs. Okay, unlike anything I've ever seen before or since, on his page. about the federal grand jury into the John O'Keefe and Karen Reed case. Now, if you look into Buffalo Jim and Steve Miller, one journalist and a wrestling school owner in Las Vegas in the early 2000s, who Buffalo Jim had a wrestling school next to an establishment called the Crazy Horse 2, which was a front for the mob. And Steve Miller was a journalist who was Buffalo Jim's friend. Steve Miller was given an assignment by the FBI in protected status to write blogs about the Crazy Horse 2 for the purpose of attracting tips for the FBI. And Steve Miller talks about this openly. The FBI had Steve Miller writing blogs that would allow him to, they would SEO, search engine optimization, the blog, so his name would pop up first if you search Crazy Horse 2. They edited content of his blogs. They gave him scoops, and then they also planted his email address in the articles because they said if you get any tips about these people, not just the Crazy Horse 2, the people running this, refer them to us, tell them to expect a call from the FBI, and we will call them. Okay? I think for 3 months, the summer of 2023, Aidan Kearney was allowed to do that by the FBI, okay, and the DOJ in Boston. Not because of the John O'Keefe and Karen Reed case, but to get attention on the state police unit so the DOJ could drive tips. Is it any coincidence, then, that in August of 2023, the real probe of Matthew Farwell starts up, according to remarks from former U.S. Attorney Josh Levy when the Farwell indictment was announced in August of 2024? Then Aidan Kearney becomes kind of useless in all this, right? You know, he was only really useful for driving enough tips to get Tully's unit for covering up the Birchmore probe. But in the fall of 2023, something else happens that also intertwines all of this, which is on November 28th, 2023, Aidan Kearney puts in writing to Karen Reed, not just to Karen Reed, but Aidan Kearney puts in writing to his then romantic partner, Lindsay Gattani, just a brilliant human being who's going to come to be central to this story, as you can see on the side there in a second. But take a look. That is messages from Aidan Kearney to Lindsay Gattani on November 28, 2023, saying that Josh Levy, a full year after Karen and Alan Jackson and David first walked into Levy's office, and when Rachel Rollins is already gone as U.S. Attorney, Josh Levy was revealing ex parte information about protected grand jury investigations to Karen Reed. Now, this becomes a big deal because Aidan becomes a liability for Karen, okay? Now, on December 23rd, 2023, Aidan Kearney comes to find out that there was an ongoing he knew there was an ongoing criminal investigation. He had been charged with 16 felonies in the fall of 2023 related to Chris Albert and Colin Albert and other witnesses in the Reed trial that had been tormented by Mr. Kearney and Miss Reed, allegedly. Now, on December 20th, 2023, a grand jury binds over those 16 charges to Norfolk Superior Court, from Stoughton District Court to Norfolk Superior Court. But then Lindsay Gattani gets a subpoena from Brian Tully, the state police trooper investigating Kearney, for another grand jury. Okay? Now, Kearney must realize right away that the only thing that can mean is that Tully is investigating Karen and Aidan and potentially the U.S. Attorney's Office for what they were doing related to the case. But then you realize there's another piece of this puzzle. Brian Tully was asking questions in his official capacity as a state police officer in early December of 2023 about what the federal probe was about at that point in time. Now, We know in hindsight, okay, that the federal probe into John O'Keefe's death closes permanently in February of 2024, okay? Just a few months after Brian Tully's asking these questions, but the probe of Farwell continues. So why is Brian Tully only really interested in the investigation of Aidan Kearney to find out more about the federal probe of Sandra Birchmore's death? Well, as I was mentioning, on December 21st, 2021, Aidan Kearney goes over to Lindsay Gattani's apartment. By the way, let me just show you these pictures from the search warrant of Karen Reed's phone. Now, it's paragraph 77 through 81, okay, and we're going to zoom in. This is from mentioning Jane. Jane is Lindsay Gattani, okay. Karen Reed's phone ends up seized in January of 2024 because of information Lindsay gives to Brian Tully about Aidan's contacts with Karen. Now, one thing we want to look at as we zoom in here is this paragraph. Jane stated she was told by Kearney that Reed's attorneys in Reed were working with the U.S. Attorney's Office, specifically acting U.S. Attorney for the District of Massachusetts, Josh Levy. Kearney would talk a lot about the federal jury and Levy with Gattani. Gattani stated Karen Reed was interviewed by federal law enforcement. Gattani also shared other information. Gattani also shared other comments Kearney learned from Reed that are corroborated by other information known to the affiant, which is Brian Tully. That statement was that Brian Tully and the Norfolk DA were the targets of a federal probe. Brian Tully, when he asked that question to Lindsay Gattani, to be very clear, knew full well about Exhibit O. Okay, he had already obtained these text messages, and he knew Aidan Kearney was revealing that Karen Reed was getting protected grand jury information from Josh Levy, which gave Tully a motive to think maybe Lindsay knew something about the Birchmore probe, in my opinion. Now, that ties that together, but I want to go back to this second paragraph here, paragraph 82. You can see that Lindsay Gattani, was served with a summons to appear before the grand jury on December 22nd, 2023. Now, that's when she was served with the summons. Now, you got to think as Aidan Kearney, if there's another grand jury, you just got bound over, right, on 16 felonies. Why is there another grand jury? Oh, it must be into Karen Reed and Aidan Kearney. Kearney, against his better judgment, and he has said this multiple times, Karen Reed told him not to go to Lindsay's apartment that night, and as did his lawyers, okay? Now, the week before, Lindsay and Aidan had kind of been talking about whether he would come over. They were broken up by that point, but she asked him to come over, then he didn't want to come over. But on this day, after he finds out he gets the subpoena, he starts texting Lindsay trying to come over to her apartment. Eventually, she yields, and he comes over on the night of December 23rd, 2023. Now, listen to what the affidavit here alleges. During this meeting, Kearney told Jane to tell the grand jury she did not remember anything, delete evidence from her phone, and told her he would hire an attorney if she cooperated with him. Now, the allegations are that Kearney pushed Gattani on a couch because Kearney used Lindsay's notepad to take notes about conversations Lindsay had had with a woman named Kate Peter, who was a private investigator working for a man named Marty Kraft. Okay, Marty Kraft was a private investigator in the orbit of Brian Tully. We're going to get to this in a second because this ties it all in as well. Now, allegedly, Kearney was also witness intimidated Gattani and was charged with that as well. Now, further charges would eventually come out from that night that Kearney put his phone in his pocket and illegally recorded Gattani. There's evidence of the court record of the unedited recording that is out there, and then Kearney submitted an edited recording to make it look like Gattani consented to the recording, which itself is a whole bundle, the Pandora's box of issues as to Kearney's lawyer submitting potentially manipulated evidence, etc. But Kearney gets arraigned on December 26th, and he gets his bond revoked on the existing felony charges, okay? And that bond revocation leaves him in jail for 60 days. where he has admitted he was offered the opportunity to flip on Karen Reed. Because in reality, the investigation of Aidan Kearney wasn't just for Brian Tully to get intel on the federal probe, which I think he found out quickly was about the cover-up of Sandra Birchmore's murder, but also to get Aidan Kearney to flip on Karen Reed as sort of this double sort of pressure tactic on Karen because she was facing the murder trial, the first murder trial at the time for John's death. Now, in March of 2024, the Norfolk DA, the special prosecutor or whatever, did try to indict Karen Reed and Aidan Kearney. That came back with a no true bill, but it goes to my point. There was a dual point in investigating Aidan Kearney. Now, this gets even more interesting, okay? Because something wild happens, okay, in March of 2024. Karen Reed starts saying that Aidan Kearney is a risk. She's been careful to lay low, and Aidan blew it all up. And there's Karen Reed saying Brian Tully took Karen's 2 phones. One of them had tons of info on it, and that's all from, quote, the Lindsay Gattani mess. And then Karen says, I can't expose myself to that anymore. This was a leaked text message. Now, as you can see here, so you had simultaneous things going on. The weaponization of the U.S. Attorney's Office in Boston in multiple different areas, the targeting of Michael Morley by Dustin Chow, Rachel Rollins, but also Tully's unit and the grand juror leaks by Jessica Leslie, potentially involving Reed, but also, and the Birchmore case and other cases, but also you had misconduct, in my opinion, by Tully. Now, this misconduct was about to get a lot worse, and it's wild that this happened. So Aidan Kearney is in jail until February, February 23rd or so of 2023, okay, or 2024. Kearney gets out of jail. Lindsay also had a restraining order that was granted by the court, okay? Now, Kearney, after he gets out of jail, okay, is still subject to the restraining order. So Lindsay, if she's around, he has to leave. Now, Lindsay shows up to a John O'Keefe and Karen Reed trial hearing, I believe it was February 26, 2024, right after Kearney gets out of jail, the first hearing after he gets out of jail. Now, Lindsay had been told by Kate Peter that Paul O'Keefe and the O'Keefe family wanted Lindsay to come to court to show support for Lindsay. Now, Lindsay wanted to go to show support for the O'Keefes, but when she heard that, of course she wanted to go. No one said anything about Aidan or Jen McCabe or anything like that. Then the O'Keefes were told by Kate, and I know Paul knows this, Paul was told by Kate that Lindsay wanted to come to court to show support for the O'Keefes. Well, that's true, she did. But Paul wasn't told that Lindsay had been told by Kate that Lindsay was being asked to come to support the O'Keefes, because the O'Keefes didn't ask Kate to do that. Now, of course, Lindsay would have done it because Kate was telling her that the O'Keefes wanted that, in my opinion, right? That's a noble thing to do. But Kate didn't need to lie. Kate could have just asked the O'Keefes. But anyway, so Lindsay goes to court that day, and she ends up walking into court with Jen McCabe, even though that name was never mentioned. And when she gets into the court, Aidan is forced to leave the area because of the RO. Now, Aidan gets charged with an RO violation that day, and he ends up being found not guilty a year later. But the important part is Aidan then moves to amend the RO, I think in about April of 2024, and the judge grants an amendment allowing Aidan to be within 100 yards of a courthouse if Lindsay's there, okay? So on different grounds. Now, it was a motion to modify or something. Now, then Lindsay was useless to Brian Tully. Okay, she couldn't provide info about the Birchmore cover-up or what the feds were investigating. Aidan was out of jail, and the RO was amended. Okay, so she was functionally useless to Brian Tully, his PI, Marty Kraft, and the person Marty Kraft employed, Kate Peter. Okay, and so then this is where it gets bad. In April of 2024, Brian Tully personally released an unredacted extraction of Lindsay Gattani's cell phone, 15 years of her life, containing protected attorney-client material, doctor-patient material, educational material, even pictures of Lindsay giving birth to Aidan Kearney's lawyer, April 24, 2024. The only thing that Tully redacted or deleted from the extraction were messages from Brian Tully to Lindsay and from Kate Peter to Lindsay. And what did Kate Peter and Brian Tully do? Oh, then they launched another operation within an operation, in my opinion, with Marty Kraft's help. They released that extraction to Aidan Kearney, and then they had a man named Jason Broyles, who's a parking clerk from Connecticut, who pretends to be a woman online named Haley Walbrecht. He presents himself as a victim advocate. They had Mr. Broyles, in my opinion, cover extensively Lindsay Gattani's phone extraction for two purposes. One, I believe that Mr. Broyles and Miss Peter and Mr. Tully wanted to provide a distraction. Okay, that was April 2024 was leading up to the first Reed trial. No one could deflect attention away from Jen McCabe and the other Reed trial witnesses. The Turtle Boy fans and the Karen Reed fans were paying just attention to them. Kate, I have video, tried to spread a rumor that Colin Albert and Chris Albert sold drugs to take some heat off Jen McCabe. It didn't work. Okay. Releasing Lindsay's phone extraction through Jason Broyles took a lot of attention off Jen McCabe and put it on Lindsay and her children. And you know what happened next? It also served another end for Kate and Tully and Broyles and Marty Kraft, because Broyles got a lot of credibility with Turtle Riders and Free Karen Reed fans. Now, Broyles had originally come on the scene in the fall of 2023 by paying for a Free Karen Reed billboard under his own name. But he kind of got forced away. It might have had to do with some very serious allegations, and he just never came back under his real name for a while. But in the winter of 2024, he comes back under Haley, and I think Kate knows him the whole time, because Jason Broyles was on Kate Peters' Discord as early as 2019, and there's evidence of it. So Jason Broyles, I think, was gaining credibility with Turtle Riders and Free Karen Reed fans at Lindsay's expense, with Kate Peter and Brian Tully and Marty Kraft's permission, so that Broyles could get close to Aidan and his people. Now, Broyles started getting close to Lauren Murray and Meredith, all these people around Aidan, and all the people around Karen Reed. And I think it was to feed intel back to Tully and Kate. But the fact that it centered around the leak of Lindsay Gattani's phone extraction opens up an entire new can of worms, because that would mean Brian Tully, under color of law, knowingly leaked that extraction while Ken Mello was in the hospital, so that Jason Broyles could cover it for this purpose. Now, there are some other moles that do run these similar operations. Christy Citroni, her mother used to date Mr. Kraft. And the reason I'm bringing this up today and covering all of this is it all ties in because, according to my sources, Brian Tully brought Marty Kraft, this PI, into his orbit way before the fall of 2023, when Kate Peter was brought on as a PI working for Kraft to investigate Karen Reed, Aidan Kearney, etc., and handle some of the people around the investigation so they wouldn't find out about the cover-up of the Birchmore probe. Marty Kraft in 2022 was going around on Brian Tully's behalf trying to influence or prevent, according to my sources, witnesses in the orbit of the Birchmore cover-up, the other girls, witnesses, etc., victims, from cooperating with the FBI. Now, is it any coincidence that right as Lindsay Gattani's phone leak, which could itself be a federal crime, happens, this network starts targeting Lindsay, Broyles, Christy Citroni, Kate, Marty Kraft? Did Lindsay know too much? Potentially. Could she have even figured out, although maybe she wasn't told anything, but was she in the orbit of people, Tully, Yuri, John Fanning, Kate, Morrissey, who knew about the Birchmore cover-up? And is it possible that, just like with the women who knew about the Birchmore cover-up, when Lindsay realized what happened to her phone and potentially thought about cooperating with the FBI, did Brian Tully, Jason Broyles, Christy Citroni, Kate Peter, Marty Kraft target Lindsay through proxy? Oh, it's possible. And ladies and gentlemen, I think we start to see a pattern here, because just a few days ago, Ashley Bell, another survivor in the area of the Sandra Birchmore cover-up investigation, has been targeted, according to my sources, by Mr. Kraft, Ms. Citroni, and Mr. Broyles, and Ms. Peter. Now, I think this all ties together for the following reasons. What you got going on here, fundamentally, is that Jessica Leslie started leaking in August of 2022, in my opinion, because there was a grand jury investigating the Norfolk DA and Brian Tully State Police Unit for the cover-up of Sandra Birchmore's murder. Although that unit did nothing wrong as to the investigation of John O'Keefe's death and Karen Reed, that unit was being investigated federally. Alan Jackson manipulated what he was told via leaks in order to present to Karen Reed an ostensible defense, which was basically, we have dirt on these the MSP. Let's try to just get this to go away. When the MSP wouldn't make it go away, and the Norfolk DA, Karen Reed and Alan Jackson ramped up the pressure, so did the feds. It wasn't just to make it go away for Karen. It was more like Karen said, if you make a lot of I think Karen was saying, and her team knew, that their strategy was to, if the Norfolk DA and the state police are going to push this, okay, then we're going to expose all their secrets indirectly. And we're going to use my case to get a lot of attention, too. That's what we get out of it. That's what Alan Jackson would want out of it, a media deal. That's his thing. It's a brilliant legal strategy. It's fucked up, but it's brilliant, okay? Now, he needs to get his pay, and his pay is not going to come from Karen and her parents, who don't have millions. It's going to come from a media deal, okay? And that's how this was probably all engineered. Now, Alan weaponizing his inside knowledge about the Tully's unit and their liability for the cover-up of Sandra Birchmore's murder, I think, is what it pieces this all together, okay? Yeah, you had the U.S. DOJ under Levy and Rollins, who knew they were doing bad things. They were interfering politically. Arroyo Hayden, Goldberg, O'Brien, Morrissey. But they also had Morrissey's unit on the cover-up of Sandra Birchmore. Then, okay, you have this unit, for whatever reason, hell-bent on not allowing the DOJ to investigate this cover-up of Sandra Birchmore's murder. Things, however, all take a turn when the liberals lose power, okay, in the fall of 2024, all right? Because, unlike before, where Rollins and Levy had an incentive to really only investigate Birchmore and not what they were doing and Leslie was doing, Leah Foley comes in as U.S. Attorney in January of 2025, and Hank Brannon comes in on the John O'Keefe and Karen Reed case in the fall of 2024. I think initially, Morrissey, it's really my opinion that Morrissey brought Brennan on. Morrissey brought Hank on. He said I can call him Hank. Morrissey brought Hank on. The only thing he's ever said to me. Morrissey brought Hank on in order to find out what the feds were doing. Okay, and I think Hank quickly figured out that Leah Foley, U.S. Attorney Leah Foley, knew about the Leslie leaks and knew what Karen had done and knew how Levy and Rollins had weaponized the old DOJ. That's big, because that's liberal Democratic establishment people in Massachusetts eating their own and weaponizing the U.S. Attorney's Office. Those are big charges. You see Levy on the screen, Rollins. I think they're targets, in my opinion. But at the same time, I think Leah Foley and Hank Brennan probably had a discussion, and Leah Foley was probably candid and said, listen, I realize Rollins and Levy did bad things here, okay, with that office. But your guys, totally, like this unit, and I bet you said it to Morrissey too, your guys covered up Sandra Birchmore's murder. I don't think the DOJ knew about Lindsay's phone leak yet, but it's the same pattern. They covered up Sandra Birchmore's murder, and then they tormented people who they thought were going to cooperate with us. Give them up. Now, Hank, I don't think ever was involved in anything bad. I think he negotiated this deal, in my opinion. And so in December of 2024, I think this was really brilliant. I think what Hank Brennan and Leah Foley did as she was coming into office, and this syncs up with Leah Foley confirming through law enforcement partners after giving an interview on Dan Ray, saying like that was really the only way she could do it, that the federal probe of John's death was closed. She confirmed that around February 13th or so of 2025, okay? Simultaneously, Leah Foley in a TUI request, which is a section of the U.S. federal regulations. It's an interpolation of a case from 1985, U.S. Ex Rel. 2 v. Reagan. And this is not legal advice. And then that's interpolated in 28 U.S. Code of Federal Regulations 126.000, which is itself interpolated in Section 25 of the DOJ Operations Manual, okay? It allows for federal authorities to turn over to both sides of a state court criminal case information that's like obtained during the context of a federal investigation. For the first time over 2.5 years, the Norfolk DA had been trying to get TUI requests like filled for years. Hank Brennan gets a responsive TUI request with a headline, with a header that shows an invoice from a company called ARCA that had been initially retained from the federal government and then paid by Reed's defense, which confirmed that ARCA, Levy, and Reed facilitated the violation of a federal protective order in the spring of 2024 during Reed's first trial in order to help ARCA frame their testimony. Like Levy was really helping Reed, okay? And then also hide payments from Judge Cannoni and state prosecutors from ARCA to Reed, which is relevant to impeachment questions on cross, so it sabotaged the integrity of the first trial. This was a very serious situation, and I think what happened was U.S. Attorney Leah Foley knew about the Leslie leaks. She knew about how badly Reed's team had corrupted the first process, and so I think it was very likely she tipped Brennan off to it, okay, and then her and Hank Brennan and the Norfolk DA made a deal. The Norfolk DA gives up Tully's unit on the Birchmore cover-up, and then the Norfolk DA and Brennan helped on an operation. I'm positive that second Karen Reed trial was not real. Yes, the verdict will never be challenged. It's not guilty. We're not revisiting it, but it was fake. It was in the sense Hank Brennan, like, I'm not going into details. I'm not going to talk about the redacted. Hank Brennan did redacted with Leah Foley's permission to allow the U.S. Attorney to investigate whether Reed would do anything to attempt to compromise the jury. It's obvious. And Reagan Communications was involved. At first I thought they were involved for Karen, and then I was like, oh no. They just had to get the person out of there who maybe like was well-meaning and good-hearted but couldn't like keep a secret, which is fine. Like most of us can't keep a secret on this level. I'm a reporter, like, you know, I can do it, but most people can't. And so I understand, like, Reagan Communications was probably involved, and I see how this deal came together. And the reason why I'm tying this all into one big picture here is I think what we're really looking at is two simultaneous sort of boxes of federal investigations, as I drop my keyboard. Two boxes of federal investigations. The first box is Jessica Leslie and the leaks from the federal grand jury between August of 2022 and March of 2024. We know that at least there are at least two cases. okay, that we know about related to Leslie leaking, confirmed by the Boston Globe towel in federal court by federal prosecutors, basically, okay? The CDL case with the state police and the John O'Keefe and Karen Reed case, which was described by federal prosecutors in court as a federal grand jury that was opened in February of 2024 but is now closed, okay? That's the John O'Keefe and Karen Reed case. Shelley Murphy with the Globe confirmed it. That's the best, long-standing reporter we have in Boston. I confirmed it as well. I'm not there with Shelley Murphy's level, but I'm telling you, we both confirmed it. It's the real deal. Okay, there are two other cases that the U.S. Attorney's Office was very hush-hush about in pleadings and in open court. And we know because of the information filed against Leslie, and I'll bring it right back up on the screen for you right here. We know that Leslie was originally leaking from August 11, 2022 through March of 2024. Right now, the U.S. Attorney has only talked about leaks that Leslie did between January 25th, 2024 and February of 2024 related to the CDL case and the Reed case. That means there's two other cases, very hush-hush, one of which was probably going on as early as August of 2022, and the other one I have no idea about. And that one, at least that one starting in August of 2022 that she was leaking about might have started back in May of 2022. Leslie started leaking about it in August of 2022. It was probably Birchmore. Now, why would they be so hush-hush about Sandra Birchmore's probe unless it was still ongoing? And what if Matthew Farwell, who's in jail right now facing indictment and the death penalty for murder of a cooperating federal witness in the context of the Birchmore case, what if he just found out that Sandra's baby wasn't his? What if he knows he was told that it was his baby by his own colleagues to manipulate him into murdering Sandra Birchmore? What if he's cooperating? What if that means the scope of the federal probe is not just Leslie's leaks and Karen Reed and Alan Jackson and Turtle Boy and their involvement in the manipulation of the state court criminal process, but what if it's also on the other side, Tully and John Fanning and Yuri Buchanan, related to the cover-up of Sandra Birchmore's murder, and now potentially the leak of Lindsay Catani's phone extraction by Brian Tully, Kate Peter, and Jason Broyles. Do you see the nets that are cast here? If the big fish on one side are Rollins, Levy, Goldberg, Sean Collins, that's huge. You destroy the Democratic establishment in Massachusetts. The Democrats, by doing some of this shit, basically made me a Republican. I already loved President Nixon. I hate the damn commies. You know what I'm saying? JFK was like a moderate Republican. I was already going that direction. But the Democrats in this state made me, someone who used to be a Democratic standard, bearer was going to party conventions as a delegate, classically liberally trained as a philosopher and a law student. Okay, I'm not a lawyer, none of this is legal advice. they alienated me from the party because of what I saw. I know how the public's going to react to this. If you get Rachel Rollins, by the way, who's subject to bar disciplinary proceedings as of June 2025, yet has not practiced law since she left the attorney's office, you think that's coincidental? If you get Rachel Rollins on federal charges, if you get Josh Levy on federal charges, Karen Reed, Aidan Kearney, and Jessica Leslie, all related to leaks. But then you also get Brian Tully, John Fanning, Yuri Buchanan, Matthew Farwell, Billy Farwell, Robert Devine. If you get all them related to Birchmore, and then you get Tully and Kate Peter and Jason Broyles related to Lindsay Gattani, do you understand this could be the biggest public corruption probe of all time? And then on this chart, now this whole chart makes sense to you all, we've covered every name. On this chart is not the Shannon O'Brien and Deb Goldberg situation, which also exposes Rachel Rollins and Josh Levy, in my opinion, to an incredible amount of liability related to that fall 2023 leak in the Boston Globe, trying to frame the federal investigation as somehow targeting O'Brien, when in we had a video for error. Reality, it was Goldberg and Collins who were getting a favor from the U.S. Attorney's Office when they should have been investigated. That leak to try to smear O'Brien was tactical to protect Goldberg and Sean Collins. If you get Goldberg and Sean Collins and Rachel Rollins and Josh Levy, do you understand that is basically the core, like, of one nest of the Democratic establishment in Massachusetts? You would decimate the party. People would vote Republican. You might actually get some of the numbers down. Now, this isn't election interference. I want to be clear. The DOJ, will think about this. It's not election interference. You can simultaneously dislike Democrats and commies. I hate commies. You can simultaneously dislike Democrats, okay, and expose their wrongdoing. Now, the fallout of the wrongdoing being exposed might be that their share of the vote goes down, and you may like that, but those motives are completely independent. If all you have to do to get people to not vote Democrat is expose something like this and show them the nitty-gritty of the Democratic machine and what they do with the vulnerable, and how people like Lindsay Gattani and Sandra Birchmore and the memory of John O'Keefe, and the witnesses, how those without political power become pawns in larger proxy wars. If you want to do something about that, then you have to focus on fundamental reform. And the way you do that is simply by showing people what has happened. You don't need to tell them that they should not vote Republican. That's election interference. Just to be clear, I'm doing some analysis now. You simply need to present what has went down here. And this is the beginning, let me just tell you, of a long road. Jessica Leslie has been escorted out of the federal courthouse twice now, undercover, and not allowed to be filmed by the media. If she's cooperating, then we'll listen to my report here in a second. It was quite clear at the hearing on August 4th, Monday of this week, I was one of 4 reporters in the courtroom, that Judge Talwani, federal judge, was not willing to accept the disposition proposed by the U.S. Attorney's Office related to Leslie's case. And by that, I mean Judge Talwani was not willing to accept the prosecutor's, at least as it stands, provisionally recommended sentence of 1 day in jail time served, 24 months supervised release, no fine, $100 special assessment. Judge Talwani glared when saying, I'll accept the guilty plea to Miss Leslie. Judge Talwani then glared at the prosecutor, I was there in court, and the defense attorney, when she said, I'm uncomfortable with the proposed disposition, and I'm not yet ready to accept it. I'll look at more information. Now, how's more information about those leaks and the extent of Leslie's behavior going to help Judge Talwani, who swore in Miss Leslie herself? Judge Talwani was the judge who swore in Miss Leslie. feel more comfortable with that sentence. The more Miss Leslie leaked, the more Judge Talwani finds out, the more upset she's going to be, the harsher the sentence. Now, Judge Talwani is within her rights to accept a guilty plea and reject the proposed disposition. If she enters a sentence that's harsher, Jessica Leslie can just withdraw the plea. We start again. So it's not like she just goes to prison. She's allowed to per the plea, and Judge Talwani told her this in court. If I reject your disposition, you can just withdraw the plea, and that will happen, okay? Now, she can withdraw the plea preemptively, and here's why I think this might happen. Jessica Leslie is clearly cooperating. I just want to pause this because, by the way, this is a prediction from a few months ago. Fascinatingly, she didn't end up withdrawing the plea, but Judge Talwani did reject the proposed disposition. Now, obviously, Leslie could have withdrew if she wanted to, and I was predicting she might. I think the 2 months home confinement meant she didn't need to change her mind, but it's so fascinating to watch my own predictions ex post facto. It's fascinating. With something. She got smuggled out of the courthouse twice so the cameras couldn't film her. I think the DOJ doesn't want to say Jessica Leslie is cooperating in open court, but under the rules, okay, Jessica Leslie in her sentencing, her plea, the U.S. attorney lays out where she falls on the sentencing matrix, okay? Jessica Leslie fell originally at a step 12 offense with 0 criminal offender history, which brings her down, it would have been a little bit higher than the 6 to 12 that the guidelines recommend that she got because she went to step 10, but it was like 12 to 16 or something, maybe 16 to 18 initially. She got bumped down to level 10 for a clean criminal history, which was 6 to 12 months in federal prison, okay? Now, judges are not bound by these guidelines, but judges they can go up, they can go down. But they really can only downward depart in that way that the prosecutor wanted, the DOJ. They can only downward depart if there's an indication under 5.1K of substantial cooperation. Okay, that's a legal term of art that says if the prosecutor stands up and says, this person who's charged gave us substantial cooperation, the judge doesn't second guess it, barring some extraordinary circumstances. The judge will maybe have a colloquy off at sidebar, impounded with the attorneys about the scope of the cooperation, but it never is made public because that would compromise ongoing investigation. So the judicial system has a built-in check, and the U.S. attorney has to activate it. The judge doesn't activate it. You don't do it in secret. You must assert it. We've seen these kind of plea agreements, okay, with Juror 11's father-in-law, where it says there's substantial cooperation, basically, okay, because you have to give back documents, you have to give testimony, those will be in the plea. However, sometimes you see it in what's called a PSR, a pre-sentencing report. Now, Jessica Leslie's sentencing, as you're going to hear this video as we close out this recap stream here in a second, you're going to hear Jessica Leslie's heading for sentencing September 26, 2025 at 3 p.m. in front of Judge Talwani. Now, in the pre-sentencing report, the U.S. Attorney's Office can say, and this is not made public until after, she's cooperating. Now, that would allow Judge Talwani to feel more comfortable with the disposition, I'm sure. Or the U.S. Attorney's Office can get up in open court at sentencing, which they have to do, because you have to announce part of the rules, and Judge Talwani explained this to us when we were all in court on Monday. Part of the rules for the plea process is the U.S. Attorney is obligated to explain mitigating circumstances at sentencing that would reduce the sentence. So I think the U.S. Attorney is really trying to avoid saying the words or putting in a document that's public, Jessica Leslie is cooperating. That's the vibe I get, okay? Very close to this. However, I also think that they're kind of between a rock and a hard place. The U.S. Attorney's Office, which, by the way, the chief of the Major Crimes Unit, AUSA Peruti, is prosecuting this. Prouty, it might be. She said her name very quickly. It was hard to hear in court. Prouty, I think. The AUSA who's prosecuting this is the head of the Major Crimes Unit. Okay, that's not a coincidence in my opinion. But the DOJ is in between a rock and a hard place somewhat. Because Judge Talwani, and I was there, I read the vibe, I saw her eyes. She smiled at me at the end of the day because I was good. I wrote quietly. Someone's cell phone off, but not mine. I just there and wrote quietly. She was pleased, I think. She gave me a smile. What do you want me to say? Get a smile from a federal judge. That's a good day in court. I'm not a lawyer. I'm a tout. But anyway, as Judge Talwani was glaring at these attorneys about this disposition, what I could sense was you don't hear very often about charges coming up for federal grand jurors leaking. Remember, federal grand jurors are charged by the court. They are basically officers of the court in a parallel role, okay? You're not offending the U.S. Attorney's Office, just the U.S. Attorney's Office, when you leak as a grand. You're not offending just the law, the letter and the spirit of the law. You're offending the federal court, and not just an individual judge. You are offending the federal court's sense of justice. They impaneled you, they gave you secret privileges, and you violated them. That's what I saw in Judge Talwani's eyes. She didn't say it, but I saw it. I saw it. I saw it, and rightfully so, in my opinion. I saw in the eyes of the federal judge, Judge Talwani, furor. Because this disposition reflected a very low penalty for not just offending the property. All right, come on now. I don't know what's going on with Twitter today. That's fine. Prosecutor in the law, but the court. And remember, when you're in criminal contempt, it's of court, of the judge, of this judge who charged you as a grand juror. And so that's why I think the DOJ is in between a rock and a hard place. Public policy, dissuasion of future leaks, like mandate almost, that the federal judge come down hard here. The potential imprisonment for contempt that Leslie's charged with is any term of years, literally up to life. Okay, $250,000 fine potentially. And so Judge Talwani has to send a message. You cannot leak from a federal grand jury. That sentence doesn't send a message. So this is the analysis here. It doesn't send a message. And the vibe I got was the only way the DOJ is getting that disposition, which they can get, it's within their prosecutorial discretion to get it, even if. Very interesting to listen to my thoughts on this because, see, now, I am not a federal judge. I'm not a lawyer. I'm a towel. And I think it reflects my feeling about not leaking that kind of stuff if you're an impaneled federal grand juror. But I mean, the fact that you can get a term of life is true. That disposition is available. It ended up being 2 months home confinement. But the point is, I was right in that I got the sense that the judge didn't feel comfortable with the proposed disposition. I called it. We end up seeing a few months later that the Judge Talwani did indeed not go along with that and impose the 2 months home confinement. Now, I guess I'm enjoying listening to this. We're on verdict watch, by the way. No verdicts come in until 2 p.m., so we'll take this through. Maybe actually I want to listen to my overview of the Cosgrove motion again. I know. I just realized that although this is mostly about the chart, it was... I rolled this out when Jessica Leslie was right about to face potential sentencing, and I forgot that. Hey, we overtook Boston 25. 4.1 thousand, ladies and gentlemen, over on the Towel X. And for us right now, that puts us 200 above Boston 25, who are at 3.9. Defense Tires 3.1. OpenAI conference 2.1. Young Jerks 984. The excellent job. Jennifer Kalfendaffer 758. Surviving the Survivor 740. And then I think Yellow Cottage Tales is on there, coming in with a respectable 746. All right, now let's take a look at the Cosgrove motion read, because that'll take us right through till 2 p.m., which is the first possible time we could have a verdict. There's nothing that indicates a verdict is coming. I'm just saying if there could be a verdict, it cannot happen before 2 o'clock. There's a rule. They don't take verdicts while court staff are on lunch. I think that's a good rule. As we all know, the court staff are unsung heroes and work very hard, and we love our court staff. Even the judges love the court staff. Judge Krupp, notoriously a little bit cranky on the bench, loves the court staff. He refers to them by their first name. He calls them Margaret. He calls Margaret Margaret. We call her Clerk Margaret. All right. Hold on. I don't want that one. I want Cosgrove's one. I want the one where it reads Cosgrove's motion, and then I yell about it. Is this it? No, that's not it. I want the one where it has Robert Cosgrove and me yelling about Robert Cosgrove. All right, is this it?
17, 18,
No,
19,
that
20.
was a Proctor cell phone. This is frustrating me. Oh, it's probably one of these ones that's like loaded up. Where is it? That's not it. Is this it? This might be it. Don't tell me it's an hour and 6 minutes. Yes, it's an hour and 6 minutes. All right.
Bring it up on the screen.
Well, we're on Verdict Watch anyway, so if you're ready to hear me yell about Robert Cosgrove's motion, oh goodness, ladies and gentlemen, now is the time to listen. Is that what you necessarily want to do with your day? I don't know. It's what I want to do with my day, though. All right, where is it? Let's see. This one? Hey, that was the right one. All right, let's go.
Bring it up on the screen. We can listen to the PDF get read out. I cannot believe what I just read.
All right. Come on now. The Twitter loading issues continue, but I will not be deterred. Hold on, let's give it a second.
Bring it up on the screen. We can listen to the PDF get read out. I cannot believe what I just read. Cosgrove coming in with the
You are frustrating me. All right, I got a backup plan. It's not really a backup plan. I'm just going to refresh this. Twitter has been a little off with its loading videos today. Nothing I can do about it. Let's give it one more go.
Bring it up on the screen. We can listen to the PDF get read out.
What? No, this was an earlier hearing. Sorry, I thought I saw Walsh. I do not.
I cannot believe what I just read. Cosgrove coming in with the Texas Pete today. No, I love your references, current resident. You are a very wonderful super tout. All right, listen to me, folks. I have just come across, I don't even know how to describe how ridiculous this is. There is ridiculous, and then there is the filing I have just read.
All right, Twitter media player, what's going on?
From Robert Cosgrove. Every once in a while, every once in a great eon, you get a filing that really intrigues you, you know? Every once in a while you get a filing that's really dense, that's really interesting. And then there are those days where you get a filing that quite literally, ladies and gentlemen, leaves your world aghast.
All right, who doesn't want us to watch my towel video? Hold on, I got a backup. I don't actually have a backup plan, but I'm just going to try one other thing. So let's try that. All right, and then my towel camera's already paused. All right, let's try again.
You cannot comprehend how you have read it. You can't comprehend how it exists. And this is that document. And you may be saying to yourself, Grant, that's not possible. Yes, it is. Yes, it is, ladies and gentlemen, and I am going to show you the proof. We're going to listen to it as soon as the Walsh hearing is concluded. The lawyers are probably just doing some scheduling matters with Judge at side back. Now, for us, What are we doing? Oh, we're about to do some things, little towels. Let me just tell you right now. We're going to listen to this. All right? We're going to listen to it, and we're going to see if it'll read. All right? There's no promises that it will read, but we're going to try. Come on now, you can do this for us. We believe in you. Didn't find any. You lawyers and making non-machine readable PDF.
Attorney Mark A. Betterow. As with a previous Betterow affidavit, hence
technology to convert web page
that uses text to speech. Works on a variety of web.
Now I'm just tormenting the poor thing. All right. But this is what we're going to do as we're waiting for a verdict. And then we'll go as long as we can today, and then I will go about my business. I was trying to skip you to the part where the motion starts being read. The Aiden Kearney case isn't being heard for a little bit, but getting updated on this motion will, I think, put the grander scheme of things into a little bit of context, so give me a few seconds here. And yes, my video player is being accepted.
Bring up on the screen.
But that's not our fault, ladies and gentlemen. Well, maybe it is a little bit of my fault. My computer's getting a little old. That's all right. I'll figure it out. All right, come on now.
To docket note.
All right, that's a little bit too far. How about there?
Is a Chrome. Read aloud is a Chrome and
Firefox. This case is specially assigned to Judge Belizos. Commonwealth's memorandum in opposition to Attorney Betterow's affidavit in support of motions to disqualify, etc. The defendant Aiden Kearney has filed an affidavit in support of motions from Attorney Mark A. Betterow. As with a previous Betterow affidavit, henceforth, B.A. the motions are phantoms, and there is no memorandum of law accompanying the non-existent motions. The Commonwealth infers that the affidavit in support is intended to serve all three functions, and assuming arguenda that this court consents to accept it as such, the Commonwealth offers the following response. The defendant first asks this court to preclude the Norfolk County DA's office henceforth NDA from appointing an Odlier special prosecutor to docket no 2482 CR 00043. The 2024 case, due to its irreconcilable conflict with witness Lindsay Gaetani. Section 1A. That request is moot, as the district attorney's office has since entered a nolle prosequi on that case. The defendant remains free, of course, to contest the validity of that nolle prosequi by litigating whether the NDA's alleged irreconcilable conflict annos fio or AAA that action, and insisting on the revival of that indictment, but so fat section EONF doing so. No ye 1314 to 803 3ALZ03Y. Next, the defendant asks this court to disqualify Special Prosecutor Cosgrove from docket no 2382 CR 00313, the 2023 case, because of his alleged irreconcilable conflict with Ms. Gaetani. Section 1B. Much has been said in previous filings with respect to Ms. Gaetani, and she herself, with prior leave of this court, has filed a number of pro se documents. All of that pays examination, but the Commonwealth offers a brief background summary. Gaetani is a single mother and a faithful, perhaps even compulsive follower of online postings on such outlets as YouTube, X, and Facebook. In this context, she viewed some of the defendant's online postings related to the then pending Karen Reed case, sent him a laudatory message, ordered one of his free Karen Reed t-shirts, then sent him a photo of herself wearing that shirt. Correspondence ensued, and not long thereafter, an intimate physical relationship. Bolstered by Kearney's bragging about his inside knowledge of the Karen Reed case, dinners and drinks, use of the internet to exchange texts, including those with explicit sexual content, and the defendant's sometime practice of videoing their sexual escapades with his cell phone camera. At some point the Gaetani-Carney relationship began to founder, and at about the same time, Gaetani began to have doubts about the innocence of Karen Reed. Whether on her own initiative or as, the defendant posits, the influence of other denizens of the online community, such as Catherine Peters, Gaetani contacted Lieutenant Brian Tully, who was leading the NDA investigation into intimidation of witnesses in the Reed case by the defendant. Tully interviewed Gaetani. The Commonwealth had already developed another witness, Natalie Wiewike Berschneider, who could attest to communications between Karen Reed and the defendant. During the months of April and June 2023, Gaetani's information confirmed such contacts after underscore that date, based on what the defendant had told her. Tully reported on the interview to Special Prosecutor Kenneth Mello, who had Gaetani served with a grand jury subpoena. Gaetani had apparently hoped not to have to testify, and began to panic upon receipt of the subpoena. She telephoned the defendant and informed him that she had been subpoenaed, and attempted to minimize her role in the matter. After some discussion, the two agreed to meet at Gaetani's apartment building, where Carney demanded to examine Gaetani's cell phone and took notes on some of its contents. He urged Gaetani to delete various items from her phone, representing that he had checked with his attorney, Timothy Bradel, and that as there was no preservation order in effect, that there was no problem in doing so. At one point in the early hours of the morning, Gaetani excused herself to use the bathroom and telephoned Special Prosecutor Mello, awakening him. Mello had difficulty understanding what Gaetani was saying, beyond understanding that she was fearful, but effectively arranged to transfer the call to Tully. A brief exchange of messages followed, then Gaetani returned to the defendant. Further conversation ensued, as did other events. After speaking with Gaetani the following day, December 24, 2023, and learning that she had not reported the incident to the local police, Tully did so. The defendant's arrest soon followed, resulting in revocation of previously imposed bail. Gaetani was granted a 209A restraining order. The defense's theory, as discussed in the Commonwealth's memorandum in opposition to Attorney Bettero's affidavit in support of motion and associated submissions, henceforth, Mem. Opposite, is that Catherine Peter, Lindsay Gaetani, Mr. Mello, Det. Lieutenant Tully, and possibly others diabolically plotted to have Mr. Kearney's bail revoked by luring him into intimidating Ms. Gaetani after they made her what Mr. Bettero describes as a witness. Taking care to put the term in scare quotes. Mem. Opposite. At 16. Subsequently, the defendant went to the Medfield police and alleged that Gaetani had wiretapped him by recording a sexual encounter without his consent, using a home security camera. As a result, Gaetani was interviewed by the Medfield Police, MPD, and in the course of that interview, MPD were informed of a sexual encounter on October 14, 2023, which Carney had recorded. Per Gaetani, he sent her a copy of the recording the following day. The question arose as to whether Gaetani, on that occasion, lacked the capacity to consent, and thus was raped by Kimi, but Gaetani initially did not want to proceed with charges. The police subsequently met with Mr. Carney and, among other things, advised him that they had a copy of his video of the October 14th encounter. According to Ms. Gaetani, on April 13, 2024, Carney publicly announced on YouTube. Episode 654, aired April 13, 2024, that Medfield police were investigating him for rape, calling a tally. This was the first public mention of the allegation, initiated by Carney himself. 8. Defendant's answer and counterclaim, hereafter, ANC, Carney vs. Gaetani, Worcester Sup. 2585 CV00035. Carney launched an online campaign of vilification against Gaetani. She was a fake victim, an unfit mother. She supposedly Kearney's postings as cloth on and on the attacks went, with Kearney's devoted online acolytes gleefully piling on, picking up the cry of fake victim, photographing Gaetani at various locations, sending accusatory messages to her children's school, and texting her with obscenities, accusations and threats. 1. Among Kearney's enthusiastic collaborators in the campaign of vilification against Gaetani was Jason Broyles, who initially appeared online under the pseudonym Haley Walbrecht. Broyles serially posted derogatory material about Gaetani, interspersed with exhortations to her to prevent him from continuing to do so by telling the truth. Publicly adopt Kearney's version of events and repudiate her own statements. Eventually, Gaetani responded to the verbal assaults against her on her social media account, denouncing the defendant as a rapist and describing him with other derogatory terms. On January 8, 2025, represented by counsel, Carney filed suit in Worcester Superior Court, alleging slander, libel, and intentional infliction of emotional distress, and seeking damages and injunctive relief. After an unsuccessful motion to dismiss, Gaetani, proceeding pro se, filed an answer and counterclaim on September 8, 2025. In the course of litigating a Dedham District Court case involving an alleged violation of the 209A order granted Gaetani against the defendant, Cosgrove had provided as discovery the Medfield Police report on the October 14, 2023 incident to Attorney Bradle. Bradle, or someone acting on his behalf, gave the report to Carney. Carney provided it to Broyles. On August 8, 2024, Broyles posted Gaetani Files Part 3, including the unredacted confidential police report of Gaetani's sexual assault allegation. ANC 65. In ANC, in addition to answering Kearney's allegations, Gaetani attempted to implead Cosgrove, Lieutenant Tully, and a Medfield police officer. The factual basis of all her allegations against Cosgrove is that his turning over the report to the defense violated GL Circa 41, Section 97D. As a result of Gaetani's filing ANC, Cosgrove filed a motion to withdraw from 2482 CR00043, believing that a conflict existed between defending, should it become necessary, against Gaetani's ANC, and prosecuting an indictment where she was the alleged victim and primary witness. That motion was allowed without argument and without objection. The defense now seeks to leverage that withdrawal to force Cosgrove's removal from the present case, in which Gaetani is alleged to be the victim and is not a necessary witness for the Commonwealth. All of the named victims in the present case are either witnesses in the Karen Reed case, or relatives of witnesses. Gaetani is not a percipient witness with respect to any of the counts in the present case. To the extent she would be of any use to the Commonwealth at all on these counts, it would be to testify, based on her conversations with Carney, as to Kearney's relationship with Karen Reed, which goes to his motive for the intimidation of the witnesses. If the Commonwealth wishes to introduce such information, it can do so through other means, including the contents of 2 of Kearney's cell phones seized pursuant to warrant, which show extensive communication between the defendant and Reed, as well as communications with some of Reed's attorneys. In short, there is no need whatsoever for the Commonwealth to call Gaetani, and no need for prosecution to, as the defense posits, defend the credibility of a prosecution witness who has sued him for his alleged misconduct. BA, L8. The defendant argues, however, that it will call Gaetani, who has apparently now, for whatever reason, made a complete U-turn and taken a Carney-like position that Special Prosecutor Mello and Lieutenant Tully conspired with Kate Peter to use her and sacrifice her as a pawn. Gaetani would be expected to testify that during her relationship with Carney, Karen Reed would come up a lot in conversation. Further, that he told her he communicated with her on a daily basis, and that with much of his reporting on the Reed case, he would have to run everything by her, that she had a lot of control or almost complete control over anything that he posted. He was not allowed to make any sort of comment about her case without first consulting with her and getting her prior approval. Grand Jury Minutes, February 1, 2024, pp. 11-13. To take down Carney, and that therefore, Cosgrove should be disqualified on the ostensible grounds that he is somehow ethically conflicted from cross-examining her. Degree. Whatever purchase this argument may have for the now dismissed complaints where Gaetani was herself the alleged victim, there is no basis for dragging the entirety of that dispute into the present indictment, where Gaetani accounts for virtually zero of the Commonwealth's evidence, either in its collection or its presentation. The expected evidence will primarily be the testimony of the alleged victims and Kearney's own video online statements. A side trip into whether the Commonwealth did or did not properly conduct the Gaetani investigation is irrelevant, not probative, and highly prejudicial, threatening to turn the trial into a circus. The Commonwealth will vigorously oppose the attempt to divert the jury down this lengthy and winding side road to nowhere but confusion. Should this court, after hearing, permit the proposed Gaetani defense testimony to the extent that Ms. Gaetani's U-turn contradicts previous statements made under oath, she may expose herself to legal peril, and the court should ensure that before she proceeds, she has appointed counsel. Clearly her interests are far from synonymous with Mr. Kearney's. Finally, the Commonwealth notes that to the extent any disability arises from Ms. Gaetani's A&C, whenever, if at all, the counterclaim against Cosgrove goes before the Middlesex Court, it is unlikely to survive a motion to dismiss or for judgment on the pleadings. Its entire basis is an act by a prosecutor in the course of his duties, and whether or not Cosgrove was correct in concluding that providing a copy of the police report to the defense was proper. Greater than a prosecutor is not required to uniformly buttress or implicitly vouch for the entirety of the testimony of a witness he calls. The modern view, and the law in Massachusetts, is that subject to a few limitations, any party, including the party that called the witness, may attack her credibility. See Massachusetts Guide to Evidence, 2020 ed., Section 607, citing GL Circa 233, Section 23. Tooley 14 Discovery, no liability should attach. C. E.g., Werty v. Lynch, 27 Mass. App. Court 498, 499, 1989. The defendant's third and final request is perhaps his most brazen. He asks this court to disqualify Cosgrove from an ongoing investigation of Karen Reed and Mr. Carney for conspiracy to commit witness intimidation, the 2005 investigation, again based on the alleged irreconcilable conflict with Ms. Gaetani. To facilitate his demand that this court preemptively intrude on the lawful authority of the executive branch, Carney attempts to mount an attack on a search warrant authorizing seizure of cell phones belonging to Karen Reed. BA 164-77 and N.14. As this court undoubtedly knows, when there is a claim that seized electronic devices may contain attorney-client privileged material, a taint team is generally required. See generally. Preventive Medicine Associates, Inc. vs. Commonwealth, 465 Mass. 810, 2013. Moreover, 2. Search warrants are required, though the two may effectively be combined into one. So the process is search warrant number 1 authorizing seizure of the device, taint team established, search. Warrant number 2 limiting the scope of the search. Presently, the matter of the Karen Reed search warrants and the establishment of a taint team is before this court, Krupp, J., having heard argument, received memoranda, and taken the matter under advisement. It is part of the normal search warrant process. Assuming the court allows the Commonwealth's motion to set up a taint team procedure, and assuming search warrant number 2 is authorized by the court, and assuming a resultant search yields evidence, and assuming that evidence results in a grand jury presentation, and assuming that grand jury then indicts Karen Reed, then Karen Reed, as in any other case, may bring a motion to suppress that evidence. Karen Reed may bring such a motion. Not Kimi, who has no standing, as he lacks any possessory or other cognizable legal interest in Karen Reed's phone. Conclusion. For the reasons set forth herein, the Commonwealth asks that this court deny the defendant's motions. Respectfully submitted. S. Robert C. Cosgrove. Robert C. Cosgrove, Special Assistant District Attorney. 45 Shawmut Road, Canton, Massachusetts, 02021.
Just outrageous. Oh my goodness, outrageous. Listen, we have to get ready for this 2:15 hearing, so we have to watch the recap video about Bradel and Cosgrove going back and forth. But let me just tell you, this is hands down one of the most outrageous things I have read in my entire life, okay? Oh, wow. Just wow. First of all, reading backwards, okay? Cosgrove was like, we just need Judge Krupp to give us permission and we'll move forward with indicting Karen and Aiden. Or Karen. Oh my God, we just need the permission to move forward with the taint team procedure. Now we know what it is. As soon as Judge Krupp issues that ruling, oh my goodness, ladies and gentlemen. If you see a ruling from Judge Krupp on those phones and the taint team procedure, the floodgate, especially if they then can move forward, there's going to be a little lag with going through it. But that would be the sign. And listen, how much time does the Norfolk DA have left? You know, there's only 11 months till the election. Oh, my word, ladies and gentlemen. Cosgrove, in that last part right there, laid out exactly what he's going to do. And if you're just tuning in, we are just 45 minutes away or so from the Aiden Turtleboy Kearney hearing. No, Judge Krupp has not been moved. He is still in Norfolk Superior Court. And that ruling could come down any day. Oh my God, I thought it was them waiting to brute force her phone. No, they just need the ruling from Krupp. What are we talking about, Nanya? Yeah, that is a Norfolk County case. Krupp didn't get moved. Judge Krupp just rotates like every other judge, but he's in Norfolk County. All right, this is big. Let me breathe. Oh, dear God. I can't believe what I've just listened to. Did you like listening to it? Cosgrove in the voice of the whiny lady. Listen, this is absolutely wild. And let me just lay out why some of this is so wild. First of all, okay, so this, Cosgrove didn't even respond to this initially. He had to do a whole nother filing. Now, the other thing is, here's where it gets absolutely wild. This honestly seems like reading something written by Kate Peter, or at least like highly advised by Kate Peter. And I really think it's
What a fun time.
there's something about that, and we'll talk about that in a little bit. But before that, let's start with this sort of initial layout. This is just so like dripping with disdain, and it's adversarial towards Lindsay. This is a case about Aidan Kearney. Cosgrove is adversarial towards Lindsay. This is the very reason he should be recused, argues Aidan, because Cosgrove, in a filing about his own recusal, spends most of it attacking Lindsay Gattani. Folks. My word. And the reason why I think Kate had some role in this is the way that Cosgrove in particular lays out like how Lindsay was attacked. That's exactly the kind of thing Kate would do, like condemn the attack, but repeated verbatim. Like, I skipped over that part and I'm not going to read it, but like this single paragraph is the most inappropriate thing ever written by a prosecutor. And what makes it so insidious is if you weren't familiar with this filing, you would think, oh, that's just Cosgrove laying out what Kearney did to Lindsay. He's trying to call her turtle boy. No. It's so much more insidious. He's trying to call attention to the attacks on Lindsay while putting it in the veneer of, oh, I'm just critiquing Turtle Boy for saying it. No, that's a Kate Peter tactic, man. You look like you're condemning it when really you want to spread the underlying attack. Jersey Girl, thank you so much for the compliment. Welcome to the Blue Wall. Of justice, you have been afforded a towel wrench. Jersey Girl says, hi from New Jersey, Grant. Love your coverage. My pleasure. Now, let me just tell you, this is the single most abhorrent, ethically offensive, inappropriate paragraph ever filed by a prosecutor anywhere, in my opinion. Just look at it. Come on, I'm not going to read it. I'm not going to dignify this. But if you're a judge and you actually know the context, this is not Cosgrove condemning Kearney. It's Cosgrove attacking Lindsay by other means and doing it viciously. Viciously. Oh, my word. Now, I think there's a few point of facts that are just incorrect, as always, in a Cosgrove motion. So here, Cosgrove doesn't actually lay out what happened. Like Lindsay didn't make the initial report, and then she didn't want to report. He just says she initially didn't want to report. Did she go back? But now, listen, it gets really bad. Okay, it gets really, really bad when you get down to this part. I cannot believe this man. Robert Cosgrove said this. So this guy, Jason Broyles, is a man who pretends to be a woman online named Haley. All right. And I'll tell you that he's under his own sort of questioning right now by a lot of folks on all sides of this. I think he's connected to Kate Peter. All right, I think Jason Broyles is connected to Kate Peter and has always had dual motives. However, you see Cosgrove kind of like talking about how Gaetani Lindsay was vilified by Jason Broyles on the Haley account. I don't think that was to just the benefit of Aidan Kearney. I think that was for Broyles to get close to Kearney by making it look like Broyles was an acolyte. You know who I think really wanted Lindsay to be attacked by Broyles? Kate Peter. All right? And if you see, like, Cosgrove's talking about how Broyles pops up. Remind you, Broyles popped up right after the Jennings report, all right? In about March or February of 2024, right after Lindsay became a witness, a website popped up online called the Jennings Report, run by this fake profile called Mark Jennings. Well, it turns out that Mark Jennings, after he registered a website and forgot to veil his information in the public lookup, in the registrar lookup, he was a guy named Father Mark Murphy. Father Mark Murphy got defrocked from the Catholic Church, and then he worked for like Athena Garrison as like a political consultant, and then he kind of like went off the grid, moved in with a nice husband or something. I don't know, good for him. The point is, he shows up, and as soon as he gets exposed as the Jennings report, which was targeting Lindsay and me in the exact same way that Broyles went on to do so, which only really benefited Kate in the long run. That, as soon as Jennings' report gets exposed, Murphy goes away and Broyles comes up as Haley Walbrecht. Now, Broyles had appeared initially in the fall of 2023 under his real name by helping to pay for a free Karen Reed billboard. And then he disappeared for a while and came back under Haley Walbrecht and started going at Lindsay, me a little bit, but mostly Lindsay. And I'll tell you, folks, I think it was no coincidence. I think that all this time, nothing's ever happened to Broyles. It's because he was really helping Kate and Cosgrove and the Norfolk DA. Now you say, why? Why would he do that? Well, why would they do that? Well, because it lets them have a mole close to Turtle Boy. And two, Lindsay was an expendable, quote, distraction, in my view, for the powers that be in the orbit of prosecuting Kearney and Karen Reed. And so they looked down on her and they were like, oh, who cares if we release her unredacted phone extraction or manipulate it to remove messages from Tully to Lindsay and from Kate to Lindsay and audio of Leah Genduso that Leah sent to Lindsay via voice note. Who cares if we do that? You know, who cares if we have it released by Tully? Who cares if Cosgrove releases Lindsay's essay report? Who cares if we have Broyles make a big distraction? That'll take the heat off the other witnesses. You know, nothing will stop the heat, quote unquote. And furthermore, Lindsay didn't have the connections to protect herself, and they clearly never were going to go forward with these charges. They were just using Lindsay. She was an unwitting honeypot to serve their benefit of getting Kearney put in jail in 2023 or into 2024, keeping him away from the Reed trial. It was all part of this sort of very tied-in plot, but Lindsay was the unwitting honeypot. And now that from the very beginning, they need, I believe, the DA and Kate and that whole group needed to keep Lindsay in check, so they had in their back pocket Broyles being tormenting Lindsay to create a public distraction with Lindsay as the distraction by releasing her phone extraction, etc., keeping the Turtle Riders focused on her. And then simultaneously, Broyles was, and those groups would be mentally targeting Lindsay so she'd be destabilized and more susceptible to Kate's predatory behavior, because Lindsay would be so overwhelmed with the emotional stress of the situation she wouldn't be able to process what was going on. Well, I saw that happening and I was like, okay, someone has to just empower Lindsay to be able to see through this. Well, how'd that work out for you, Kate? You know what I'm saying? You don't target the vulnerable. And it is very hard to help explain how to not only see these tactics, but when you're experiencing them, be stuck enough to have your cognition control your emotional response so that you're able to not only see through the tactics, but put together the larger mosaic and thus prevent this kind of stuff from happening. But let's see what Cosgrove does here. What does he do? Ladies and gentlemen, Cosgrove admits that he released an unredacted SA report in the context of discovery, and then he pins it on Broyles for publicly posting it in a court document. I don't believe there's an exception. I'm not a lawyer. This is not legal advice. I don't believe there's an exception to GLC 4197D. I've never even looked at this. Let's take a look. Is there an exception to, I'm not even going to ask. I'm going to just read the statute. GLC 4197D. Is there some kind of exception? I have no idea. All right? So let's take a look at this. I have never, and I just want to show you this. There's not one. I'm telling you. We're going to look at this together. Let me make sure. Yep, this window. Look at this. We're going to look at this. I have Googled it. We're going to find this down. You can see they're all blue. I have never looked for this. I don't know what the answer to this question is. So we're going to click this one, okay? And what we're wondering is Cosgrove's argument is that he was performing his official duty. So let's see what this says, okay? Is it a defense for, and I don't know, I'm not a lawyer, I'm not a legal advice, but let's see what this statute says about the rules for what happens if you release that kind of report. Is there a defense? Does it say, is it a strict liability? I don't know. Let's take a look. All right, here we go. Section 97D. All reports of R and SA or attempts to commit such offenses, all reports of abuse perpetrated by family or household members as defined in Section 1 of Chapter 29A, and all communications between police officers and victims of such offenses or abuse shall not be public reports and may be maintained by the police departments in a manner that shall assure their confidentiality. Provided, however, that all such reports shall be accessible at all reasonable times upon written request to the victim's attorney, others specially authorized by the victim to obtain such information, prosecutors and victim witness advocates, as defined in Section 1 of Chapter 258, domestic violence victims counselors as defined in Section 20K of 233, SA counselors as defined in Section 20J of 233. If such action is necessary the performance of their duties, and provided further that all such reports shall be accessible at all reasonable times upon written, telephonic, facsimile, or electronic mail to LEOs, DAs, or ADAs, and all persons authorized to admit persons to bail pursuant to Section 57 of Chapter 276. Communications between police officers and victims of said offenses and abuse may also be shared with the foregoing named persons if such access is necessary in the performance of their duties. Okay. Tell me, I understand there that it says a little bit about having access to it in the furtherance of their duties. And, this might not be the only section, actually. Hold on, let's look up the other section as well, because I think he referenced one more, didn't he? Hold on, let me look up the other one. He might have only referenced one. Hold on, Massachusetts. I thought he referenced something else. Maybe he did it in two different places. No, it was that one. But the point is, it talks a little bit in there about accessing it. Yeah, the statute is classified. We were able to find it. It talks a little bit in there about accessing it, about accessing this kind of material in performance of your duties. Where does it say anything about releasing it? Not to mention releasing it unredacted. Raises more questions. Hi, 5MEO DMT. It is so good to see you, my friend. We have a big 2:15 p.m. Eastern hearing coming up in about 27 minutes, and I'm so glad to see you with us. Now, I will say, regardless of Cosgrove's argument here, okay, which I think is very attenuated and stressed, he still is like, Broyles posted it online. He's still, so then why haven't you charged him? I mean, I'm not a lawyer. This is not legal advice. I just have a question. Even if Cosgrove has this really weird argument, which I don't think, I'm not a lawyer, but I don't think it really aligns with what we just read, especially on a first read. Where does it say anything in there about, it says it about accessing it in the furtherance of your professional duties. Where does it say you could just release it unredacted? I don't think the legislature intended that. I'm going to go find who wrote that statute. They might be dead, but I'll find who understands that statute, and I'll ask them. I'll petition my government and say, tell me what this means. An electronics guy. At this point, I think it's less about electronics and more about who is working for who, Because even if they're throwing Broyles a little bit to the wolves here, I mean, they're basically accusing Broyles, I'm just interpreting it. They're basically accusing Broyles of being the endpoint of the public release. Obviously, this is a court filing, so it's Cosgrove submitting it, and there you go. But what we hadn't heard before is who released it. And I'm telling you, Cosgrove admitting to releasing it, unredacted. Oh, goodness. Good. Great. And let me just say, it gets a little bit weirder as well, okay? So, the thing I really don't like about, there was some stuff that I just found like factually tenuous and just a little weird. And then there was some stuff I was really uncomfortable with, okay? Now, the first thing I was really uncomfortable with is, one, I get that the state is saying, oh, we don't need to call Lindsay as a witness. But then they're also saying that Gattani is the only one who has information about certain communications between Reed and Kearney. And I know that to be true, because if you read Tully's affidavit from the search of Karen's phone, paragraph 72 to 84 in particular, pages 29 through 31, you will see exactly what I'm talking about. Which is that it wasn't just Natalie. Natalie was out of the picture completely by July of 2025, because initially it was about housekeeping, people thought, but it wasn't about that. Natalie and Karen had a falling out because Natalie introduced Turtle Boy to a Sony producer, and Turtle Boy just like ran with it, and that pissed Karen off because Karen was like, "You can't go with the first offer. What are you doing?" So in that context, you got. And Lindsay was the one who. Lindsay is in fact the only witness for Tully's affidavit that spans the period September or so, October 2023. Through December of 2023, when Karen and Aiden kind of have that falling out initially in December, because Karen told Aiden not to go to Lindsay's on December 23rd. So to me, okay, that's where I find it so weird that Cosgrove's like, we don't have to call her. Well, notwithstanding that it's the state's choice who they're going to call, the defense can call her, okay? And then Cosgrove says it in other words here, but he's like, we won't let, if the defense tries to call Gattani, we're going to object. They don't even want to, no, well, Bossy Texas Chick, it looks ostensibly like a good job, but if you know the factual record, as I think, I'll declare myself one of the foremost experts on this factual record, he's just leaving a lot out. And the way that he's presenting the argument, one, it's an unnecessarily Kate Peters style attack on Lindsay. That paragraph where he smeared her for 7 sentences, calling her all those names, making it look like he was calling out Kearney for saying that about her. No, that was disturbing. And you won't get kicked out, Bossy Texas Chick. Just, just understand the network here. And if you read this motion less as about the state even caring about Aiden Kearney and more about Cosgrove trying to get back at Lindsay, because it appears Lindsay revealing communications between Kate Peter and Ken Mello that were withheld from Kearney in discovery has exposed the Commonwealth through the Robert Cosgrove misleading the court, perhaps unintentionally. So, yes, never forget the third option. Especially when I've done a close reading and we're getting close to a bombshell 2:15 p.m. hearing. Oh no, we're doing all facts, all erudite, cogent commentary today. We won't be belaboring anything, but it will be in very quick and direct response if the factual record comes up. And furthermore, I got a second towel of coffee because I have to stay up till 7 for the social change warriors discussion I'm going to have. So there you go. You get extra awake towel. All right. Now, the other thing here is Cosgrove openly threatens her. He's like, oh, if Gattani contradicts anything she previously said. Excuse me? Is that what this is about, Cosgrove? No, there isn't anything about that that's at issue. It's the new evidence that Lindsay was privy to. which has to do not even so much with Aiden directly, but with Kate Peter communicating with the prosecution team, that was withheld from Kearney and Discovery until Lindsay revealed it, and then all of a sudden you found it, I guess, Cosgrove. So just that sentence alone is so gratuitous. I mean, it demonstrates, in some sense, it demonstrates exactly what people were talking about. Yes. Well, Bossy Texas Chick, all legalese is the art of bamboozling. But the art of being a judge, in my opinion, is feeling pleasure in seeing through the bamboozling. So we always take a look at how the judge responds to the different arguments, and then we inductively reconstruct what the judge might have been feeling about who's spewing the most nonsense. Now, here, I think, frankly, Kearney wins on the merits, all right? I'm sorry. The reality is a lot of stuff was withheld from Discovery. There was a lot of tomfoolery. The stuff that was withheld from Discovery came out in public or through Lindsay or whatever, and then the Commonwealth tries to make up for it. It involves Kate Peter. That's why there's so much noise. This motion, though, just egregious. Just like from Cosgrove, I think it is a terrible motion. Not only is it terrible on the merits, it is in form the embodiment. He's literally cutting against his own argument. This is an argument by Cosgrove to not have to recuse himself from the existing 2023 indictments and the 2025 indictments involving the window shop with the pizza. This situation, all right, is this is supposed to be Cosgrove responding to a motion to why he shouldn't be recused. Instead, he does the very thing that would warrant someone being recused, which is he uses his position to, one, argue a collateral civil case, argue the merits of a collateral civil case, two, make an admission in that collateral civil case about being responsible, hitherto unknown, by the way, information, that Cosgrove was responsible for the leak. It was only known that it was the Norfolk DA's office, quote unquote. But to openly, listen, it looks like in this paragraph, I'm not going to leave it up on screen, okay? It looks like up on this screen, Cosgrove is just trying to highlight some of the attacks on Lindsay, okay? But if you actually read it, all right, it is just Cosgrove doing what Kate Peter does, which is taking a lot of negative things, every smear you can imagine, every lie, every horrifying thing, and just quoting them and saying them about Lindsay while pretending to critique Kearney's followers. Come on, outrageous. It's on whatever page it is. It's that alone. I mean, listen, we have to rethink, in my opinion, the entire way this case is being litigated, because that is punching below the belt. That is a former judge, that is a very skilled lawyer, a litigator with extensive experience, taking pot shots akin to an internet post against Lindsay, as if Kate Peter herself were penning this motion by talking to Pam Friedman and having Pam tell Cosgrove what to write. I mean, it is hands down one of the most gratuitous. It really pushes the line as to acceptability. One, he's going to lose on the merits. Two, the form of it is an embodiment of the conflict that Kearney's lawyers are trying to show the court. Cosgrove took the bait. I've never seen... I'm so frustrated with this fucking case, because it's like, at least Betterow writes like a snarky lawyer, but like a fun snarky lawyer, like it's intelligent. Cosgrove writes like he's pissed he can't go on Twitter and chirp at people, so he's like, I'll just chirp at them all in the motion. It's not fucking social media. This is so petty. Betterow's motions, I don't always love them. He goes a little overboard. But they have that flair. It's not gratuitous flair. It's flair with a purpose. This is not flair with a purpose. This is petty. And it's petty towards, it's unnatural and it's odd and it's towards a named witness and someone who's cooperating with the state. It's It's a harbinger of very bad things. It's a red flag. First of all, there's no need for it, okay? The motion didn't call for that level of pettiness. Second of all, it's inappropriate because he is a counter plaintiff or potential plaintiff, counter plaintiff or defendant or whatever the hell in that other case. Third of all, he's literally admitting to things in this filing that materially affect the other case. Fourth of all, he's wrong. Like, the way he's presenting facts is designed to make the court think Lindsay has less credibility than she does, and he's wrong about some of the almost everything he says about in that regard, which is making him adversarial towards her, which is the whole point of Kearney's motion for Cosgrove to be withdrawn. Nanya, absolutely. 2:15 p.m. is it? Oh no, what word did I say? What happened? Did I 5-MEO-DNT? I don't know which word I said, but you just let me know. I may have said the F word there. I apologize about that. All right, now 15-minute countdown, ladies and gentlemen, until the hearing. You know what that means? Time to fire up the old Zoom machine. Oh boy, we're really at this moment, huh?
This was from the other day, by the way, and I was watching the Aidan Kearney hearing. Might play another video for you. We're on Verdict Watch. I'm doing towel things, just hanging around, being a towel. We are 2 hours and 15 minutes to Verdict Watch, ladies and gentlemen. If I have news about that or any developments in the Walshe case, I will let you know. Otherwise, we're going to watch some towel videos. Why? Because I'm a tired towel. And as Bossy Texas Chick said, when towel's tired, it's best we just watch videos and get caught up on things. All right, what else can we get caught up on? There was the hearing, my Crim Pro review. Let's see. Oh, wait a minute. Nope, nothing yet. I thought maybe we had an update. Nothing yet. What else do I have for us to potentially watch? I have lots of interesting things. Let's watch Towel's analogy of the cave. I really like that one. It's a really interesting video. And yeah, I hope you're all doing well. We're on Verdict Watch, so once you're on Verdict Watch, you mostly just kind of sit around and do Verdict Watch. And that's what we're doing, ladies and gentlemen. So thank you for your patience. Thank you for hanging out with Little Towel. And let me get a video for you to watch. And the Twitter video player's been a little bit annoying today. I think that's an understatement. But anyway, let's watch Towel's analogy of the cave, because I find this video very interesting. Alright, let me get it all ready for you. Alright, there we go. Alright, so let's watch Towel's analogy of the cave.
And that's where we're at. Tully's screwed, Fanning's screwed, Yuri's screwed. Proctor's a little bit screwed, but he was really more the scapegoat. I don't think he actually covered up Mr. Birchmore's murder. I think they just made him the fall guy. Kate Peters screwed. Karen might actually end up getting out of this, because I think they want Rachel Rollins and Turtle Boy, in my opinion. A lot of people have some very bad qualities. There is no heroes. There are no villains. Morality is not black and white. And that's what inhibited.
I'm going to qualify that statement and saying, and maybe we can even take Turtle Boy out of that exclusion list. The person I don't think has redeeming qualities is Kate Peta.
People for so long for understanding this, because they couldn't. We live in this polemical world where your heroes must do no wrong and the people you hate must be wrong all the time. That's not right. You cannot analytically analyze a situation if you just assume people you like are always right and people you don't like are always wrong. That's like being in a cult. The only way that you can figure any of this stuff out is to look at it from the perspective of human morality is complex. On the whole, most people are Kantians. They're not operating from the categorical imperative trying to universalize moral maxims. Who does that? Very rarely is that going to happen. Most people are selfish. Most people, and I'm not being jaded here, most people are selfish. Most people are acting from personal interest, which we can't really fault them for. But some people in particular in positions of power, are acting from places of mixed motives. Maybe they're trying to do some good. Maybe they're trying to cover up some bad. Maybe they're willing to play a little dirty. Maybe they're willing to wheel and deal on all sides. And if you think that's not happening, I don't know what to tell you. You're in la la land. All right? Not being mean, but like you're in a fairy tale. You're living in a state of comfortable numbness, and it's going to be uncomfortable. Like, imagine if you were living your life. Like, I'll show you a good image. Give me 1 second. Let me pull it up on the screen. I've shown this image before, but imagine if you were living in a cave. Okay, just imagine you were living in a cave, and part of living in that cave was that you were very comfortable. You know, like it's easy if you're living in a sort of underground cave and you don't have to actually go out and scavenge for food. We're using this by analogy. It comes from Plato. You don't have to scavenge for food. You don't have to kind of look for stimulation in your brain. People just cast images on the wall, like some unknown force, and like you're comfortable, like your needs are taken care of. You're satiated, but you're not thinking. You're just going day to day. And so I don't say to people lightly that this is something you should do. I'm not just gratuitously encouraging you to come to a position where you're always critically analyzing everything. But if you're going to engage in analysis of high-level politics, one of the most important parts of the arena, the public sphere, is looking at morality as a complex interplay of motives, overlapping concentric social circles of influence define and permeate through every element of this sphere. It's not high school. It's not regular day-to-day existence. It's complex politics. Nothing is ever as it seems, and there are no good guys and good girls and bad guys and bad girls. There's people with motives trying to accomplish things. Oftentimes they're very evil, but we cannot fall into that trap. And that's why I think the fallout from this is going to induce a lot of cognitive dissonance for people. Rightfully so. You should have cognitive dissonance. If you thought Brian Tully and Kate Peter in that unit were heroes because they investigated Karen Reed, but can't understand how they could have done bad things in the Birchmore case or with Lindsay Gattani's phone, like, yeah, you should experience cognitive dissonance, okay? Because that's kind of what happens when you fall into these traps. Now, take a look, ladies and gentlemen. That is how I visualize what's going on. So it's just people just trying to get by, live their daily lives. They want to be comfortable. They do not want to be analytic philosophers studying Kantian moral maxims and applying them in their daily life. That's not something we should expect of people. They deserve to live, raise their families, and be happy and love people. Okay, that's life. All right, we're not trying to make this too complex. No one's saying you have to be an analytic philosopher or run the government. You can just be happy in your life. But what we have, where the problem comes in the middle of this image, is the Sue O'Connells, the Turtle Boys, and the Kate Peters of the world. Now, what they do, by analogy, in my opinion, is they cast shadows on the wall. Now, those shadows, as you can see, are like being consumed by the people in the cave just trying to get by, but it doesn't really explicate the full context. You can't understand what's going on if you're just seeing a shadow cast on a wall. You don't even know somebody's in a robe is holding it up. You don't know it's a stick figure. You just think it's a shadow. So, of course, you're like, that's a wonderful duck. What do I care about the damn duck? And the duck is a fitting analogy here because a lot of people invoke rubber duckies who are on the Karen Reed side. Now, look at that. That's just a duck. I like ducks. Oh, I'll just sit here and watch the duck. I love the person showing me the duck. Oh, Kate Peters, wonderful. She likes ducks. Okay, that's a little dangerous, and we're using duck by analysis here. Let's say Kate Peter loves Brian Tully. Brian Tully's a duck. All right, we love Brian Tully. Then you got Sue O'Connell casting an image of Karen's parents. Oh, Sue O'Connell likes Karen's parents. Look, they're beautiful. We love them. Then you got Turtle Boy casting an image of his beloved Karen Reed. Unrequited love is such a horrible thing. Don't worry, Turtle Boy, you'll get through it. Anyway, so Turtle Boy.
Any second now. I paused this on purpose. I wanted to say I shouldn't have said that either. I take that back.
By casting his image of Karen Reed to hide his unrequited love. And people are like, Turtle Boy's just defending an innocent, quote unquote, woman. He doesn't have any ulterior motives. Look at Karen Reed. We love Karen Reed. But then you have some people who climb out of the cave. They see the Sue O'Connells and the Turtle Boys and the Kate Peters for what they are. They ignore them. They start climbing up. And then you get to the top and you're like, wait a minute here. There's just a world out there and I consume it and understand it and I don't have to be subject to the projections of someone interpreting it for me. And then you're Sean McDonough. You see what I mean? And then you see the light and you're like, wow, it's a little weird up here. So, oh, all right. Now, I'm not saying that Sean McDonough was incapable of this from the beginning. I think he did it pretty quickly. But you still got to go through the process. You'd be hubristic to think that you can just get up to the top of the chain and just see the sun if you don't climb up the little cave there. So, therefore, Plato, ladies and gentlemen, predicted over 2,000 years ago how Karen Reed, Sue O'Connell, Aidan Kearney, and Kate Peter would try to manipulate the public. All right, everybody on the same page? All right. How can people, I didn't say I love Karen Reed. I said that there are people who are very blinded and just see an image of Karen Reed without understanding the context, and they're like, oh, that's a Karen Reed, and they love her. That doesn't mean they understand her or that their love is a reflection of her, an accurate depiction of who she is. They just love the image of propaganda. And Plato didn't put it in the terms. If you read, this comes from book 8, I'm pretty sure, this analogy of the cave. If you read book 8 of the Republic, you're going to see the analogy of the cave. Plato predicted the rise of the discipline of public relations 2,000 years ago. He didn't call it public relations, but that little casting of the shadows onto the wall of the cave, bro, that's public relations. He knew what it was before it was even a thing. This man knew what that shit was before we had fucking TV, before we had, I'm pretty sure we had just invented writing. We didn't have electronics. This man was a G, all right? He was a genius. So that's why now this is my artistic rendering of the analogy of the cave, adapted for the Karen Reed and Turtle Boy situation. But that's why this is so complicated. No one can understand, other than maybe Sean and a few other people who I really respect. It wasn't that anyone was all good or all bad. It's that some people did good things, some people did bad things, and that they're all mixed in there together. And you can't parse out truth from narrative unless you're willing to admit that people you either like personally or have whatever dedication to their cause might have done something wrong. Otherwise, you're a sycophant, and that you undermine cogent public discourse, and you threaten the integrity of the justice system, and you need 2 adults in the room like Hank Brennan and Leah Foley to clean it up. God bless America, ladies and gentlemen. My name is Grant Smith Ellis. Let's see what's coming in to say.
Hello, I'm a little tired, so let's just leave you on verdict watch. I'm getting tired, but I'll get a second wind. In any event, let's leave you on verdict watch, so if the verdict does come in, ladies and gentlemen, you will be the first to see it. Absolutely, indeed. So let me get this set up for you. Gonna change quality a little bit, and give me 1 second. Alright, and there you go, we are live. I'm going to turn the volume on, I'm going to mute myself, and you will be able to see verdict watch. If we get a verdict, you will hear me come over the screen and announce it. Otherwise, we're on verdict watch, the clock's up on the top of the screen, and I'm a little towel.
Mr. Grant responsible for. I think I gave Mr. Grant a shorter sentence, substantially shorter. I knew he was out in May when we had this argument because I saw him in Nantucket at the courthouse. I seen him, so he did his time. He paid his debt to society. And encouraged the district attorney to think about where we are in this case, whether it makes sense resolving the case. Short of another 2-week long trial. I can't force that. I can ask you to give some serious thought to what makes sense. Now, the motion to the second part is denied. Okay. And I didn't ignore it. I just don't not persuaded by it. Okay. I just been thinking I more than my 30,000 feet assessment. So now this should be all we want to talk about. Yeah? Yes.
Yes, you're opposed to that. I think what's relevant here is an assessment of flight risk. The defendant was declared that he's convicted of a serious threat offense. The jury did hear the evidence. Gordon does not exonerate. Gordon does not test out on the defendant's guilt. The jury heard the Commonwealth's case as far as the weight, the drugs.
It does cast doubt on guilt. That is in essence what Gordon did. Gordon tells me Miss Hayward did not get a fair trial because her confrontation clause was war offended. And that kind of offense, for lack of a better word, is of constitutional proportions. She is an innocent woman as of this moment. I'm asking you to make a bail argument, and I guess you can make an argument that likelihood of success, the strength of the government's case is stronger. That is, they're going to retest that a jury heard this at one point and thought that it was sufficient evidence to prove beyond a reasonable doubt, and once you get your substance thing squared away, she can make an argument with regard to that. She's innocent. Where she sits here today.
As she sits here today, with the convictions I could reflect on, and you actually anticipated the chunk of my argument here, that when I say Gordon doesn't exonerate her, it allows her a new trial. It does say her rights of confrontation were violated. However, at the time of the trial, the jury did hear the evidence. It's a serious case. There's a lot of drugs. They're priced steps for an amount. She got a heavy sentence, 13 to 14 years. She's only served 3 of those sentences, 3 of those years. I propose to put to death. That elevates the flight risk here because we have verified that the drugs are still available. The chemist is now back. The chemist will be available to testify. So if this case is a result,
So maybe we got a quick trial then.
what I'm saying is, if we go to trial or it would be resolved by plea, but the bottom line here, on either avenue that it goes to, there's a significant likelihood of conviction, and there's also a significant likelihood that she will face a prison sentence, maybe not as high as what she got initially, but it will be substantially more than the 3 years that she's already served. So she's looking at a continuation of a prison sentence here once the cases are retried and resolved by court. Under those circumstances, the flight risk here is elevated.
At the time that bail was set on the case, I looked back at the docket. At the time that bail was set on the original case, the defendant had returned the passport. Is that right?
I'm sorry, I don't know.
Well, I know that it was. I looked at the docket. So what I just don't know is what happens because I think
something that I have to be concerned with, but I don't know what happened after she was convicted. But Monica from Nantucket is here, and she believes that we still have the passport. Is that right? Yes, Your Honor. I have my office manager email it to me. So the bill was set at $25,000 initially. It was reduced to $10,000 after she turned in her passport. In recognition of the fact that I think the strength of the government's case has been established to some degree, I'm going to put the bail back at $25,000. And I think that'll provide enough of an incentive for Ms. Hayward to stay where she is. She didn't have any issues with her at all when she was pre-trial on the other case. She appeared for all of our hearings, and I expect she's going to do the same.
One other point was where the defendant would be residing now. She was been in prison for the last 3 years. I don't know that she'll have the residence on Nantucket or where it would be or where she would be.
She needs to stay in the Commonwealth of Massachusetts. And any ideas about where she's going to be when she posts? She'll be with her daughter in Springfield. Okay. And Your Honor, can I just say for the record that I want to reiterate that Ms. Hayward attended all her hearing dates. And if you look at her record, this is basically the only conviction on her record. I understand that. Look at it this morning. Yes. So just want to make sure that was clear for the record. I appreciate you saying that. Right. Anything, were there any other terms and conditions? I don't think there was. It was just post the bond and make sure you show up. Those are the key things. Make sure you show up for your minutes. So being contacted, I've been in touch with the Judge Buckley, who's the Rajin Barnstable responsible for Nantucket. She's going to be sitting and hearing criminal cases on January 23rd, 2026. I'm going to put you on the docket for that day. I'll be there to see her so that we can get this back on the schedule. I don't know if the parties are going to seek. I'm encouraging you to try to resolve this, but if you don't, I can anticipate by the motion for new trial that the defendant may want to bring additional motions to suppress. So we need to get you in the cycle for what is going to come to the case. And what is now going to be no fault of the parties, a very old case because it's a 2020 cargo. So I think Judge Buckley is going to be interested in seeing that you move the case in terms of the next trial date, if that's where you're headed. So can I just say that so I'm more of a, I know you are. So in the meantime, could I file my motion to withdraw and for appointment of counsel? And would that take place on January? So, I don't know how far Judge Buckley is going to want to go. I told her I'd follow up with her since this is going back to Barnstable County. I told her I'd send her an email today when we got done letting her know what happened, and that I was going to put you on for 12326, sort of as a status to the status for appointment of counsel. If we can get our counsel before then, we will. And I anticipated that you were going to pull off because you were our counsel and that she would be assigned to me, presuming that her financial situation is the same, and I don't think it's gotten better while she was incarcerated. So I assumed that she's going to qualify for appointment of counsel, and she will get appointment of counsel, and hopefully we can get that person to Nantucket. I can't make any confirmation of where I know Judge Buckley is going to physically be in Nantucket on that day. I can't speak for her with regard to whether she's going to want me there or not, and make sure you're in touch with the clerk. If so, we start off on the right foot. Absolutely. Thank you.
So the 23rd is in Nantucket?
Yes. Yeah, it's in
ticket. 12326. And presume it's an in-person hearing unless you hear otherwise. So we'll expect to see you there. She will expect to see you there. Anything else that we need to do today? Appreciate you coming to Norfolk to trial. Thank you. Those reinstated. Well, bails, it was reduced, so bails reinstated at $25,000. And I know, I think that passport, we still have it. She can't apply for any new passports of any sort. Yeah.
Seated, court's in session.
Everybody saw the question?
Yes, Your Honor.
My suggestion is that there are 265 exhibits, and I ordinarily have sent in an exhibit list that the parties have reviewed, and I would think that would be an appropriate way to assist them in their evaluation of the evidence, but it needs to be cleaned up. In particular, on a quick review of it, photo 52 should say something other than butcher paper.
Yes. And 189?
Also the same term?
No.
What were you calling it? What kind of paper? Bench?
Bench paper.
That term is used throughout. So what is it that is, that term is used in other numbers? So is it something about that particular photo that is problematic with that description?
Oh, I
just
don't like it, but,
I know you don't like it, but I'm trying to distinguish between, I think there was one, witness who used that term butcher paper as opposed to bench paper. And I don't think it was the witness that was associated with that. This is just the old-fashioned terminology that people often use to describe that paper. I think I used it at the side of the bench one time, not in front of the jury, but just with you. But that is there's a more neutral characterization that would be appropriate and more in line with what the witnesses actually testified to. But as to the other language in 189, it seems to me that that's what the witness testified to, right?
that's right.
Yes, Your Honor.
Anybody, let's all take a moment to look through the list right now and see if there's anything. I'm going to do that right now. The answer to their question is 97, by the way.
Yes.
Let me just take the time to look through these, and you do the same.
Other than that, that's the only one.
Who's 189?
Blood clots and
aside from that one suggestion, the change.
Okay?
Tracy wanted to. Oh, doing this one? 182.
All right, so I'm going to write back to the jurors, and I will give them the name of, or the number of the photo, which is, I'll answer it as exhibit number 97, and here's an exhibit list to assist you.
Thank you, Your Honor.
Here you go, Madam Clerk. If you want to look at it, you're welcome to. It's pretty straightforward. Thank you.
Court's in recess.
It was the Wild West.
What's in session, may be seated.
Your Honor, we're back on the record in Commonwealth versus Walsh.
Thank you. As is my custom, at 4 o'clock, I send a note on every day the jury's deliberating, asking if they want to stay until 4:30. That note will be marked as the next exhibit for identification. And it gives them the option of staying until 4:30 or suspending and coming back on Monday in this instance, and they've elected to do the latter. So we'll bring them in and send them on their way.
R for ID, so marked. Thank you.
All rise to the court. Jurors entering.
I'm gonna go see Mom, but otherwise I would. Maybe on Monday if we're.
Court is back in session. You may be seated.
Welcome back, jurors, to the courtroom. Again, thank you for your work today. And I'm going to send you on your way for the weekend. I remind you, jurors, that the rules still apply. They will apply until you reach your unanimous verdict. I remind you of those rules now, jurors. Don't speak to anyone about this case. Don't do any research about this case. continue to have open minds as you evaluate the case and as you wait to see if you are going to evaluate the case. Don't access any social media or any news media over the weekend. Hope you have a good weekend, get some rest, and we'll see you back here ready to work on Monday morning. Thank you, jurors. Thank you.
All right, so the court, please. Jurors, follow me.
Thank you.
Just as short as council, make sure you're back here a few minutes before 9 o'clock in the morning on Monday. Have a nice weekend.
Thank you.